Good morning. We're here for a hearing in the matter CFI 009-2016 before His Excellency Justice Omar Muhairi. The claimant is represented by Hamdan Al-Shamsi, lawyers and legal consultants. Lead counsel is Roger Bowden. The defendant is represented by Taylor Hussain. The lead counsel is Tom Smith.
Yes, Mr. Tom, supposed to start with you first today.
Yes, I'm very happy to start. I had anticipated that Your Honour might want to hear from Mr. Bowden about the application to restore the company to the register.
Yeah.
If you recall, that was to be stood over, and I thought Mr. Bowden had said stood over to today, this morning. Would Your Honour like to hear from him on that? Or
I prefer to start with you, and I'll keep it at the end.
Grateful. Well, let's do it that way.
So, your plan that you're going to address your application at the beginning and reply to his applications?
Yes. Well, what I was going to do was deal with the question of disclosure, not the application for disclosure, but what has gone wrong with the disclosure process first. Because my learned friend says something's gone terribly wrong with disclosure, and we need to hear from Melanie Fernandez. And there is this outstanding application for a witness summons to have her attend court, apparently today, albeit that morphed yesterday into let's adjourn the hearing and have another hearing and have Ms. Fernandez come to court. So I was going to deal with that at the outset. Then I was going to deal with the application for amendment by my learned friend and his application for immediate judgment and my application for immediate judgment, all of that together. Because as I've said, I think yesterday, really the issues in those applications are broadly the same. And the question for the court is whether there's a real prospect of success on the three ways that the claim is put. So assignment, registration, estoppel, and the two defences that I advance, which are the uncertainty point arising out of the amendment to the lease, and then secondly this question of illegality, or the effect of the illegality on the contract, so the strata management's plan and the scheme, which says you can't use this unit as a bar and restaurant. So those are the five issues which I was going to deal with all together after I've dealt with at the outset, and then I was going to come on to the actual application for further disclosure in this case, and I'll deal with that at the end.
And you think up to lunchtime you're going to finalize that, and after that give them time to
I'll do my best. My learned friend took a full day to deal with it. I anticipate I may need a little bit of time in the afternoon. I will move as fast as I can, and no doubt Your Honour will tell me if there are areas where I don't need to address you. But at the moment my current estimate is I'll need a little time into the afternoon.
Yeah, we'll try to finish it today, because tomorrow I have other case to deal with.
I'm sure.
So I'm not available to continue the hearing.
I don't think there's any real risk that we'll go over at the end of today with Your Honour's, with a bit of luck. Thank you. All right, let me start with these complaints about the recent document production. Now, the starting point, as Your Honour knows, is that the Court of Appeal took what was actually quite an unusual step of ordering my client, the defendant, to make early standard disclosure of documents. Let me show you that order very briefly, because something was said about it yesterday. And it's in Bundle 1, tab 5. You see the judgment with... Tab 5 of this bundle, you'll see the Court of Appeal's judgment with amended order. And over the page, on page 155 of the bundle, you'll see the order itself. And the operative bit is paragraph 3. The respondent, that's the defendant, client, shall provide standard disclosure of documents to the appellant within 35 days. And that superseded, the Court of Appeal said, any prior orders. So that's the operative disclosure order that my client's working under. So that is an unusual order in this court for two reasons. Firstly, it was made at an early stage. So my client still hasn't seen the claimant's documents, for example. There's been no exchange because we haven't got to that stage yet. My learned friend's applying to amend his case. We're still right at the very beginning of the proceedings. My learned friend already has most of the documents that he would be entitled to through the course of the claim. The second point is that it's a wider order than would usually be the case in this court. Because as Your Honour knows, normally one produces the documents you rely on and then you have to ask for discrete and narrow.
You refer to the November order? This is the one?
The November order that came before.
Yes.
But that was superseded by this order.
Okay.
Yeah. So the November order was also wider and earlier, and was in some senses also an unusual order for this court to make in these sorts of proceedings. But nevertheless, this superseded it. And this is a far wider and earlier and more unusual order than one would see in the everyday case in this court. For those reasons, it's much broader and comes early proceedings. The court did not, as my learned friend asserted yesterday, make any specific order for the production of a master sales agreement in relation to the retail units in Limestone House. So my learned friend says repeatedly, in all submissions and in his skeleton arguments, the defendant was ordered to produce the master sales agreement. It wasn't. Now, if that document existed, it would clearly fall within the scope of the order that's been made. But there was no specific argument or order that that document ought to be produced by my client. The obligation to make standard disclosure is an obligation to make a reasonable search of documents. And in a case like this, where most of those documents are digital, that will take 2 stages. The first stage, you need to gather in the data. So you identify who controls that data, emails mostly, and you need IT team to put that data together. And then the second stage is a search. And you will have seen Mr. Barrack's witness statement. And I'll take you to it in a second. But my client accepts that something went wrong. But what went wrong at the first stage. And so, on behalf of my client, Emirates, I apologise for that, my client apologises for that, and Mr. Barrack has apologised for that. And if the claim proceeds, we will put that right. But it doesn't affect the primary applications that Your Honour has to decide today. What we are dealing with are applications for immediate judgment and for amendment. And I'll come on to why it doesn't make any difference to those applications in a moment. But ordinarily, those are not applications that would be determined by the resolution of disputes of fact. We're dealing really with is there any evidence for the claimant's position? But primarily we're dealing with what is the position in law, what are the consequences in law of the facts as pleaded by my learned friend. So let me just explain in a little bit more detail what went wrong and show you what Mr. Barrack says about it on Thursday. If we go to bundle 4 and turn to tab 27A. Tab 27A it is.
Okay, start there.
And it's 1123.1 is where the document starts. If you haven't had time to read it yet, can I just ask Your Honour to read paragraphs 5 to 9 and 13 in particular? By all means read the rest if you would like to, but those are the operative and key parts.
Yes, 1123 point?
1123.2. Bottom. So 1123 is a letter, and that's the end of an exhibit, and then you've got the witness statement itself, 1123.1. And you'll see that paragraphs 5 to 9, paragraph 13 in particular, are relevant. By all means, if Your Honour needs to, or wishes to, I would like you to read as much of it as you feel necessary.
Yeah. And the other paragraphs?
13, please.
Yeah, your point here.
So a lot is made of this, and so I'm showing you on what actually happened. What happened was the defendant's emails were in archive, and they had to be retrieved before they could be searched. various custodians of documents were identified. So the emails attached to their email accounts were collected, and then the searches were conducted against those documents. And so the error arose at the point of collecting the emails of Ms. Fernandez. And so for some reason, not all of her emails from 2012 and 2013 were collected. And as we've heard, you will have seen as well, Ms. Fernandez was one of the essential figures involved in the sale and purchase of the units. She is not, however, directing this disclosure exercise. She is in fact a former employee of the defendant. So, as I said, she was involved in the purchase of the units, but she's not employed by the defendant anymore. She is employed by an entity which is also within the Emirates MBD group, and she has been, to a limited extent, assisting, but she is not an employee of the defendant, and she's not controlling the disclosure exercise. She was also, as you want to know, is the person who in May 2012 signed the lease registration form. And the other thing that is potentially relevant, because the application is an application to summons her to court, is that her involvement in the preparation of this case has been limited, and there is a reason for that, and that it is that she is extremely unwell, and she is currently being treated for cancer. That's one of the reasons why her involvement has been limited. Now, my learned friends made quite a lot of assertion yesterday. Ms. Fernandez was the one controlling the disclosure exercise. There's no evidence for that. And if Your Honour wants to know the true position, that's the true position. She's not directing this disclosure exercise. And my client's never suggested that she is. She's tangentially involved in the preparation of this case, to the extent that we can have her involved. But that is a limited extent at this stage. Sorry. I've been asked to deal with an issue. My learned friend can make his submissions, and I'm here to make my submissions, and I shall make them. So I accept something went wrong. My learned friend makes a great deal of this, but as I say, this is an error that occurred at the IT level. So no one in the legal team, and certainly not Ms. Fernandez, were involved in the collection of the emails. That's where the error came in. Now, this has only recently come to light. The defendant has identified this problem itself, and it has disclosed in short order what happened. And it's taken some time to work out what went wrong, and quite obviously, Your Honour, given what has happened, my client wanted to be sure that any information that it provides to the court about what went wrong is accurate. Now, in a sense, it's unfortunate that this happened close to the hearing, but that's really more about perception than anything else, because in reality, it doesn't make much difference to the issues that Your Honour has to decide. I say it makes no difference at all. Certainly, I say, there can be no reasonable suspicion that this was done deliberately. My learned friend, I'm not sure whether he went that far, but he certainly suggested it, at least implicitly. If this was deliberate, it wouldn't have been revealed by my client. Your Honour will have seen how quick my learned friend is to fire off allegations of that sort. But this is a major commercial enterprise, and its reputation is more valuable to it than a single case. This is a mistake at the IT end. The defendant's responsible for it, and for that it apologises. But the response to that has to be proportionate. Now, searches have been completed of the material that was missing from Ms. Fernandez's emails. Those searches have produced only 29 potentially relevant documents. And frankly, it is a stretch to say that they change anything about this case at all. And my learned friend's letter of yesterday, in which he asked that Ms. Fernandez be ordered to attend court, identified two particular documents that were said to be relevant. or two issues to which they were said to be relevant. If Your Honour has that letter, if not, it's not material. I can recite what happened in paragraph 9 of that letter. What the documents are now said to establish is firstly that my client did consent to registration of the lease, and secondly, it's said to establish that my client did have a copy of the lease. If we look at the first one, I'm not sure what the claimant gets from these documents on consent to register. So we're dealing with the first issue, consent to register the lease. I'm not sure what possibly my learned friend could get from these documents that it doesn't get from Ms. Fernandez simply signing the lease registration form. I'm sorry, my learned friend's trying to give me notes on my own submissions. I'm sure.
Mr. Roger, would you mind let him continue his submission, and when your turn coming, just say whatever you want to say.
My learned friend, he intervened a lot yesterday, and in order to avoid intervening, I was just pointing out as we went along a couple of little problems. I could come back to it, it's fine.
No doubt if I say anything...
You can use it in your submissions.
Thank you. No doubt if I say anything that's inaccurate, my learned friend will intervene. It's one thing to mislead the court with submissions, but the other point, as to how I put my case, that's up to me. So the first point that my learned friend made in his letter is that these documents assist on the question of whether or not my client consented to registration of the lease. And as I say, it's hard to see how much further these documents could possibly get my learned friend than the fact that Ms. Fernandez actually signed the lease registration form. The second issue my learned friend says this goes to is whether or not my client had a copy of the lease at particular times. That point, during the course of my learned friend's submissions, rather evaporated, because what he was originally saying was that details in one of the internal emails that have been disclosed could only have come from the lease, and therefore the lease must have been in my client's possession. The problem with that was that the details don't actually match the lease. They match the offer to lease that came before. So I'll give Your Honour the reference, but we don't need to go back just to deal with those deal with those documents in detail. But the document itself is at Bundle 4, Tab 27A, 1123.87. And the material details for the lease commencement date and the term of the lease, and they don't match the actual terms of the lease itself, which is at Bundle 3, Tab 20, page 632.31.
Page?
632.31. I'll take Your Honour to the lease in due course. One of the extraordinary things about my learned friend's submissions is that you haven't actually been taken to the key documents in this case. You haven't been taken to the lease. You haven't been taken to the actual agreement by which the units were sold. You haven't been taken to the amended particulars of claim that my learned friend sets out the case that he seeks to advance. And we'll go through those. But the lease itself doesn't match the document my learned friend was referring to. So then he changed his position, and what he says, well, those details must have come from the offer to lease. That's a document from the 15th of March 2011. I don't, standing here, know where those details came from, but the point goes nowhere. Because if my client was copying documents or copying details in an email from an offer to lease, and those details were actually different from the lease, that would rather suggest that my client didn't have the lease. But the point is, I'm not even sure still whether this is even asserted. My client simply says it didn't have a copy of the lease, at the least before the sale of the units in January 2012. That's as far as I go, but I don't even need to go that far, because none of this affects the issues that Your Honour has to decide on these applications. And I'll come on and explain that in outline, and I'll deal with that, the effect of any missing documents, when I cover the particular elements of the claimant's case and its defences, and the defendant's defences. But just to provide a summary of this, the claimant's case is in three parts. Firstly, there was an agreement between Emirates and Union Properties for the assignment of the lease. That's the first part of this case. So that's an agreement between Emirates and Union Properties, not between my client and his client. Secondly, the lease was registered and became binding on Emirates. Thirdly, there's some estoppel. And then we've got the two defences. Firstly, variation of the lease in May 2012 rendered it void for uncertainty. And secondly, the terms of the SMS made the lease void for illegality or caused it to be frustrated or placed the claimant in breach, or however that works. Now, none of that has been affected by these disclosure problems. Firstly, and I'll show you this, we have the contracts by which the defendant acquired the units. As I've said, remarkably, Your Honour's not been shown these. Took you to just about everything else. They didn't show you the operative documents by which the units were sold. So we can look at those documents to see whether the lease was assigned. Now, there is this allegation that there might have been some other agreement, a master sales agreement, in relation to the retail. And that simply doesn't exist. That issue is not going to be affected by the disclosure problem, because at least in relation to Ms. Fernandez's emails, the relevant searches have now been done, even over the missing emails. You have the evidence of that. I showed you that in paragraph 13 of Mr. Barrack's witness statement. So those missing emails won't affect the position of whether there's some other document, which my own friend has never been able to obtain, which says something different from the sale and purchase agreement. I'll come on to why that can't be the position anyway, and why you can be perfectly satisfied now that there is no master sales agreement, and certainly none that would be inconsistent with the sale and purchase agreement. So this problem with harvesting emails can't have affected that issue. As to registration, which is the next issue, we have the account from the registrar. The consequences of what happened in the registrar are a matter of law, but certainly further searches of my client's documents are not going to shed light on that issue. As to estoppel, that depends on the claimant establishing, firstly, some representation or assurance by my client that the claimant had an interest in the property, and secondly, actions to its detriment, which make it unconscionable for my client now to deny that interest. So the representations are all about communications, but they have to be communications between the claimant and Emirates, things about which the claimant has to be aware. My learned friend has finally pinned his colours to the mast as to what the representation was, and he says yesterday the representation was the signature of the lease registration form. So there's no light going to be shed on that through to further document disclosure. As to reliance to detriment and unconscionability, that's all about action that the claimant has to say that it has taken in response to and in reliance on the representation. Now, as we'll see, none of that's properly pleaded. The way in which it was put yesterday orally doesn't make any sense. But in any event, again, no documents from my client are going to shed any light on this. Now, the defences are simply pleaded on the basis, I'll put on the basis of the facts that are pleaded by the claimant. So it's the claimant's own pleaded case that we rely on to say, well, this just doesn't work, as a matter of law, as a matter of construction of the terms that are pleaded. And so the consequences of that, again, will not be affected by any documents that my client can have. So the position remains. Your Honour can and should find that the case is advanced, and as the claimant proposes to advance it, has no real prospects of success. So, as to this suggestion that Ms. Fernandez should be hauled into this court, it is simply misconceived. This is an interlocutory hearing. It is not a forum for resolving disputes of fact. And that is why it is extremely rare to have cross-examination on an interlocutory hearing, since it's an order of last resort. I must have appeared in literally hundreds of cases in this jurisdiction in England, literally hundreds, possibly up to 1,000. I couldn't give enough on it. And I have never seen anyone even make an application of this sort. Now, in theory, it can happen. And my learned friend relies on the Djibouti case. And that was a completely different circumstance. What had happened was that the claimant had applied for and obtained ex parte a freezing order in that case, and it had been discharged for breach of the duty of full and frank disclosure. And so the court had to determine the extent and nature of the breach of the duty of full and frank disclosure. And the facts of the case are extreme, because the solicitor involved was found to have deliberately suppressed evidence, and that had been done to advance a case to obtain the freezing order, and the freezing order had been used to get an Interpol Red Notice, and the Interpol Red Notice had been used in effect to harass the defendant at his home and tell him that he was going to go to jail for a very long time. It was about as serious misconduct as it gets. And so the court was faced with having to decide an issue of the extent of the culpability of that solicitor in breaching the duty of full and frank disclosure. And apart from anything else, there was a disciplinary element to the whole thing, because he was an officer of the court. That is nothing like this case. There is no disputed issue or fact which would help this application either way. Even if that could be the right course, Ms. Fernandez is the wrong target for all of this. She's not employed by the defendant. She's not controlling the disclosure process. She has, as I've said, been giving assistance. But the disclosure exercise has been undertaken, as we see from Mr. Barrett's witness statement, by Mr. Barrett, supervised by Mr. Haddy Brocklehurst. My own friend made a suggestion yesterday that lawyers shouldn't be giving evidence, and that, with respect, is an extremely odd suggestion. Mr. Barrett was giving evidence of what he had done, of the process that and the review that he had conducted. The only other person who could shed any light, people who could shed any light on this, would be the IT personnel who harvested the emails in the first place. Now, procedurally, this application is also a complete mess. It is an application made against my client. A witness summons is an order issued by the court against the individual. Now, normally it needs to be personally served on the individual at least 7 days in advance of the hearing. That's in the rules at Rule 30.12. Now, the court can shorten that time period, but it's obviously going to be slow to do so. Why? Because if the individual fails to comply and doesn't attend, they are in contempt of court. So they need to be given a chance to say, I can't attend. They need to be given a chance to organise their affairs to make sure they can attend. So it's wholly extreme to say that, and in any event, the prospect of the application being granted and Ms. Fernandez being ordered to attend this afternoon seems to be exceeding. And ultimately, the claimant should not be allowed to use that as an exercise in fishing for more evidence to see what more can be extracted from Mr. Fernandez. Now, if Your Honour wants more information about what went wrong, we can provide that. It will not change the issues on this application. That information and the evidence supporting it will not be coming from Ms. Fernandez. And certainly, there's no justification for having it by means of a witness summons. If Your Honour is troubled by what has happened, then we can provide a full explanation of that, if necessary, in the form of a witness statement, however Your Honour wants that to be produced. What's not going to assist is somehow delaying the real applications, distracting from the real issues in these applications, which is that on the face of the material, there just isn't a real prospect of success, there isn't a real viable claim here. And don't forget, the normal process is the party pleads out its case first and then asks for documents relevant to its pleadings. Otherwise, it's quite hard to see how you can define the scope of the disclosure. But in any event, the claimant is in a far better position to plead a case, to state what its position is going to be, Here we are, 3 years after the claim was first advised. So that's what I have to say about the attendance of Ms. Fernandez. I was going to move on then to deal with the questions of immediate judgment and amendment. Now, at the outset of my submissions, I just make this one point. There were a large number of inaccuracies in my learned friend's submissions yesterday. Now, I intervened more, perhaps, than the court would want me to, and more than I would want to have to. But it is a difficult balance that one has to strike when one sits and listens to somebody misrepresenting facts in the case and also misrepresenting the case that I am in fact advancing. Court time is wasted, and the danger is that you want to get stuck in Your Honour's head the assertions that are being made. So I picked up, as we went, probably against my better judgment, some of the more egregious examples, but not all of them. Now, many of the inaccuracies don't matter for the purposes of this application. In respect of those that do, I will deal with them. But I just say at the outset, Your Honour is here to deal with relatively limited issues on relatively limited applications, where there are many of them, but by the parties. And if I don't deal or respond to any particular allegation that my learned friend makes, then I wouldn't want it to be taken that I accept what has been said simply because I don't pick it up. Many of those issues are pure prejudice issues. So, for example, there was this complaint about an attachment to an email of the 9th of December 2012 that was left off the original disclosure. And what my learned friend said, and so the email, the body of the email, if you recall, spoke about all of the units being transferred, and the attachment just referred to the residential units. And this was provided by Mr. Hadi Brocklehurst, and you were taken to the provision in his witness statement explaining this. My learned friend said, well, I don't accept that, because the appendix is about residential units. So because the annexure to the email didn't say what my learned friend wanted it to say, he disputes the word of Mr. Hadi Brocklehurst, my client's general counsel. So yesterday during the course of the hearing, to put this one to bed, we produced the digital version of the email. My friend appears now to accept that there was no failure to disclose in relation to that. Another complaint that was made, and I do need to deal with this very briefly, was that there was a letter which was misstated by a year. Does you want to recall that, with the difference in dates between 2012 and 2013? My own friend said, well, I don't allege misconduct, but this should have been pointed out to the Court of Appeal. Now, if Your Honour is interested in this issue, we can deal with it on evidence, no doubt. My instructions are that we told my learned friend expressly about the misdating in that letter prior to the Court of Appeal hearing. I'm told my learned friend nevertheless put the wrong date into his chronology, and at the hearing, my client's solicitor was only called on to make very limited submissions. So there's a sort of implied suggestion that somehow my client's advisors trying to pull the wool over the eyes of the Court of Appeal could leave Your Honour with a very false impression of how my client has been litigating this case. It's completely unfair, and the material shouldn't be presented in that way. There are other examples. As I say, I will pick up on the ones that matter, but I just wanted to highlight those two at the outset. So, immediate judgment, application for amendment. The issue at the heart of both of those applications is whether, in respect of each part of the claim, there is a real prospect of success. That is the test for immediate judgment, and it's also the test for amendment. I don't think that's disputed. There's a case called Orion Holdings which confirms it in this court, but it's the orthodox position also in England. So when it comes to amendments, the amendment shouldn't be permitted where it's speculative or unsupported by any evidence, or where it is bad in law. I won't labour the test. My learned friend accepts the position and summary that I rely on, But just to give Your Honour the highlights, when dealing with these sorts of issues, firstly, the prospects of success must be real as opposed to fanciful. That means that the prospects must be more than merely arguable. Is Your Honour looking for the rule? It's 24.1.
Yeah. Yeah, go.
So the rule is 24.1. I'm saying the test is the same for amendment. But when we get to what the rule means, real prospects of success, it's real as opposed to fanciful, must be more than merely arguable. Your Honour should not conduct a mini-trial. However, the court is not required to take every statement at face value. If there's a point of law or construction, the court should grasp the nettle and decide it. That's the summary from Nest Investments. There is a difference as to who bears the burden of proof, of course, because when the claimant seeks to amend, it bears the burden. Of course, both parties also apply for immediate judgment, and technically each bears the burden of proof in their application. As I say, my position, however, is based on law and construction, so nothing is likely to turn on the burden of proof. But when we approach these issues, I say the background is significant. We are 3 years into this case. Your Honour is faced with 9 bundles of documents already. The parties have committed huge resources to this case already. I've seen the cost bill of my learned friend for the Court of Appeal application, the application to the Court of Appeal against the security that was made, and my learned friend's cost bill for that was $200,000 US. And the total cost bill is likely to be very substantially more than that on both sides. And here we are, with the claimant effectively wanting to replead its case from the beginning and start again. As I say, ordinarily you plead out your case first and then you ask for relevant documents. Here the claimant's had the benefit of documents first and English-style disclosure. So regardless of whether that has been as thorough as it could be, the claimant is far better placed than the normal litigant would be to set out its case, and it's had ample opportunity to do that. It has known since the 12th of February what the defendant's position is on this application. It's clearly set out in Mr. Faddy Brocklehurst's witness statement. And a draft defence was filed was provided with that statement as well at the same time. And in response to that evidence and the draft defence, the claimant served a yet further version of its proposed pleading. I'll take Your Honour to that because it's important to look at actually what the position is. Your Honour wasn't taken to that yesterday, but that remains the case that my learned friend proposes to advance on behalf of his client. We heard a lot of other matters being raised yesterday, but Your Honour, my primary position is that the court should confine itself to that. That is the case. That is where the claimant set its stall. And that is all the more important here, I say, where the quantum of this claim is entirely unknown. And on inspection, it is highly unlikely, I say, to be significant. And I can show you this from the draft pleadings. If we take up bundle 1, please, and turn to tab 7. I've been working from the version that starts at page 185, and that bears some markup which explain, as I understand it, the changes that were introduced to the draft after my client served its evidence in support of its application in response to the claimant's application. So page 185 is where that starts, and if we go forward to page 189, we see this point about the claimant's case being that the lease was amended. If we start at paragraph 28, on the 15th of March 2012, this is the pleaded case of the claimant, to be pleaded. 15th March 2012, agreement between Union Properties and the claimant regarding the leased units was reached as follows. And the most important bit for my purposes is C. The further lease commencement date and rent commencement date was to be adjusted and revised towards a new date once progress of occupancy of the commercial units in Limestone House was achieved. Now, the lease commencement date is the date when the claimant would be entitled to entry into the property. So until then, the claimant is not entitled to possession of the property. It can't occupy it. Now, my position is that the effect of that agreement was to put the lease generally on hold. So there's, and I'll develop this in due course. That's my first defence that I want to advance today. That there's no way to determine, on the face of the agreement as it was amended, when the lease commencement date should be. There's just no mechanism to determine that. The result of that, you can call it uncertainty if you like, and that's how it's put. It becomes an uncertain contract and therefore not legally enforceable. The effect is that the parties just said, we will put the lease on hold indefinitely. That's the effect of that. But I'll come back to that. Just looking at the case that's advanced. If we go to paragraph 31, you will have seen complaints about the 60% issue, and it was suggested that this was introduced by my clients. It's simply not correct. Paragraph 31. The first defendant on the 23rd of April 2013 confirmed that the commencement date of the further lease could be extended until the Limestone House retail was 60% leased. And so 32, the extension of time for the commencement of the further lease binds the lessor to make the premises available to the claimant, either when the surrounding shops are 60% leased, or if the claimant waives that condition at an earlier time as notified by the claimant. Now, the 60% element of it may well have been abandoned, but we'll look at it because it's instructive to see how you might interpret that clause. I'd understood this to be inserted to try to get around the problem that trying to work out what progress meant is impossible. And so what the claimant was trying to do was crystallise that into something which they could say was objective, sufficiently objective, to amount to a contractual agreement. But now they've abandoned that. They walk away from that entirely. I say there's no support for that 60% figure, but even if there were, that in itself would be uncertain. But in any event, that's no longer, as I understand it, going to be advanced by the client. As to B, the claimant, as to B, this idea that there's some scope for waiving this, or that it's a condition at all, there's no basis for that at all, and I'll come on to that as well. You know, either it's amended or it's not. It's not a condition which the claimant can waive. And as I say, the effect of all of this is to render the lease void. But in any event, the claimant's position in this pleading is that the lease has not yet commenced. The lease commencement date has not arisen. It's not said the claimant has waived the condition, or the claimant waived the condition on X date. And if you look at the relief that is sought, you go forward to page 197. And at the bottom we see the relief. Wherefore the claimant claims against the, and this is against the second defendant because the second defendant is in possession. B, an order that the further lease period be amended to a period of 10 years from the date of judgment, or a later date to be determined in the judgment. C, an order that the second defendant make the lease unit available for a period of 10 years from a date to be determined by the court. So what the claimant's saying here is that the date of commencement of the lease should be the date of judgment. As I've said, the lease commencement date is the date the claimant will be entitled to access. What does that mean? Just as a matter of logic, if the lease commencement date hasn't arisen, there can be no rights to enter yet. So there can't be any loss yet, because there's no breach in keeping the claimant out. That is the logical consequence of the claim that is pleaded. So this becomes all about losses that the claimant might suffer in the future. Now, Mr. Al-Khalili, in his recent witness statement, says, the loss is in the millions. How is that possible if the lease is on hold? The claimant has never said and could not say that the lease is not still on hold. You've seen the pleadings, it says the opposite. So just dealing with this question of what's likely to be, and dealing with the discretion as to how deeply Your Honour looks at these issues, it's an expensive case which is unlikely to have any value. But even if I'm wrong about that, the next question is, why hasn't the claimant looked elsewhere? So we're nearly a decade after signing the lease. the claimant, if it truly was suffering from a breach of contract, would have a duty to mitigate its losses. Restaurants have opened and closed in the period this lease has been in dispute. It's just absurd to say that there's no other site that could possibly work for this restaurant. Nothing particularly special about the location. And if another location would be more expensive, then the quantum of the claim, normally the quantum of the claim would be, you'd say, they didn't let me into this lease, so I got a unit over here, it cost me more, so now I'm going to claim the difference in the rent. But the claimant doesn't even say that. Just says, oh, in fact, the recent evidence simply says that the claimant has very good reasons for insisting on that location. Even now, it's not said what those reasons are. The whole thing is very odd. And then the final point on quantum, just so you have this context when looking at these issues. As things currently stand, the SMS prohibits the use of the units as a bar and restaurant. So even if my client allowed, or was in a position to allow the claimant to have access to these units, there would be no loss because it wouldn't be able to operate a bar and restaurant. It would suffer more loss. It wouldn't be able to open. So, if there is a way to resolve this claim on these applications, I say Your Honour should take it. If, as I say it does, the claim turns on issues of law or construction, then Your Honour can and should decide them. So, Your Honour, I'm going to deal with the three ways in which the case occurs: assignment, registration and estoppel. But before I turn to those, what I was going to do was just to try and give Your Honour something of an overview of the way the real property law works. And I'll do this as briefly as I can. I've summarised the position in my skeleton argument. But I'd just like to make sure that Your Honour has in mind in particular this distinction between, on the one hand, the position in contracts. So contracts bind, some exceptions that don't apply here, contracts bind only the parties to the contract. That's why my learned friend needs to work on the assignment case. And on the other hand, the position in rem, which are the property rights, the interest in the property, and that binds the whole of the world. You have to separate those out. Because a contract doesn't necessarily create an interest in rem over the property. It may do, it may not, and we'll look at that in a moment. But an interest in land, an in rem right, doesn't create a contract. So they are two separate, distinct concepts, and they need to be kept in their own boxes. So if we look at the in rem part of it, I won't trouble you with the principles of contract, I'll deal with the relevant parts, but if we look at the in rem part of this, the starting point under DIFC law is what's known as the indefeasibility of title. So that means that if the interest, the starting point, there are exceptions, but the starting point is if the interest is not on the register, then there's no interest in land. There are no in rem rights. And so what that means is that when a purchaser is buying a property, they can check the register and they can see what interests affect the land, and so they can be confident that once they purchase, they take the land free from any unregistered interests. So if the register is clear, the incoming purchaser gets clear title. Now that is subject to exceptions, and the claimant relies on one of them, and that's the estoppel part of it. It is worth at this point just looking at the law briefly and relevant provisions of it. It's in my authorities bundle, tab 1. Authorities bundle, I'm afraid. We go to Article 25. That's where I'd like you to start. So this is the point: conclusive evidence of information in the register. So the information about a registered instrument recorded in the register is conclusive evidence of the registration of the instrument, when the instrument was registered, and the contents of the register. Article 26, the need for registration. Subject to this law, an instrument does not transfer or create an interest in real property until the instrument is registered. If we go down then to Article 29, conclusive effect of registration. Subject, and this is the point about indefeasibility of title. Subject to this law, the registration of a person as owner of an interest in real property is conclusive evidence that the person is the owner of that interest and the person's title to that interest is indefeasible. And then we have 30, the quality of the registered interest. And then 31 is again the heart of the Torrens system principle. Subject to this law, a registered owner holds the registered interest subject to all prior interests registered or recorded in the folio of the register for the relevant lot, but free from all other interests. So when you buy, if it's not registered, subject to the exceptions, you get it for free. And also, important difference from, in particular, English law, 32A, in particular, the registered owner is not affected by actual or constructive notice of any trust or unregistered interest affecting the lot. So the fact that you know that somebody else has a lease over a land is not enough. If that lease is not registered, it doesn't bind you as an incoming purchaser. I don't think we need to look at the others, save for 3, which is the fraud exception. I was taken to this yesterday. It says paragraphs 1 and 2 do not apply to any interest or matter mentioned in Article 31. So that's the general carve-out for the exceptions in 31, of which my learned friend relies on 1. If there's been fraud by the registered owner in acquiring or holding the interest, and importantly, C, if the registrar has reasonable suspicion, importantly 4, for the purposes of this article, knowledge that a trust or unregistered interest is in existence is not of itself regarded as fraud. So my learned friend said in his skeleton end yesterday, it said that a notice of an interest doesn't create an interest. And then he said, well, what the law actually says is, and he took you to that provision. What it didn't take you to was Article 32A, which is the one that says expressly that in particular the registered owner is not affected by actual or constructive notice of any trust or unregistered interest affecting this law. Now that is subject to the exceptions, and the exception that my learned friend relies on is 31H. A registered owner does not obtain the benefit of Article 30 in relation to the following interests or rights affecting the lot H, an equitable obligation binding the registered owner as a result of the registered owner's conduct. So that, for now, is all I want to show you in the law. And as I said, this is based on the Torrens system. And a similar system has been introduced in other jurisdictions around the world, not in England. And it's a difficult system to introduce when you are moving from one system to the other. But when you have a green field, as we did in the DIFC, it's much easier to introduce the system from scratch, because every piece of land can be registered immediately, and there's no concerns about what happens when people move from the unregistered position to the registered position. And just to show you how this principle has been interpreted, I just wanted to take you briefly to a case in the Australian courts behind tab 8. If we go, we've got happily page numbers at the bottom right. Do you want to have those?
Tab 8?
Tab 8, yeah.
Authority bundle, right?
Of the same authorities bundle, yes. And we go to page 230.
Yes.
The bits I'd like Your Honour to look at are paragraphs 20 to 21. Now, there are differences between the systems in the different countries, but the heart of the system, the Torrens system, is the same. So just reading this passage supports the view that the effect of registration of a subsequent dealing, bringing about the registration of proprietorship of an estate or interest in land, is to extinguish all prior unregistered estates or interests which, but for that registration, would have conflicted with the proprietor's estate or interest, or encumbered that estate or interest, unless the prior unregistered estate or interest falls within the exceptions to indefeasibility of title. mentioned in the equivalent of our Section 31. In other words, a person seeking to preserve an unregistered interest not falling within those exceptions must register that interest in advance of the registration of a subsequent inconsistent dealing, or prevent such registration by caveat or otherwise, and thereby enable registration of the unregistered interest. Once that interest is defeated by registration, a subsequent inconsistent dealing, bringing about the registration of a new proprietor, the first interest is extinguished for all purposes and cannot be asserted against any later proprietor. I don't think we need the next sentence, but if we go to the end of the next line, the first interest does not become an inchoate interest capable of being asserted against a later proprietor, or an interest which remains in suspension, so that it is capable of subsequent revival against such proprietor. So it's gone. We skip that and go to the next paragraph, 21. It is an incident of the indefeasibility of the title of the registered proprietor, not only that he or she holds free from prior unregistered interests, except those specified in Section 68, but also that he or she has the capacity to transfer a title to the interest to which he or she is proprietor to a successor, free from such unregistered interests. In this respect, the operation of the Act is similar to the operation under general law of the doctrine of bona fide purchaser for value, who acquires the legal estate without notice of a prior equitable interest. The acquisition of the legal title by such purchaser in those circumstances defeats the prior equitable interest in the sense that the interest is destroyed. Thus, a subsequent purchaser with notice of the equitable interest who purchases from the first purchaser is not bound by the interest. If we then go forward, just to show you if you just turn forward to page 237 of this, you can see how widely this particular case is cited in the case law. And what I won't take you to is another case called Conlon at tab 9, but I've set out the passages in my skeleton argument which recites the relevant bits that I've just shown you. But if we go forward to some of the commentary on the Torrens system, very briefly, tab 17, if I may. We start, please, at page 641 of the bundle, that is.
641,
bottom right corner. So if we look at the bottom paragraph of that page, knowledge of any unregistered right prior to registration does not mean that the registered proprietor is subject to the in personam exception. As Carruthers notes, an in personam claim that is wholly or substantially based on the registered proprietor's knowledge of a prior unregistered interest will be inconsistent with the Torrens system and will therefore not give rise to the in personam exception. So this is the question about whether there might be a personal claim. And the point is, any personal claim which is solely based on the new purchaser knowing about a prior unregistered interest is not going to succeed because it's inconsistent with the system as a whole. Consequently, the Torrens title system is a race system because registration protects the registered proprietor even though it is aware that registration harms another person. And then the final passage I wanted to take you to is in an article by Professor Tang Wu, which is behind tab 18. Looking at, in particular, the Singapore and Australian systems. And if you look at the introduction, just to get a sense of it, page 647, the central feature of the Torrens system of land registration is the principle that the registered proprietor has indefeasible title. Every land lawyer knows that indefeasible title is shorthand for the notion that a registered proprietor's title is paramount. It cannot be defeated by a prior unregistered interest, except in certain categories prescribed by statute. Memorable words of Edwards J. and Fells and Knowles, the cardinal principle is that the register is everything. By conferring on the registered proprietor an indefeasible title to the land, the Torrens land system save persons dealing with the registered proprietor from the trouble and expense of going behind the register in order to investigate the history of their author's title. As such, the Torrens system is said to enshrine the mirror principle. The register effectively reflects all interests affecting the land. However, the Torrens philosophy that the register is everything is inevitably subject to certain qualifications. Apart from the statutory exceptions to indefeasibility, there are also non-statutory exceptions which are collectively known as the in personam or personal equities exception. So that's in effect the contract assignment case that's being advanced, the in personam, but also the statutory exception, which is the equity exception. If we go forward in this to 653, dealing with a debate as to the extent of the in personam exception. So it doesn't directly apply in our case, but it illustrates how this court should approach in particular the equity, the equitable estoppel claim. 653 at the bottom right I'm looking at, the numbering at the bottom right, so it's 678 of the article. First paragraph, the wide approach to the in personam exception as currently articulated is far from satisfactory. Recall that Thomas J. said in Lawton that the key element to in personam liability is involvement or knowledge of an unconscionable or illegal act. The latter limb, just simply knowledge, of Thomas J.'s test, mere knowledge on the registered proprietor's part is almost certainly too wide to be utilised as a guiding principle in relation to the in personam exception. This formulation is inconsistent with the hallowed Torrens principle of absolving the registered proprietor from liability based on actual or constructive notice. So how do we approach it? If we look at, turn forward please to 655, Professor Tang, sets out some principles which he says are important to keep in mind when considering the scope of the in personam exception. In the middle of the page, 1, 2 and 3, prima facie position is that personal claims may be brought against the registered proprietor unless such claims directly or indirectly undermine the principle of indefeasibility of title. The claims which are brought against the registered proprietor must in most cases be a known claim, either in law or equity. This requirement does not mean that the courts are forever precluded from developing new causes of action, proprietary responses to meeting changing social needs response to Torrens land. However, such novel causes of action or proprietary responses must be principled, supported by precedent, and not dependent on vague notions of unconscionability. The personal claims brought against the registered proprietor must arise from the personal conduct of the registered proprietor. Moreover, such conduct must amount to something more than merely becoming a new registered proprietor. And then 6, over the page, the personal claim brought against the registered proprietor must not undermine the principle of indefeasibility of title in substance. This is essentially a question of fact. If the registered proprietor has done no more than register their title, then no personal claim ought to succeed against them. So, there are exceptions to this indefeasibility principle, but none of them can be interpreted in a way which undermines the fundamental principle, which is that a purchaser is not bound by a prior unregistered interest simply because he knows about it. That is the hallowed principle of the Torrens system. So the position is quite different from English law. And the way in the first article that we looked at, the way that it's explained there, is as a policy choice between, on the one hand, protecting a party who has an unregistered interest using liability rules on the one hand, and protecting them using property rules. So giving them in personam rights against the outgoing owner, and giving them in rem rights against the incoming owner. So if you take the position of a party who has a valid and binding lease, but it's unregistered, they have contractual rights against the landlord. If the landlord sells that land to another party, English law protects the leaseholder by making sure that the property rights go with the land. Now that's subject to exceptions, but that's the starting point of English law. That's where you get to the questions of bona fide purchase of the value, and people can escape from the starting point. But that's the starting point. The leaseholder gets a claim against the new owner to make good their in-rem interest. Under this system, it is the other way around. The leaseholder is protected with liability rights. He loses his interest in land, the interest is destroyed forever, but he is protected with a claim against the original outgoing landowner. And on top of that, and we see that in our real property law here as well, if something has gone wrong with the registration process itself, If something has not been registered when it ought to be registered, there is a system of indemnification. So a party who has suffered as a result of that has a right to be compensated by the register. And that system of indemnification is supported by the registration fees that go into fund it. And there are policy advantages to arranging land transfer in this way. Primarily, they are the cost of purchasing property and the speed of purchasing property, because you don't have to investigate what went before, which can take a very long time. You have to page through this long history of transfers to work out who got the land from in England, the Crown. But also purchaser confidence, because they know if it's not on the register, they can buy the land and they take it free from prior interests. So that's the in rem part of it. Is the incoming owner bound by the prior unregistered interest of a leaseholder? And the answer is only if the exceptions apply. And I'll come on to the one that you're reading. The other way that the incoming owner might become bound is personally by contract. So as my own friend puts forward the case, the new owner might agree to take an assignment of the lease. My learned friend pointed you, I won't go back to it, to Article 33(1) of the Real Property Law, which states that notwithstanding the effect of that law, nothing stops a contract or a lease taking effect in contract. But that's the distinction which is at the heart of this, and that's the distinction that needs to be kept in mind. So a lease which is not registered is not effective against the world, subject to the exception, but it is effective, or can be effective, as a contract. So that I say illustrates the case. I think it's important to bear that legislative background, that policy background in mind when we then go forward and look at, in particular, the equity exception. But I'll start with this issue of assignment, if I may. So this is a question of whether or not my learned friend has a real prospect of successfully showing that Emirates, my client defendant, became party to the lease. So what my learned friend has to establish there is that there was an agreement between Union Properties and Emirates for the assignment of the lease. And then I'll come on to the question of registration. Was there registration? Does that even matter now, because we know that there is no registration now? And finally, deal with in his case, the Article 31H exception. So starting with contracts. As I say, Your Honour's looking for a contractual agreement between Union Properties and Emirates for the assignment of the lease. And as I've said previously, in my learned friend skeleton, also orally, my learned friend refers to just about every other document except for the one by which my client purchased the units. So my learned friend described tab 20, and in his words, as a comprehensive collection of the relevant documents. It just isn't, because it misses out entirely the critical document, the actual document by which this land was sold to my clients. So just starting with what he focuses on briefly, my learned friend chooses to focus on two letters. If we go to bundle 2, tab 20, and page 420, please.
Which page?
420. So my own friend says the offer and acceptance emerged from two documents. And firstly, this is Union Properties offer. So you'll see that at the outset. We write now to offer our inventory. Does you want to see that?
Yes.
Vacant and rented as at 15th of December. Now, my learned friend says at paragraph 43 of his skeleton argument that that offer was accepted. But if we go forward to the document that he relies on, page 434, we just see that's obviously not the case. What you've got there is a counter-offer. On behalf of Emirates MBD, we would like to express interest and submit its conditional offer to Union Properties to purchase from its properties. So when he says in his skeleton 43 account, the offer was accepted, this offer was conditional, the offer was accepted. The 43 says the counter offer contained by an offer by UP to assign the leases. The offer was conditional, not in relation to the assignment of leases. I don't know where he gets that from, but the offer was accepted. And then he refers to this document. It's just plainly wrong. You can see that from the first paragraph. But anyway, if we go down to 6A, see my client's offer. 6A, UP agrees the following: to execute sale and purchase agreements for each of the properties in a form and substance acceptable to Emirates within 2 weeks from the date of UP's acceptance of this offer letter. The properties should have clear title, free of any charge, mortgage, lien, or any due and pending payments to external vendors, contractors, and government departments and utility providers. But all of this is by the by, because this precedes actual sale agreements. And for those, we don't find them in tab 20 of my learned friend's comprehensive bundle of documents, we find them in the appeal bundle, tab 2. Do you want to have that? Appeal bundle 2, tab 17. So there are 2 of them.
Give me a second, please. Appeal bundle 2, huh?
Appeal bundle 2, tab 17. So just to orient Your Honour,
Sale and purchase agreement.
sale and purchase agreement for unit 17A.
17A.
Your Honour will remember that there's another unit as well, 17B. The sale and purchase agreement for that is separate and appears behind the next tab.
Yes.
So I'm not aware that I don't think there are any material differences, but no doubt someone will point them out if necessary. But if we go forward and look on page 132, you will see the date of the agreement is the 11th of January 2012. My learned friend suggested it was the 22nd of January. It does appear to be the 11th. I'm not sure anything really turns on that. There's another date on it. In any event, it looks like the correct date is the 11th of January 2012. If we turn forward to page 139 of the bundle, bottom right corner, you'll find clause 4.1.
Again, the page number? You are faster than me.
Sorry, 139.
139. Okay.
So 139, transfer of title. Do you want to have that paragraph?
Yes.
Clause 4.1. So this is the agreement. Provided the purchaser has fulfilled its obligations in terms of this agreement, and I won't go through those obligations. A, possession and occupation of the property shall be given to the purchaser, and all risk and benefit in respect of the property shall pass to the purchaser. That's not possible if there is a lease. The whole point of a lease is that it gives you possession, right to possession, exclusive possession. So the landlord is not entitled to possession. And if we look then over the page at clause 4.3, it becomes even more express. So save for the encumbrances set out in clause 4.6, I'll come back to that in a moment, the purchaser shall accept the transfer of title to the property subject to the provisions contained in the constitutional documents. So the 2 exceptions, so it says, and it deals with the easement restrictions, obligations and so forth, as imposed by the competent authority, but otherwise free from encumbrances. It's an express term that if it's not in the constitutional documents and it's not in clause 4.6, it doesn't impose an encumbrance, it doesn't encumber the transfer. Clause 4.6 looks like, but this is my speculation, it may simply have been deleted, because 4.6 as it appears doesn't impose any encumbrances at all. And then the constitutional documents are defined to include things like the Master Community Declaration. Let's see that 157, I think. Yeah. So 157 includes the strata plan, of which the strata management statement is a part. So not only do the terms of sale say nothing about the lease, they expressly state that Emirates is entitled to possession. They expressly state that the transfer of title is not subject to any other encumbrances, and this is important, they go on expressly to require Emirates to comply with the terms of the strata management plan. We can see that on page 144. We'll just go back, if Your Honour would just go back to page 144 and look at clause 7.9. Deals with purchase acknowledges that the real property law, strata title law and bylaws contain rules and provisions binding upon all owners within the building and the retail component, including but not limited to provisions governing the sale or transfer of units within the building, rules for their general use and occupation, and payment of service charges. The purchaser agrees and undertakes to comply with all such rules and provisions and shall procure that his occupier is aware of and complies with. 7.10. The purchaser acknowledges that the constitutional documents, that includes the strata management plan, strata plan, may be subject to amendments prior to and following their implementation, and that notwithstanding that the new finalised version of the constitutional documents may not be available at the date of disagreement, the purchaser will nevertheless be bound by it. The purchaser shall enter into all further documentation which shall be required by the seller and body corporate building management group and master developer, either pursuant to the constitutional documents or otherwise. And as we see. And then if we go to 14.1 on page 148, there's this obligation: the purchaser will observe and perform and will procure that all occupier will also observe and perform the purchaser's covenants at all times. And then we know what the purchaser covenants are. They appear at, well, the relevant one is at page 166. Well, that's where they start. So if you go forward to 166, you can see the content of what the Emirates is agreeing to abide by. And if we turn forward to 7, 7.1, the purchaser will procure that the users and occupiers of the property and its or their invitees will use the property and the allocated car parking rights and exclusive use rights in the common property strictly and exclusively in accordance with the constitutional documents at all times. Now the problem was that, and we've heard all about this, but the lease was inconsistent with the terms of the strata management statement. Because the lease requires and permits the use of the units as a bar and restaurant. You get that from, I'll give you the references. We'll come back to the lease in a while, but the lease itself appears at Bundle 3, Tab 20, 632.1, and the relevant clauses are 2.7, 3.4.1 and 3.4.2.
Bundle 3?
Yeah, we could look at it now, 320.
Appeal bundle, right?
No, it's in the other bundle. That's why I wasn't going to take it on. So I don't think it's excuses that the lease permits and requires the use of the units as a bar and restaurant. It's very surprising it was.
And the tab again?
Page 2632. And 1 is where it starts. Yeah, volume 3. Sorry, is that?
Yeah.
Yes, great. And so if we go forward to 632.9.
632.9, right?
Correct, yeah. So 2.7. The tenant acknowledges that there should be no delay in opening for business. And then 3.4.1. 63211, use. The tenant shall use the premises solely and exclusively for the permitted use and as authorised in its valid trade licence and for no other purpose whatsoever. And the trade licence, it's in the bundle. We have to go back to Appeal Bundle 1, tab 1, page 11. But it's there.
This is all accepted. So it's
Yeah,
absolutely.
so we don't fine.
So these are the basic facts which were before the Court of Appeal, are reflected in the Court of Appeal decisions. None of this matters here. What matters is the other evidence that they purchased it.
My look for
That's what-
maybe it's
None
that's not
disputed, so
So it's not disputed. So the position is
Wait a second.
that the lease requires and permits the use of the units as a bar and restaurant. So there's a positive obligation on the claimants to use it in that in those terms, and there's a positive obligation on the landlord, whoever that may be, to permit that use. But as we've just seen, the purchaser's covenants in the SPA prohibit my client from allowing that sort of use. And so it's completely and fundamentally inconsistent with the terms of the SPAs that the lease should come with it. Because it would be totally bizarre if at the same time, firstly the contractor signed the lease which permitted and required this use, and at the same time the defendant is promising not to permit or allow that sort of use. So there's no prospect of implying some sort of assignment into this agreement. It's expressed that it's not in there, but also it's fundamentally inconsistent with the agreement that was done. And the final point on the SPA, if you've still got it open, if you just go to clause 15.4, which appears on page 149, still lying tab 17.
yes, page again.
149, please.
Yes, okay.
Clause 15.4, entire agreement. This agreement constitutes the entire agreement between the parties relating to the property and supersedes any previous agreements or understandings, whether verbal or written, including but not limited to representations and marketing material and so forth. So the earlier documents, which my learned friend showed you, can't be relevant because they're superseded. It supersedes is the entire agreement relating to the property. And my learned friend accepts, as he has to, that this is the sale and purchase agreement by which my client purchased these units. That's in his draft pleading. Pleads it out as being the 11th of January 2012.
That's with respect to our case is that yes, there were two sale and purchase agreements. They did not mention the lease, and read as my learned friend says, they tend to suggest that there was no lease being assigned. Okay? But that was not the only agreement for sale and purchase because there was the master sale.
Well, I'm coming on to the master sale agreement, so my learned friend's interruptions are not appropriate.
It's not right to say that this is our pleading, that this was the sale transfer agreement. No. There's two. Or three, in fact. One for each unit and the master.
No, thank you.
All right, so I'll come on to the issue of the master sale agreement in a moment. But let's just look at the positions understood by the registrar of real properties. If you want to have tab 3 of the hearing bundle, so bundle 3, tab 20, go to the back of that, the final 2 pages of that.
Hearing bundle will be volume 3.
Volume 3.
Yes. Page.
The final 2 pages says 851 and 852. So this is the certificate of official search. See, there's one for each unit. They're in reverse order, but if we start on 851 at 17B, you see the registered interests, SPA between Union Properties and Emirates MBD Properties, dated 11th of January 2012. The same entry on the next page. So, I was dealing first with the case actually that was outlined by my learned friend both yesterday and in skeleton argument, that the sale was affected by these prior documents, the documents that came before the sale and purchase agreement. And showing why that can't be right. And if we look at the pleading, because of the interjection we saw, which we see behind tab 7 in bundle 1, bear with me, I'm so sorry.
The draft amended claim form.
Yeah, that's the one. Paragraph. Sorry, I just lost my reference.
Which is maybe.
Yeah, sorry, it's page 188,
Yeah.
paragraph 22. Just to see how it's put in the pleading. Paragraph 22. By agreement for sale and purchase dated on or about 11th of January 2012, Union Properties agreed to sell its remaining units, including the lease, in Limestone House at GIFC. So that's the case as to how the sale came about. That's why I said it's accepted by my learned friend that is the sale and purchase agreement for the land. So then, if we go to paragraph 20, let's take it. My learned friend's making a lot of noise, so we will go through it, and I don't want to be unfair to this case. Let's go through it. Paragraph 23. On or about 29th of March, Union Properties transferred the freehold of the leased interest, Limestone House, to the first defendant. So that's 22 is the agreement of sale and purchase, 11th of January. 23, he says 29th of March, that's the transfer of the freehold. 24, this is the point, the first defendant was aware, prior to its purchase, that the leased units were leased to the claimant pursuant to the further lease. 25. The sale of the freehold interest in Limestone House by Union Properties to the first defendant was therefore expressly subject to and made with notice of the leasehold interest of the claimant as set out in the further lease. And then it talks about the consent of La Crane at 26. The first defendant was aware from 14th March 2012 of the fact of the consent of La Crane. And then on the 21st of December 2011, the first defendant authorised Union Properties to continue the property management of Limestone House. Where there is it pleaded that there is a master sales agreement that came after the 11th of January 2012, which affected an assignment of the lease. It isn't pleaded in that way at all, simply not correct. I'll deal with the assertion of the existence of a master sales agreement, but Your Honour is faced with an amended pleading. This is still the pleading my own friend wants to advance, and that's the pleading that I primarily have to attack. My own friend's had 3 years to put this part of the case together. This is the case. This is the case that Your Honour is faced with. And the point at 24 and 25 is simply that the 24, the first defendant was aware of the lease. 25, the sale of the freehold interest to the first defendant was therefore expressly subject to the lease. So the way it's pleaded is simply on the basis that knowledge of the prior lease means that the lease must have been transferred to the property. And as we've seen, as a proposition of law, at least in this jurisdiction, this is absolutely no foundation. If you actually look at the document, the 11th of January agreement, it says there is no transfer of any other encumbrance. And by the way, everything else that came before is superseded in this agreement. So there's nothing about the master sales agreement in that at all. But anyway, when we actually look at this question of was there a master sales agreement, it is pure assertion. What we know is that there was at one point an intention to have a master agreement for everything. So we see that in bundle 2. Tab 20, page 437.
Bundle 2, page?
2, please, page 437. So you'll see in the middle of the page there's an email chain. In the middle of the page you'll see Ms. Fernandez emailing somebody at UP. Dear Helen, do you have that one?
Yes.
Emirates MBD will be sending across a final offer for acceptance based on the discussion between Mr. Ali and Mr. White and Mr. Carly. Please have the master SPA drawn up and sent to us. And so then above that, dear Melanie, kindly note we have sent the master seller purchase agreements to Emirates for its perusal last Thursday, 15th of December. Attached is a copy from the email sent. Therefore, we highly appreciate receiving your comments and reviews on the contents of the master SPA at the earliest. And then if we go forward to page 439, we've got the draft of the master SPA. This is what was being contemplated. But even this document says nothing about the lease or any leases. In fact, it says the opposite. So if you go forward to page 441, clause 3.1a, you'll see transfer of title. It's a similar clause to the one that's in the unit.
Sorry, the page again?
Page 441. Clause 3.1. And it starts in the same way as the previous clause that we looked at in the unit SPA, provided the purchaser has fulfilled its obligations and so on. A, possession and occupation of the unit shall be given to the purchaser. But not only that, if you turn over the page, page 3.6, turn over the page to clause 3.6, it is further agreed between the parties that in the event of any contradiction between the terms and conditions stated herein and in the individual SPAs to be signed by the purchaser acknowledges and agrees that terms and conditions of the individual SPAs will override the terms and conditions stated herein. So had there been a master SPA that was executed, it wouldn't have affected the position under the sale and purchase agreement. And anyway, it says possession and occupation.
Whilst we're here, sir.
For goodness sake.
My learned friend was granted considerable latitude yesterday, and he needs to address the submission that was made. And the submission that was made, sir, is the 2 pages on.
Mr. Roger.
Yes, sir.
Let him finish his submission.
Okay, I'll come back to it. That's
Yes.
fine.
And your reply, use whatever you want.
Yeah. But the trains have got to collide, sir. And he can't just go whizzing past with a
Again,
case that
this is
doesn't.
his submission, and he has a right how he want to address it to the court.
Thank you.
I mean, as I say, if I say anything that is inaccurate, or if I misrepresent somebody's case, no doubt I will be corrected, and I have no objection to that being a position. But in terms of how I put my submissions, that's a matter for me, and the interruptions really need to stop. All right, I'll carry on. Now, my learned friend said yesterday that the defendant was ordered to produce this document. He says that in the skeleton argument as well. So, he says, because it hasn't been produced, you can infer that it undermines my case. And that, with respect, is creative. The starting point, as ever, is that my learned friend has to prove his case. The absence of evidence does not establish the evidence. And there are cases, plenty of cases, which explain the principles and circumstances in which the court can draw adverse inferences from a party failing to produce evidence. And normally what has to happen is there has to be notice of it, there has to be some evidential basis for the assertion in the first place, there has to be a case to answer, and there has to be no valid excuse for failing to produce the evidence. And none of that applies in this case. But the starting point of my learned friend's submission is simply not correct. My client was never ordered to produce this document. It was ordered to make standard disclosure. I've shown you one of the order. So there was no specific order about a master sales agreement. It's simply wrong to say my learned friend was ordered, my client was ordered to produce it. It's also wrong to characterise the particular provision of the rules that my learned friend relies on. Does you want to have a copy of the rules?
Yes.
My learned friend relied on Rule 28.61. Which deals with the consequences of failure to produce documents. 28.61. If a party fails without satisfactory explanations, this is the point that my learned friend glossed over, to produce any document requested in a request to produce, to which he has not objected in due time, or fails to produce any document ordered to be produced by the court may infer that such a document would be adverse to the interests of that party. So that's why my learned friend has to make the grand assertion that my client was ordered to produce that document. Now, just imagine, let's just take my learned friend's conspiracy theory to the ultimate. Imagine my client simply can't be trusted. All right? What my learned friend is looking for, what he needs to establish is an agreement between Union Properties and Emirates for the assignment of a lease. Right? So that's between my client and Union Properties. So who else would have evidence of that? The obvious party who would have that document would be Union Properties. The other prospect would be the registrar of real property. Now, Union Properties, unlike my client, has been specifically ordered to produce the master sale agreement. Can I show you that? It's in bundle 1, behind tab 3. So do you see the order of the Court of Appeal?
Yes.
And you see the parties, VEGIE, Emirates, and then the DIC Registrar of Companies and the DIC Registrar of Real Property. Sorry, this isn't UP. Sorry, the Registrar of Property was ordered to produce the Master Sales Agreement. You see that on page 145. Paragraph 1b. Oh no, I'm so sorry. I am right. Start again. Page 144. If you see the recitals, this is why it's confusing. Upon reviewing the appellant's application notice, dated 6th of February 2017, seeking a witness summons, did you want to have that?
Yes.
For Bushra Udiri of Union Properties to attend the appeal hearing on 6th of March 2017 and produce documents. Paragraph 1. The application be granted in respect of the following documents. B. The master sales agreement for the sale of the units in Limestone House and Index Tower from Union Properties to the respondent. So Union Properties has been ordered to produce the document, and when it came to it, I believe it was Ms. Bushra-Udiri who attended. When it came to it, she attended and she handed over copies of the master sale agreement for the residential units. So that's the document we've seen. It's behind tab 29. You'll want to have picked up on it at the beginning of the hearing. So Union Properties has said that this is what we have. Now nobody has suggested that they are not telling the truth about what they have. They've been ordered by this court to produce it. But the full point is, why would they? Because it's in their interests to show an assignment. It's in Union Properties' interests to say, yes, this gets us off the hook. Look, the lease was transferred. The registrar has also been subject to an order and we see that in the same order behind tab 3. Paragraph 4A, DIFC Registrar of Real Property has been ordered to produce the file or that part of the folio relating to the units. So everything that it's got relating to the units has been produced, and there's nothing there. Now, for good measure, because of the complaints by the claimant, my client has conducted further searches for these documents. Mr. Hadi Brocklehurst has given evidence that the original documents that were gathered for the disclosure exercise have been researched, and nothing has emerged. And we see that in bundle 4. I'll take you to this, because there's also evidence in there that's relevant. Bundle 4, tab 23. If I can just take you to page 911. So we're still on this question of whether there might be some mysterious and elusive agreement.
Would you mind bookstore?
So it's behind tab 23, page 911. So paragraph 5, Schedule A, paragraph 1A, so dealing with the application to be made for disclosure. Says particular paragraph requests signed master sales agreement made on or about 22 January 2012 relating to Limestone House Retail. I've read the document production statements and so forth and produced the documents in its possession. Nonetheless, further searches in the raw data harvested for the document production served in February 2018 and inquiries by my team and former staff members Rajesh Mistry have failed to produce such a document. Indeed, Rajesh Mistry recalled that while a master sales agreement was signed with Union Properties and First Defendant Connection...
Objection, sir. That is hearsay.
I'll deal with the hearsay argument, but it seems to be this idea that we're in an American court here. We're not. Can I just make my submissions? Was signed between Union Properties and First
If it's
Defendant
hearsay,
Connection.
I'm entitled to make an objection. There's rules about hearsay.
I'll take you to the rules about
and,
hearsay.
and those rules say that it should start with an objection. I'm making it. Thank you.
Thank you. Smart. Go ahead.
I'll take you on to the rules about hearsay. Anyway, I've failed to produce such a document. Indeed, Rajesh Mistry recalled that while a master sales agreement was signed between Union Properties and First Defendant Connection with certain residential properties, the sale and purchase of retail units, including disputed VEGIE units, were documented by signed individual sale and purchase agreements only. And then for completeness, he produces the master sales agreement for the residential units, which we've discussed previously. So there's been a further search for these documents by my client in the original data that was harvested for the disclosure exercise. It hasn't produced anything, and we've seen. I'll come back to this evidence about what Mr. Mistry says. But then, since the problem with the emails emerged, what has happened is that the bits that were missing from Ms. Fernandez's emails have been researched. And Mr. Barrett deals with that in his witness statement behind tab 27A. If we go forward to page 3 of that document, it's 1123.3. 27A is the and I showed Your Honour this at the outset of the morning. Paragraph 13. Beg one?
1123.
That's the, yes, correct. 1123.3. It's been inserted. And we see there again, what's happened is that the documents have been researched. I'll just give you, Your Honour, a chance to remind yourself of this.
Okay. Before you refer me to the paragraph 13.
1.3, yes. So in addition, I searched Melanie Fernandez 2012 archive using the following search terms. And if you recall, what was missing was documents from 2012 and 2013. 2013 is not going to be relevant because that's well after the event. So what was missing was reserved. 2012 was researched. And you'll see the search terms that were used. And there was no response to that. And then he says, this search result is consistent with the factual position given to me during a telephone call in early 2019 by Mr. Rajesh Muhairi, former CFO of Emirates MBD Properties, who recalled the sale and purchase of the retail units, including the disputed VEGIE units, were documented by signing individual sale and purchase agreements, and that no retail master sale agreement was ever signed. On the basis of these searches, likely in my view that the master sales agreement for the retail element of Livingston House does not exist. So, my letter friend. So you've got 2 points there. One is, we've done the search. Yes, there was a problem with the original data collection. It's been corrected in relation to Mr. Fernandez, and we've researched those documents. Nothing's come up. Union Properties have carried out their own search. Nothing's come up. There was a draft, but it went nowhere.
That's not even hearsay. There's no evidence to support that submission as to what UP did and didn't do.
Mr. Roger, if you keep interrupting, you will not finish until...
It's very difficult. I'm just doing...
Just keep your notes for your turn. Otherwise, you're confusing the course.
Okay, thank you.
There is evidence of what UP did, because they were ordered to come to court, and they produced the documents they produced. There's a dispute about that. So we don't know precisely what they did in the search, but they would have complied with the order. Let me just deal with this hearsay point. So my own friend says this is hearsay. The answer to that is, so what? Hearsay has been admissible in England for decades. It's admissible in this court since it opened. The position under the court law, in fact, is the court can do what it likes in terms of evidence. There are rules in relation to hearsay notices. But and we can look at those briefly. 29.101. My friend just makes the assertion it's hearsay, so it's not admissible, but doesn't actually present any authority for that. It's utter nonsense. Hearsay evidence. Clause 29.101. I've never heard it suggested in this court that hearsay is not admissible. It's just an extraordinary assertion. Rule 29.101. In this part, hearsay means a statement made otherwise than the person giving oral evidence in proceedings, which is tendered as evidence of the matter stated. References to hearsay include hearsay of whatever degree. So just pausing there, just think about that. This is what people get wrong with hearsay. They think hearsay only means somebody writing a witness statement saying I had a conversation with someone else. It's not. It's far broader than that. Every single document in this bundle is hearsay evidence. It is tendered as evidence of the truth of its contents, otherwise than by an oral witness coming to court and speaking it. That's the point. It used to be the position you had to provide a hearsay notice in respect of every single document. That's just simply not the case at the moment. So look at Rule 29.102. Where a party intends to rely on hearsay evidence at the trial, and either that evidence is to be given by a witness giving oral evidence, or that evidence is contained in a witness statement of the person who has not been called to give oral evidence, that party will be deemed to give notice of such an intention by serving a witness statement on the other parties in accordance with the court's order. How can my learned friends say hearsay evidence is not admissible at trial when we have rules which prescribe the way in which hearsay evidence is to be provided? It's just madness. So what's the position for today? Paragraph 29.106. The duty to give notice of intention to rely on hearsay evidence does not apply, 1, to evidence at hearings other than trials. There's just nothing in the point. Hearsay evidence is admissible at trial. There are formalities for it, which, frankly, have never occupied the court's mind in any of the cases that I've done in these courts, or indeed in England. And they will be complied with. But at this hearing, there's no requirement for a hearsay notice at all. So for my own friends to boldly stand up and say hearsay evidence is not admissible is simply wrong. You did. But again, this is beside the point. there is no actual evidence of a master sale agreement. There is no actual evidence that its terms can contradict the sale and purchase agreements. There is strong evidence that nothing further exists. Nothing from Emirates. There's positive evidence that there's no master sales agreement for retail. There's nothing from Union Properties. They would be expected to have these documents, and they have an interest in showing that there was assignment. Nothing from the registrar. Nothing on the register. And the terms of the sale and purchase agreements are inconsistent and supersede anything that came before. And the draft that we've seen of the master sales agreement said if it's inconsistent with the SPAs, then the master sales agreement gives way. So, if the court is asking itself, what's the position going to be at trial? The answer is the same as it is today. The claimant is going to have no evidence whatsoever of an agreement to assign the lease. Instead, the court's going to have the contract by which the units were sold. And as I say, those contracts make clear it's not subject to the lease. It's not just that they don't mention the lease. Now, my learned friend points to payments made by the claimant to Union Properties before it sold the units to Emirates. And there was all this evidence and all this long explanation of payments and reconciliations. Those payments made by the claimant, it said, were received by Emirates. That's said to be indisputable proof that Emirates purchased an assignment of the lease from Union Properties. So it's evidence of some contract, my learned friend says. It's nothing of the sort. The schedules my learned friend relies on are reconciliations of the financial position between Emirates and Union Properties. So they're an accounting between Emirates and Union Properties and what was due between them. And at best, so this is the height of my learned friend's case, one can say that those documents and those reconciliations were prepared on an assumption that the lease was transferred. But that doesn't solve the problem, that in fact it wasn't transferred when you look at the actual sale documents. My learned friend also relies on documents which were recently disclosed, and in the skeleton he describes them as the most compelling piece of evidence of offer and acceptance. I tend to agree that my learned friend has no evidence which is more compelling, but this is not compelling evidence. What we see is a letter from Union Properties saying that there's been transfer of ownership of the land for tab 27, which should still be in the same. If we go to page 1123, it's a letter sent by Union Properties to Mr. Al-Khalili, notification new owner. This letter is to inform the lessee of the transfer of ownership of the above unit to Emirates NBD Properties. Union Properties will no longer be managing the unit. Your contractual interest has now passed from Union Properties to the above named company, and so on. And then they say deal with the new owner. And so my learned friend's point is that if you go back to page 1120, Ms. Fernandez sends this on to the claimant. And so again, the height of this is that the height of the case that emerges from this is that the assumption of both Union Properties and Ms. Fernandez at the time may have been, and I don't concede this, but I can see the argument being made, that they assumed that the effect of the transfer of the land was that the lease went with it. But that's as high as you can put it. It doesn't amount by itself to an agreement to assign a lease, and that's not even alleged. What happened was that people wrongly assumed that the lease went with the land automatically, and it doesn't do that. Union Properties does not say, we entered into a contract which assigned the lease. It doesn't say that in that letter. What it says is that there's been a transfer of ownership, and therefore your lease has been transferred. So, and interestingly, when challenged about this, we need to go to two more documents which I'm afraid are distributed around the bundles. If we look at Appeal Bundle 2, tab 29.
CUP letter.
Tab 29.
Yes.
Appeal Bundle 2. This is a letter from Union Properties sent in June 2015. So this is at a point when the claimant was having a go at Union Properties as well. And the response is, reference to your letter, the aforementioned subject, the tenant was recognised and we've entered into a 10-year lease agreement on the 1st of June 2011. However, within the lease period, Limestone House Retail was sold to Emirates MBD. During the transition, all documents and related documents were provided to Emirates related to the existing lease agreement and any other issues, which includes your lease units 35 and 96. Therefore, all the preceding transaction and communications should be addressed to Emirates, which is the new owner of Limestone House Retail. So clearly, so what they don't say is, we agreed that there would be an assignment. What they say is, the land was transferred, therefore, go and talk to Emirates. So the assumption is that the lease goes automatically. And so then later, when we go to Bundle 3, in fact this is earlier, if we look at the way that they were thinking about this, behind tab 20, 831 please.
Okay. Bundle 3 today hearing.
Yes, today's hearing, thank you.
On the page.
We go to page 831.
Yes. An email.
In the middle of the page, you've got an email from Mr. Ayman Akasha of Union Properties to the claimant, Dear Naki, in reference to our discussion yesterday, note that we are working internally to agree of how we will terminate your lease agreement due to the sale of Limestone to Emirates MBD. In the meantime, we appreciate your patience to resolve this and agree mutually on lease termination. So, at that stage at least, they seem to have given up. And Union Properties is thinking, well actually this is our problem. Now Mr. Claimant, please can you agree to terminate the lease? They don't say, we've agreed all this, we've agreed an assignment with Emirates. We've agreed that the lease should go with it. They've started on the assumption that it goes automatically. As a matter of law, that is simply wrong. But people have acted on that assumption, it appears, and that's the highest the case can be, in relation to agreeing what was owed us between Union Properties and Emirates. But that doesn't get around the express terms of the agreement. It doesn't magic up a master sales agreement which doesn't exist, and for which there's absolutely no evidence of its existence. That's all I was going to say about the assignment case. So the next argument that's made is that the lease was registered. Now this is about in-rem rights. And as I said, it's important to keep those distinct from in persona rights. This is about saying that there is an in-rem right owned by, or interest owned by the claimant in the land, and there was at material times. Now, it may be that there's some misunderstanding between the parties here, because my learned friend may, or at least appeared at one stage to be misconstruing that my case was on registration. It may be that I misconstrued his as well, but I accept this proposition. If there was an assignment, then it is at least arguable that Emirates is bound by the lease whether or not it was registered. So for the purposes of my application, I don't take the point that there's some technical defect there. I say there was no assignment for the reasons I've been through. But I had understood my learned friend's pleading to say that because the lease was registered in May 2012, it became binding on Emirates. And that does seem to be what my learned friend says in his amended particulars of claim. He's nodding, so I think that convinces his case. Not quite the way it was put in the skeleton, but it did seem to be put that way yesterday. But in any event, I say it's completely misguided. So for two reasons. Firstly, we can see today that the lease was never registered. But secondly, even if it wasn't registered, even if it was registered, it's not now registered, and it wasn't registered at the time that Emirates sold the property to Zain. And that's the second point. I'll come back to it. It's why it's important to keep the distinction between the in-room rights and the custodian rights. Registration doesn't create a contract; it creates an interest in land. Deregistration destroys that interest in land. There isn't somehow a contract left behind that binds a party. If at the time that an interest is registered, I sell the land to somebody else and thereby destroy that interest, then there may be an argument that I have somehow created a liability. But it's hard to see how that arises, because if it is registered at that time, then it just binds the incoming owner. So the point is that, and as I say, I'll develop it, it doesn't matter if there was a temporary period when the lease was registered, because it's no longer registered. It doesn't leave anything behind if it's removed from the register, if that is what happened. Now, my learned friend took you to a spreadsheet which was kept in the document kept by the registrar of real companies. And my learned friend accepts that no certificate of registration was ever issued in relation to the lease. And the real property registrar has explained what happened.
Again, sir, there's been no evidence called by my learned friend on this, and this is hearsay. It's not about notices, it's about reliability. Again, I'm making that objection. Thank you.
His evidence is admissible. I don't know how my learned friend can say the opposite. It's admissible evidence. At this stage, Your Honour is looking at what is the evidence likely to be at trial. This will be evidence at trial, if necessary, and if it could be possible, summoning the relevant person for the registry down to court might happen, I suppose. But if Your Honour has to decide what's the likely evidence, one has to see what the registrar has actually said about this in the past. It's the only way we can assess it. So if you turn, please, to Bundle 4, we'll see what the registrar says.
Bundle 4 tab?
It's behind tab 24, page 1002. Can I ask you, Honour, just to read this letter in full at some stage? Not at this point, but if I can just ask you, Honour, to take a note of that. I'll take you to the relevant section, which is at page 1004. So just starting with the paragraph that begins with regards to the registration of your client's lease. You've already explained in a meeting with yourselves that the lease was provisionally registered with the law prior to completion of the building. It was not possible to issue final legal title to units within a building until the building is complete, subdivided, and the strata survey is carried out, for the reasons that the exact dimensions of off-plan units will often not be identical to the finished units. Therefore, at the time of your client's provisional lease registration, a record would have been kept of its existence on the register against the unit numbers referred to in the lease. However, when the strata management plans were submitted and the unit numbers referred to in the lease had changed in the final plans, your client was contacted by the Registrar of Real Properties to explain that they would need to amend and re-register the lease against the correct final unit numbers shown in the strata management plan. Despite the submittal of a partially completed lease registration form attached in the name of the previous landlord, who would no longer have been authorised to sign the form in any event, they failed to complete the process. Therefore, please note that your client does not have a current registered lease on the real property register. Now, I won't go over my comments about admissibility. It's just not right to say it's not admissible. But in any event, it must be right. The units don't exist as distinct legal property until they are registered. We see that. We start with My Authorities Bundle, tab 2. Strata title law as it was at the time. It's just a short passage, Article 9.1. It's page 100 of the bundle. Real property, does you want to have that real property for which one or more folios of the register have been created under the real property law may be divided into lots or into lots in common property by registering a strata plan as provided in this part. So that's how you turn real property, which has a single folio, into lots and common property. And then if we go back to tab 1, Article 146.
Of real property law?
Yes, that's right. So we're in the real property law now, as it was.
Article 100?
146 on page 70. Is that right?
Yes. Subdivision?
Thank you. So subdivision approval before dealing with part of a lot. Subject to Article 147, the registrar must not register an instrument affecting part only of the lot unless the registrar is satisfied that in relation to the part, the relevant authority is certified that its requirements related to subdivision have been met, and the boundaries and dimensions of the part accord with the boundaries and dimensions shown in the plan to that part lodged with and approved by the registrar. So that appears to be the registrar's point. My own friend says this is a complex argument. It's not. It's just that the law says you can't register this until the plans are approved. And in effect, and the other point was, in relation to this, that there are other reasons why we might not have registered at that time. Obviously, one of those reasons was that the lease was inconsistent with the strata management statement, and therefore the strata plan, and therefore unlawful. That's one point. And then the other point is that the lease was provided by the wrong part between the wrong parties. So the owner, the current owner of the land, wasn't party to that lease. So when it came to rectifying the numbers on the units, it required the consent of Emirates, and they weren't willing to provide that consent. So when the registrar refers to provisional registration, he can't mean registration. A record was kept on the register. As my own friend concedes, there's no legal concept of provisional registration. What there is a system of caveats. I'll just show you that briefly. So that would ordinarily be the means of protecting your rights under an unregistered instrument. If we stay in the real property law, I just want to show you very briefly some aspects of it. In particular, if you go to Article 33(2), unregistered interests. So page 20, Article 33, you've seen this. Nothing in this law prevents an unregistered instrument from operating as a contract or being otherwise enforceable according to its terms. So it can, that's the point about assignment. Number two, though, the lodgement of an instrument in registrable form for registration has the same effect as the lodgement of a caveat protecting the interest claimed under that instrument. The benefit of paragraph 2 is lost if the instrument is withdrawn from registration. So it may be that what the registrar is saying is that it treated, by saying provisional registration, it treated it as in effect the caveat. That's the only thing it could have been. But then if we look at the effective caveats, if you go forward to page 60, and look at Article 120, what does the caveat do? The caveat prevents the registration of an instrument affecting the real property or interest in respect of which the caveat is lodged, to the extent stated in the caveat and from the time the caveat was lodged. Paragraph 1 has effect for a caveat until the caveat lapses or is withdrawn or cancelled. And then there's certain provisions about what isn't affected. So that's all that a caveat does. And when it's withdrawn or removed, you see the consequences on Article 128, withdrawal, lapsing, removal. It simply ceases to have effect. So the effect of a caveat is the effect either to prevent or make conditional the sale of property until, say, the new purchaser takes an assignment, or alternatively the purchaser buys with the risk that the party is going to make out their claim. It doesn't create an interest in land. Caveat is not an interest in land. So at best, what would have happened is that lodging the lease would have placed a restriction on the registration of any subsequent sale while it remained in place. So my learned friend is whispering at me, and he's saying, well, what happens if it was registered before the SMS? That point doesn't get off the ground, because the point of the scheme is that when you have a series of instruments that are being registered, that are being presented for registration, filed for registration, they are registered in the order that they are filed. So it just doesn't even begin to get anywhere. So that's the first point. The first point is that it wasn't registered. As I say, when it came to it in 2015, the registrar refused to register that lease for various reasons, could have raised other reasons. But for these purposes, it's not important what those other reasons might have been. It's simply important that it wasn't registered. But the next point is that on any, there is no registration now, and there was no registration when my client sold the property to Zane. So if there was some prior registration, it has been corrected on the register. And the effect of correction is dealt with by Article 149 of the Real Property Law. In subparagraph 2, it's on page 73, subparagraph 2 says, the register as corrected by the registrar has the same effect as if the error had not been made. Goodness sake. And I just remind Your Honour of Article 17 of this law, Article 25 of this law, which is on page 17, which says that the information about a registered instrument recorded in the register is conclusive evidence. So the point is this, that say that the document sounds wrong, my primary argument, and the document was in fact registered at some point, and that the effect of that is to vest an interest in the land, in the claimant. Deregistration simply divests them of that interest. It doesn't then exist. What it doesn't do is bring about some further personal relationship. It's just an in rem right. It doesn't create a contract. It doesn't create any kind of obligations on my client other than it binds future purchasers when they take possession, when they purchase the units. So Zane, if my learned friend was right, and the lease was registered, if Zane purchased the units at that time, then Zane would be bound by that interest, whatever it may be. But if it's not, once that interest has come off the register, Zane is not bound. My client's not in breach of any obligations in selling to Zane. And if something has gone wrong in that registration process, if it's been taken off the register when it shouldn't have been taken off the register, well, that is what the system of indemnification is for. That is the situation where you have to sue the registrar to get indemnified for your loss from the indemnity scheme. But again, rather like this master sales agreement, no, fine. The fact of registration, even if it occurred and said it didn't, doesn't create a contract. It's two completely different and distinct legal concepts. That's all I was going to say about registration. I was going to deal next with the argument about equity. So this starting point for this argument is therefore that there was no registration, or none about my client, or binding my client now, firstly, and secondly that there was no assignment, right? Because this is the third limb of my learned friend's argument. No contract between the claimant and the defendant. And this is the Article 31H point, and we have looked at the provision. Sorry, I put it away. I'll just remind you of the words of it for me.
Bundle 1?
Yeah, bundle 1 of the authorities. 31.
Tab 7?
Tab 1. Sorry, I will take you to bundle 1, tab 7, yes, in a moment, which is how it's put in the pleading. But 31H, which is the exception that my learned friend says it gets it, is a registered owner does not obtain the benefit of Article 30, so does not take free of unregistered interest in relation to the following interests or rights affecting the lot, an equitable obligation binding the registered owner as a result of the registered owner's conduct. Right. So, this is when we have to look at the pleaded case, which, as Your Honour says, is in bundle 1 for this hearing bundle, tab 7. As I say, we have to recall, it's been 18 months since the Court of Appeal hearing. Part of what was to happen next was that the claimant was to plead out its case. None of this depends on documents that my client might disclose. It's all about communications which were received and relied on detrimentally by the claimant. So what is the conduct that is relied on? It have to be, as I say, things that the claimant knows about. We go forward to page 194. You see how it is put, paragraph 62 to 63. Do you want to have that?
Yes.
The sale of the freehold interest in Limestone House by Union Properties to the first defendant was expressly subject to and made with notice of the leasehold interest of the claimant, who held the further lease in the same terms as if it had been registered under the real DIFC law of real property. So that's just the assignment case. The 63, the equitable obligation arises by operation of equitable estoppel, the doctrine of anticipation, and the rule in Walsh and Lonsdale, which apply irrespective of any registration pursuant to Article 31H of the DIFC real property law. And then it goes on about refusal of access. So there are really only 2 points made there. Firstly, the sale was expressly subject to the lease, so 62, expressly subject to, and secondly, and made with notice of the lease. That is all that is pleaded in support of the case for equitable estoppel. That is it. No particulars of the alleged estoppel are provided. I'll come on to the issue of estoppel in a moment. But what is being said here in the pleading is that there's an assignment, fine, we've been through that. If there's an assignment, you don't need estoppel. Alternatively, there's notice of the lease that creates the estoppel. But we've been through the authorities which show, and I think my learned friend ultimately accepts it, that something more than simply notice is required. You need conduct which isn't knowledge, which isn't just simply purchase. Taking you on to the authorities on that. But fundamentally, that is the basis of the real property law provisions and the Torrens system. So, just to look at what could amount to an estoppel in these circumstances. If we assume, for present purposes, that English law is effectively the guidance here for these purposes, one has to be very cautious, because a lot of the authorities that are relied on by my learned friend are based on English law. So the idea that there's a trust interest that is created by a specifically performable contract over land, they all need to be seen in the context of the feasibility of title principles that apply here and not in England. But in any event, let's look at the English position on estoppel. Assume that that applies. If Your Honour could have, again, my authorities bundle, tab 16 this time. What I've done is just provide the leading text on contracts. Your Honour will be familiar with this as an extract from Chitty. If we look at page, we'll come back to the first because they deal with certainty of terms, but for now, if Your Honour would go forward please to page 605. And it's paragraph 146, we're dealing with the main elements of proprietary estoppel. That's an estoppel which creates a proprietary interest in land. There are said to be three main elements. Does you want to have that?
Yes.
Representation made or assurance given to the claimant, reliance by the claimant on that representation or assurance, and detriment suffered by the claimant in consequence of such reliance. And then it goes into what those mean subsequently. Our concern in these paragraphs will be with situations in which the representation or assurance is one which amounts to a promise, or from which a promise can be inferred, but that promise is one which, for some reason, want of consideration, absence of contractual intention, failure to comply with formal requirements, lacks contractual force. There can be no proprietary estoppel, as the kind here under discussion, where the statement relied on was not a promise at all, for example, where that statement was contained in a letter which did not promise anything. So that's the first element, a representation, assurance which amounts to a promise. And then if you go forward please to page 611, we see the other main requirement, which is detrimental reliance. The other bit is unconscionability, but it has to flow from the detrimental reliance. And 4.158, the promisee, so that would have to be the claimant, must have relied on the promise or representation to his detriment. Although reliance and detriment may, in the abstract, be regarded as different concepts, and applying the principles of proprietary estoppel, they are often intertwined. So much so that they will here be treated as a single requirement. This requirement has been doubted, but in the absence of any such reliance, it's hard to see why failure to perform a gratuitous promise should be regarded as giving rise to any legal liability. So reliance is an essential element of estoppel generally. The element of detrimental reliance is necessary to satisfy the essential test of unconscionability, which is a necessary condition for the operation of proprietary estoppel in the existence of the requirements further supported by the rules as to the revocability of the promise. The detriment must be substantial, i.e. as much to make it unjust or inequitable, to allow the assurance to be disregarded. And the question whether it has this character is to be judged as at the moment when the person who has given the assurance seeks to go back on it. So that's the point. It's a promise which somebody relies on before it is taken back. So the classic case is where somebody says, yes, you can have a lease over this land, or I'll give you an interest in this land. But there's no interest is ever transferred, and it doesn't take effect at all. And so the person relying on that representation goes ahead, and they usually improve the land, so they will perhaps build a building on it. There are a lot of farming cases that deal with this sort of thing. So they build the farms, improve the land, and then the landowner comes back and says, well, actually, we never actually made that legally binding, so now you have to get off and leave everything behind. And so that's the sort of situation. One is looking for the period between when they first say you can have the land and when they eventually say you can't have the land. And you have to find within that period detrimental reliance, which is so substantial that it means you can't take that promise back. And as we've seen from the pleading, that's effectively the structure of all the estoppels, but proprietary estoppel is just simply spelled out in these terms. So, as we've seen from the pleadings, there's simply nothing like that whatsoever. So my primary position is my learned friend ought to be stuck with his pleadings. 18 months after he said he was going to plead out an estoppel case, 6 months after he re-amended the proposed pleading and came to this court. That is the way he puts his case. He does make a stab at it in his skeleton argument, and the stab starts at paragraph 60 of his skeleton argument, and it's worth looking at this. So dealing with the second cause of action, proceeds on the assumption that there's been no assignment. So, paragraph 60, assuming Mr. Hadi Brocklehurst is correct, and for some reason which is not identified, the contractual assignment did not take place, or the registration was not perfected, the registrar wrongly removed the lease from the register, or failed to notice on the title, that will not release Emirates from the obligations of the lease. It makes no difference because those circumstances invite equity to intervene, and that is why the new cause of action was introduced on reading Mr. Hadi Brocklehurst's evidence. So there's no positive case there made as to how this equitable obligation arises. And indeed, it's drafted on the assumption that there is a lease, because it says it won't release Emirates from the obligations of the lease. The question is whether Emirates ever became bound to the lease, or whether there was some other proprietary interest by which my client could be bound. So there's no positive case in 60, as far as I can see it. And then it's 61 to 65. My learned friend refers to some principles of some cases in English law. Now, to the extent that those principles say, well, it's possible to create an interest in land by estoppel, I agree that that's at least arguable for the purposes of today. But to the extent that they go further, then they don't apply in the DIFC, because if and so far they're applying the English approach, which is that you're bound by knowledge of a prior interest, then they're simply relevant to the reasons that I've explained. But really, the whole case on estoppel appears in paragraph 66. This is really how it's put. This isn't even included. This is how it's put in the skeleton argument. This case, where the landlord, on any reasonable view of the facts, willingly contracted to take assignment of the lease, not just accepted but demanded their share of the rent and the entire security deposit, raises just such an estoppel which prevents it from changing its mind later and attempting reliance on the legal position regarding the lease. So just taking that in stages, firstly, my learned friend falls back on the assignment point, so he says willingly contracted to take the assignment of the lease. That's a different point, that's about assignment. There was no assignment, I've shown you on that, but in this separate argument, it only arises if there's no assignment. So secondly, it said, well, they accepted and demanded their share of the rent. Well, I'll come on to that in a moment, but no case for estoppel, for reliance, detrimental reliance, is advanced at all. There's no attempt to analyse how the estoppel arises. And there's simply no allegation. There's no case to answer. Now, the demand, which is said for their share of the rent, isn't explained. What is that demand? Presumably that's, at least at this stage, was going to be the representation. It needs to be a communication from my client to the claimant. So what is the demand? It can't be some form of accounting between Union Properties and my client. That's not a representation which reaches the claimant. So that can't be part of this estoppel case. So the closest he gets is the presentation of cheques, which happened, I believe, in August 2012. But if one looks at my learned friend's skeleton argument, go back to paragraph 54. Later, and with full knowledge that the cheques were on hold and to be replaced, the first defendant, and no doubt knowing that the bank account was dormant, banked the cheques which were returned and in bad faith attempted to use the event to cancel the lease, rather it affirmed. So what my client's saying there is that the cheques which were banked in August 2012, and I take that from the chronology, calling on the checks was actually an attempt to cancel the lease, not a representation that there was a lease, not a representation that there was an interest, a valid interest in land. My own friend can't now, we said that, turn around and say, well, the banking of the checks was received as an indication that Emirates was happy to proceed with the lease. It just can't work, given that it was understood by the claimant, rightly or wrongly, as being a bad faith attempt to get them out of the property. And anyway, by November 2012, so if that happens in August, then we've got, by November 2012, they are clearly saying the units have been released. The reference to that, my reference, I'm afraid, is to the witness statement extract from that. It's on Bundle 2, tab 20, page 335. Sorry, it'll be tab 2, tab 19, 335. So you see, this is just a recital of an email from Mr. Al-Khalili.
Bundle 2?
To, yes please, tab 19.
Tab 19, okay.
Page 335.
Yes.
As you see there, there's a recital of an email from Mr. Al-Khalili
To Melanie.
to Melanie Fernandez. I'd like to thank you, do you see that? I'd like to thank you for the time during our meeting on Thursday the 29th of November. Very surprised to learn what I did during this meeting concerning the situation of our retail space at Limestone House. Extremely disappointed that the cheques were submitted. And then, if you look at the final underlying section of that, also you mentioned during our meeting that our premises has most likely been released or sold to a third party. Therefore, can you please clarify the current status of the units? So the dispute, so even if my own friend could say presenting the cheques was the representation, he needs to show some reliance between August 2012 and at the very latest, end of November 2012, which makes it unconscionable for my client to withdraw. And I'm tilting windmills to an extent because none of this is pleaded. There's no prospect of any case on reliance, and none is in fact made. Now, during oral submissions, one stage yesterday, if we keep Bundle 2 open, I've got something else to show you, I'm afraid, on this. At one stage, my learned friend said the reliance was the payments made by the claimant. They relied on the representation by making payments. And at another stage, my learned friend said they spent money in setting things up, and if you're recalls that. So when he was talking about estoppel, representation, reliance, unconscionable to withdraw, on the reliance phase, he said payments, and I took a note of this, and he said they spent money setting it up. If we stay in the same bundle, we go to tab 20, and we go to page 384. 384. This is the evidence of payments made of setting of expenses in setting things up. I mean, one reads this email, and then one sees the absurdity of my learned friend's complaint about hearsay evidence. This is all hearsay evidence. This is relied on by him for the truth of its contents. This is the evidence of the payments that were made. And this is an email sent in May 2011. So you can't rely on a representation made in August 2012, or in May 2012, or whenever it may be, by taking steps in May 2011. And don't forget, by the time any of this happened, my learned friend said another time, so we've been looking at the skeleton argument as to what was the representation. It says nothing about reliance. We've been here, I've explaining what my learned friend said about reliance yesterday. It doesn't make any sense, because all of the reliance, payment of rent, payment and setup costs, all occurred before my client bought the property. So, and one mustn't, and another time my friend said, well, the representation was in signing the lease registration form. You want to recall that happened in May 2012. And don't forget that by then, the lease had been put on hold. So there's no case for reliance that could come after, that does, I mean, it could come after May 2012, or any of the events that my own friend has indicated, but not pleaded, that might make out a case for estoppel. So, where we are today, and that's where how this application needs to be judged, is that on the evidence there clearly was no assignment. The lease was never registered, but even if it was, it's undisputable that was reversed and there's nothing left behind. If the claimant has a problem with that, if there was something wrong with that, they should take it up with the registrar. And the claimant is, in any event, completely unable to make out or even plead a case for estoppel. So the consequence of all of that is that there just is no case by which it could be said that Emirates was bound to the lease. So that's all I wanted to say on my own friend's case. Now I wanted to move on and deal with the defences. Should I do that now, or is now a good time to break?
No, still we have half an hour.
I don't think I'll quite finish before lunch, but I'm on schedule, if I can put it like that. So the defences which I advance, not the only defences I advance, but the defences that I say you could decide today, a complete answer to the claim. So we have to proceed on the basis that my client is bound, or would otherwise be bound by the lease, by an assignment or some other mechanism, right? And so what I say is that these defences that I'm going to deal with, they emerge from two features of the case. The first is the amendment of the lease in March 2012, and the second is this fact, which appears to be accepted, that the use which the lease permitted and which it required, which is as a bar and restaurant, was prohibited, and still is prohibited. So let's start with the amendment itself. If we go to bundle 2, if your still has that open, the letter is at page 490, which is towards the end of that bundle, behind tab 20, 490.
Yes.
All right.
It's 15 March, huh?
Correct, 15th of March. So this is an agreement between Union Properties and the claimant about the lease. And the lease is said to have been amended by this, and that's the case that I'm meeting. So it says, following the last meeting held between us, due to selling and changing the ownership of units LP5 to LP6 retail shops in Limestone House, both parties agreed for the following. 1. Since VEGIE Bar was the first retail operator to approach and sign a lease agreement to lease retail space in Limestone House from almost 3 years back, 2 contracts earlier signed and cancelled, which we've seen 1, it seems, prior to the existing one. VEGIE Bar interior fit-out to be postponed again until progress and development is achieved with the commercial spaces available in Limestone building, since Union Properties did not fully lease and develop the retail area in this building. Number 2. All checks issued by VEGIE Bar in favour of Union Properties are to be either put on hold and replaced when the progress of leasing the rest of the commercial units is achieved. 3. Lease commencement date and rent commencement date to be adjusted and revised towards a new date once the progress of the occupancy is achieved. However, all other terms and conditions of the agreement remain the same. And then they deal with, they say it's agreed that the penalty for the previous cheque, which had been returned unpaid by the bank, shall be paid accordingly as per the penalty rates imposed by Union Properties, while all future checks will be put on hold due to the non-clarity of the leasing progress of Limestone House retail leasing. So this is pleaded out pretty much in those terms. So if we look at the pleadings behind tab 7, page 189, and it's pleaded out pretty much as set out in paragraph 189, page 28.
Which paragraph?
28 on page 189. So,
Yes.
so those are effectively the terms, and in particular C, which is the one that I draw your attention to, the further lease commencement date and rent commencement date, was to be adjusted and revised towards a new date once progress of occupancy of the commercial units in Limestone House was achieved. And so then there was over the page then, as we've seen in paragraph 31, what appeared to be an attempt to define what progress would mean, 60% of the occupancy of the surrounding units. And actually that was pleaded as part of the amended terms of the contract. You see that? 632A. So I was a bit surprised by my own friend's evidence and skeleton when they said, oh well, we've never said this. They did say it, but anyway, they appear to now to abandon it. I may not have to trouble you with it in those circumstances, but we will look at that because it's instructive, because it's an attempt to salvage what would otherwise be an inherently uncertain term in any event as to when the commencement date arises. And even that, I'd say, would be uncertain. I'll come on to that in a minute. What my learned friend also says, and we heard it yesterday, is that that is a condition that the claimant can waive. And my position is, and I'll deal with that as well. So my position is that on the face of that amendment, the lease became either void, became void for uncertainty. So I do say there's nothing in the agreement which we see about a 60% occupancy. And we will...
Except Fernandez email, which at the beginning she mentioned that 60%.
Yes. So
she sent the email to Ali Ketbi.
Yeah, correct, exactly. That's an internal email. We don't know what the provenance of that is. There's no documentation. But that's a... Well, my own friend says he doesn't rely on that. In fact, he disclaims it and says his client's no party to that. So that's why I say you probably don't need to trouble you with whether or not that actually became part of this agreement. But what I say is we should look at it, because imagine that was the contract. Even that wouldn't mean that there was any way to find out when this lease actually reactivates. So I'll come on to that. But I say it is uncertain, whatever the form it's in, or in effect, just put it in effectively the same way. It amounts to an agreement to put the lease on hold indefinitely. Let me show you then briefly what Chitty says about certainty. If your Honour has my authorities bundle and goes back to tab 16, page 602.
Yes, tab 16.
16 is the first page, yes. Your Honour. So the requirement of certainty. An agreement may lack contractual force because it is so vague or uncertain that no definite meaning can be given to it without adding further terms. And there's some examples. For example, Scammell. The House of Lords held that an agreement to acquire goods on hire purchase was too vague to be enforced, and so were many kinds of hire purchase agreement in widely different terms, so that it was impossible to specify the terms on which the parties had agreed. In Blue and Ashley, the court denied the existence of an enforceable contract because, inter alia, the agreement alleged to pay £15 million. The alleged agreement to pay £15 million if the claimant raised the company's share price to £8 failed to stipulate the period for achieving this. There was no objective standard the court could invoke to imply that the obligation would be performed within a reasonable period. That was the famous case of Mike Ashley, the owner of Newcastle Football Club, and a late evening in a pub. you may have heard about it in the news. In any event, in kiting revenue and customs and commissioners, the alleged contract was held to be insufficiently precise to be a binding settlement of the claimant's tax liabilities, given that the claimant's tax liabilities were plainly complex. The claimant sought a settlement deed, and the reference to the claimant's tax affairs being brought up to date far too general to be of assistance. Similar reasoning may be applied where the agreement is expressed to be subject to a condition that depends on the satisfaction of one of the parties. The problems arising from such provisions are discussed in 2164 below. And just draw your attention, rather than going into the case, just to show you the footnote 829 below, which says ANSI landmark brickwork and Sutcliffe, where a covenant in a contract of employment restricting competition in two named counties, and in others, quotes, to the south of them, was too uncertain to be performed. So if we look at what is left of this contract after this amendment, which my learned friend himself alleges exists, the question is it possible to determine what the commencement date is? So what event triggers the start of the lease? I'll come back to the waiver point afterwards, but that's the first and fundamental point. Because what the clause, what the commencement date is changed to is a commencement date, quotes, to be adjusted and revised towards a new date once progress of the occupancy is achieved. So there are 2 points there. And so the first point is there's this issue of what is progress. There is no objective standard by which progress can be assessed. When is that going to be satisfied? And that's why it's interesting that the pleading, as it still is to the effect that 60% occupancy would satisfy that test. That's the effect of the pleading. So what's happened there is the claimant's trying to plug this gap, this uncertainty gap, let's say, with that 60% figure, which they now abandon. But even then, what is surrounding? We saw in the landmark property case that to the south, so counties to the south, what was too uncertain. There's just too many different answers to that question. What was to the south? So what is surrounding? Is it one unit? Can't be one unit either side, because you're talking about 60% occupancy. Can't therefore be 2 units. What counts as the surrounding units? It's not possible to determine that. And here, we're in even more vague territory than that, because we simply have progress. What would amount to progress? It's not said. It's not even reasonable progress, not even good progress, just progress. Even then, there's another problem. So imagine that we could work out what progress meant. What the clause actually says is not that once progress is achieved, the lease will commence. It says once progress is achieved, the parties will revise and adjust the commencement date. So the progress doesn't trigger the commencement date, it triggers a discussion between the parties as to when the new commencement date should be. So even if you could know what progress meant, you still can't work out, there's nothing objective there to say when the start date would arise. Now, my learned friend says in his skeleton argument that the agreement was only to place the lease on hold for a short period of time. And that's presumably based on Mr. Naki's evidence. Mr. Naki gives subjective evidence about what was meant by this. I'm sorry, I'm being interrupted again. Either way, this evidence is irrelevant. What we have to deal with is the pleaded case as to the terms that are set out quite clearly in the pleading. So what my learned friend thinks of that, what Mr. Al-Khalili, Mr. Naki Al-Khalili thinks of that, is completely irrelevant. And anyway, they have absolutely nothing to do with the written terms, the written record of what was agreed, the pleaded case of what was agreed. The terms were not, the commencement date is deferred for a short time. We know what the commencement terms were, and even a short time would be totally vague and uncertain. Now, ultimately, this is a question of construction. What was meant by the terms of this amendment? My learned friend says, well, And courts are very reluctant to impose a construction which renders terms uncertain. And that's right, Your Honour. That's right. So courts can be quite reluctant to impose an interpretation which renders terms uncertain. But the doctrine exists, and I've shown you reference to two cases, the Ashley and the Landmark case, which are modern cases decided quite recently, which apply this doctrine. And one has to think about the policy reasons why. And the reasons why courts are reluctant to make contracts uncertain is because, generally speaking, when parties enter into agreements, they intend them to have some contractual effect. And so if you and I enter into an agreement, it would be surprising if we found out later that there was no way to make that work because it just was too vague. So that's the starting point for a lot of those discussions in courts. This is a completely different situation because the parties agree that what was happening was that Union Properties and McLean were agreeing to put the lease on hold. The only question is one of construction. Were they agreeing to put the lease on hold, as my learned friend says, for a short time? Or were they agreeing to put the lease on hold to a date in the future, which is in effect indefinite, which in effect can't be ascertained? So the intention has legal consequences, which is to put the lease on hold. The question then is, can this court... So the court gives legal effect to that intention, but the question is, can this court then fix on a date when that lease or an event which will happen, which will cause that lease to become reactivated? If my learned friend's right, then a short time, what is that? Who knows? We're 7 years after this, or 8 years now, I think. So, no, seven, sorry. So it's March 2012, May 2019. So that's obviously longer than a short time, but presumably the short time arose at some point in the past. It's not what the pleaded case is, but we'll have to decide when that was. But that's not what the agreement says. The alternative, and there's no real answer to this in my submission, is that you just can't determine when that date or how that date will be triggered because of those two fundamental problems with it. So what the effect does is that the agreement has contractual force, but the effect of setting a commencement date in those terms is that you don't have an agreement that can actually be enforced. So now, Ms. Akinlele may have expected that within a short period of time the parties would have agreed to reactivate the lease. But that's his personal subjective understanding, and it's got nothing to do with contractual intention or the terms that were actually agreed. And even if, as I say, that was a term that would be too uncertain. My learned friend has a number of other responses to this, and I picked them up from his skeleton argument to begin with and what he said yesterday. If he turns to paragraph 20. There it is. Page 20, sorry. So, these are the reasons which are given in response to this point. So, the first argument is this, and this is in the pleading. It says if this agreement was intended to benefit the tenant could waive the condition at any time, which it did by asking for possession in November 2012. So it's now being said, well, the lease started in November 2012. Fine. So the question is this an agreement that's capable of simply being waived unilaterally by one of the parties? And the answer is obviously no. In order to be capable of being waived, a term has to be a condition which is for the sole advantage of one of the parties. Just looking very briefly at some law on this, we can see it at tab 16 of my authorities again.
going back to the basics, shitting. Go forward to page 617, please. So where the terms of the contract include a provision which has been inserted solely for the benefit of one party, he may, without the assent of the other party, waive compliance with that provision and enforce the contract as if the provision had been omitted. He will not be permitted to do so where the provision has been inserted for the benefit of both parties or there is in reality no concluded agreement. I mean, there are a whole range of answers to this point. It's misconceived. My case is not the lease hasn't started because the condition hasn't arisen. My case is that as a result of the agreement, one can't actually determine when the lease starts. The second point is that this isn't a condition at all, which imposes any kind of obligation on my part, on my client. It's simply an amendment. It's an amendment to when the commencement date arises. You can't just waive an amendment. Can you waive the term which is amended? Well, obviously not, because the term which is amended states when the lease commences. It's not a condition which imposes an obligation unilaterally on one party. You can't waive the start date of a lease, because then you don't have a start date at all. The lease doesn't start. And anyway, it's obviously not to the sole benefit of the claimant. So if the parties agree to put the lease on hold, they do so with benefits to both of them. The claimant needn't pay the rent, the defendant needn't carry on with the fit out, and fundamentally, it needn't make the premises available to the claimant. That's the bargain. The whole bargain is suspended. It's ridiculous to say that the suspension of the bargain is entirely in one party's favour or not. The value of the suspension of the bargain is precisely the corollary of the value of the bargain in the first place. It's not a one-sided bargain. The second point that's raised, and this is B in the skeleton argument, is if the condition is intended to benefit the landlord cannot unfairly take advantage of the situation by failing to lease the surrounding premises. And then my learned friend refers to the case of Rother, for the basic principle which says, 96, on the basis of the foregoing discussion, it seems clear, based on the underlying principle that a person is not permitted to take advantage of his own wrong, the contractual party who is in breach of an obligation owed to the other party will be prevented from asserting rights or claiming benefits which arise in consequence of his breach. So, again, this is completely misconceived. I don't rely on the fact that the surrounding area is not leased. I'm saying the agreement is void for uncertainty. It's a conceptually different question. I'm not asserting that the lease hasn't started yet for these purposes as a result of a failure to impose a condition. The agreement simply puts the lease on hold indefinitely. And anyway, this argument could only work if my client was under a relevant obligation. So presumably an obligation to rent out the surrounding area. But there's no obligation on my client to do that. None's even alleged. And there's none in the letter. So it's like saying, two business people say, well, I've started a business, I want you to come into my business, but now's not the right time. We'll go into business later once my turnover improves, and it's worth you coming into business with me. It's a similar situation to that. Unless I agree to impose on myself an obligation to enter into business, to increase my business, then you can't come to me later and say, well, hang on, you were supposed to improve your turnover. So now we have to go into business together. And anyway, even if that was the obligation, this is the point about it being misconceived, it's completely uncertain. It's rather like the Bloom and Ashley case. There's no objective standard by which to determine what amounts to progress, and how that's going to be achieved and how that will be met. And that's the fundamental point. This doesn't meet it. The next point again, it's just completely misconceived in paragraph C. The next point is that by banking the cheques in November 2012, Emirates affirmed the contract. That's got nothing, the principles of affirmation are just completely irrelevant here. Affirmation is about authority. It's about a principal taking responsibility for the acts of an agent. So if an agent does something unauthorised, the principal can affirm. It's sometimes also used in relation to contract. If there's a breach of contract, which gives one party the right to terminate the contract, they can affirm the contract and carry on. But none of that has anything to do with the uncertainty of contractual terms. The point about uncertainty is that at the moment of contracting, there is no contract. Nothing to affirm in the contractual sense. It's an entirely different principle. It's got nothing to do with this. And finally, at D, it said, well, the final point is that any such condition can be easily severed. The court has a duty to cure uncertainty. There's simply no support for that. The court has a duty to interpret the contracts and understand objectively what the parties' intentions are from them. It's right that the court will allow for some precision in business practice and will build in flexibility. And it's right that the court will reject unmeritorious pleas of uncertainty. That submission pulls itself up by its own bootstraps. This is not an unmeritorious plea of uncertainty. We're not, as I say, in the normal position where somebody's saying, well, parties have entered into a detailed commercial arrangement, but some part of that arrangement has become, it just can't be worked through, and therefore the whole thing falls down. The parties have, on my 11 friend's own pleading, agreed to put the lease on hold, and everybody agrees that it had that legal effect. The only question is whether or not, as on true construction of what was agreed and what's alleged to have been agreed, it is possible for the court to ascertain when that suspension comes to an end. If it can't, if those terms just don't allow for an objective interpretation, then the result is that the lease is on hold indefinitely, and the legal consequence of that is that it fails for uncertainty. You can't just sever a condition in a lease because you don't like it. You can't just take it out. Anyway, imagine what happened if you did take the commencement date out of the lease. Again, you wouldn't have a commencement date. You still have this problem. So that's what I want to say about the amendment of the lease and uncertainty. I do need to deal, and I'll do it relatively briefly, with the position on unlawfulness. That's the only other part of my application. I was going to say something very brief, but it will be brief about disclosure as well. Depending on any questions from Your Honour, I would expect to be finished in about 40 minutes at the outset, at the point.
So then we'll pause and we resume at 2.
Great, thank you.
Thank you.
All rise.
Yeah, please go.
Your Honour, I was about to turn to the second line of defence that I say there's no answer to in this case, and that is the position that the lease, even if it could otherwise have found my client, was void for illegality, or alternatively could be brought to an end as a result of the fact that the use required and permitted of the units as a bar and restaurant is prohibited by the terms of the strata management statement. And as a result of that, its use is prohibited by law, and that's both before and after the lease was amended. So that emerges from I don't need to, and I'm grateful to my own friend for his assistance there, I don't need to show you, it seems to me, the terms of the lease. So the lease it both permitted and required use as a bar and restaurant. What I do need to show you is and I don't think I need to show you the strata management statement. My own friend pleads the relevant parts of that out.
Okay.
It's not a permitted use to use something as a bar and restaurant. what I do need to show you very briefly is the strata titled law, which is in my authorities, tab 2. Will see on page 100 of the bundle 3 of the law, yes. Article 9. You've already looked at Article 9.1. But if you want to look at Article 9.6, we see where a strata plan shows expressly or by necessary implication the use for which a lot is designated, the registered owner must not use the lot for another use or permit it to be so used. And then if we go forward to Article 135, we see in effect the same. Under the heading Part 10 Miscellaneous, it's on page 170 of this bundle, page 73 of the document. The owner or occupier, so this is an obligation on both, of a lot established by a scheme under this law must not use the lot or permit its use, A, for a purpose other than a purpose for which the lot is established as indicated in the relevant registered plan or scheme, or B, contrary to a restriction indicated in the relevant registered plan or scheme. Now, so the position as it has always existed, at least since registration of the strata management statement, is that these units could not be used as bar and restaurants. If we go back to Article 24, we can see how you would go about amending a strata management statement or a strata management plan. So under the heading, if you see on the previous page, Chapter 6, Amendment of the Strata Plan. And then it says, Article 23, a strata plan may be amended by registration of an amendment under this chapter. And then the procedure for that is set out in Article 24. And you see an application for an amendment may be made for an application for registration of an amendment to a strata plan may be made if the body corporate is authorised by special resolution to make the application by the body corporate, or jointly by the owners of the lots that are affected. So that's the basic position. If we look at the pleading now, as to my learned friend's proposed casings, we go to Bundle 1, Tab 7, page 177. In fact, let's do it in the re-amended version. If we go to page 191, please, so we're looking at the same version of the draft. There are two drafts, one with markup and one without. So my learned friend pleads out, if we start at 42, he says, on the 24th of May 2011, AUH, they were then the owners of the Ritz-Carlton, acting on behalf of La Crane Group, agreed with Union Properties that the claimant could operate a bar and restaurant in the leased units. So he's asserting, and there's an email which he relies on to that effect. The SMS was lodged and registered after 24 May 2011, the date on which Union Properties and AUH, acting on behalf of La Crane Group, agreed that the claimant could operate the leased units as a restaurant and bar. The SMS at 33JJ Little Roman 2 and 33KK purported to prohibit the use of the leased units as a bar and restaurant. So that's his acceptance, that's what it says. But this is his case on it, paragraph 45. The SMS, at those provisions which prohibit the use, is to be read subject to the prior agreement between Union Properties and Mr. Munib, dated 24 May 2011, allowing the claimant to operate in the leased units. It's not the sum of his case now, because he makes other points in the skeleton argument, but that's his pleaded case. And as we know, it doesn't work, because we're not dealing with a private contract here, which can be amended by agreement between some of the parties to the document. And in fact, on registration, it creates a higher corporate body, which then becomes itself bound. So this is then registered, and it takes effect, and the law, as we've seen, explains the way in which a strata management statement, strata management scheme can be amended, and it's not amended unless an amendment is registered. So the case that's pleaded doesn't work, because the case is that there's some private agreement between relevant parties, but that can't work. The SMS isn't amended until both an application is made to amend it and that amendment is registered. So that's the case that's pleaded. So then we have the skeleton argument. And if your Honour has that, you could pick it up. Turn please to page 18.
Yes.
So paragraph 77 is where my learned friend deals with these points. He says, the SMS regarding the ability to operate food and beverage outlets point fails on the evidence and at law, and in the event it cannot prevent judgment on liability as the SMS does not affect the enforceability of the contract, but goes to the performance of the contract. I'll come back to that in a moment, but the point there is that, I mean, that's just an incoherent submission on law. But if a contract is illegal in its, or unlawful in its performance, then it is void. You can't say, oh well, it's only when we get to performance of the contract that it becomes illegal. Point is, if the performance of the contract is illegal, then it is void. And I'll come on to that in a minute. But let's start with the propositions that are advanced. A, the evidence is that UP, on the 2nd of May 2011, initially attempted to cancel the lease based upon an agreement with NCTH and AUH, the managers and owners of the Ritz-Carlton, regarding food and beverage. This was forcefully rebuffed by the claimant, and that rebuttal was accepted by Union Properties and AUH, who were parties to the SMS. The reference there, paragraph footnote 53, is to the 2011 documents. That's the email, which is at, we don't necessarily need to go to it, but it's bundled to tab 2387.
That's before me, the reference.
Yeah, you've been So you've been shown that document. That's the email from Mr. Muhairi, ostensibly from NCTH. My own friend says it's on behalf of AUH. Doesn't much matter. This is the point that's pleaded. That email somehow amends the SMS. It can't, as a matter of law. So that point just falls there. The next part is not only were Emirates aware of the agreement that VEGIE Bar could operate as a bar and restaurant, but later they sought to create the same exception to the SMS for themselves. I mean, I just can't see how this affects the question of whether or not the lease was void because the activities under it were unlawful. It can't. EMBD's awareness of it is completely irrelevant to the question of whether the performance of the contract is illegal. But actually, this point rather reinforces my case, because what's being said is that my clients actually tried to get an exception to the SMS to permit certain uses, and they were not able to do so. So it's not within my client's power to amend the SMS. So in a private claim against my client cannot be blamed for the fact that the SMS can't be changed. This simply reinforces that point. You don't need to decide it for the purposes of this issue. But if Your Honour sees what I'm saying, if one thinks about who's really at fault here, what happens is Union Properties, according to my learned friend's case, AUH, Union Properties enter into the lease. AUH says, fine, you can have that lease as an exception. Nevertheless, a few days later, Union Properties and AUH sign up to a strata management statement which excludes use as a restaurant bar. And they then file a lodge that and enter into a contract with my clients which says that we have to respect the document, even before it's been registered and even if it's changed. So and my client can't get that changed, just has no capacity to do that. So if one's looking for the merits of the situation, who's at fault? Why has the situation arisen? It's arisen for two reasons. One is because the lease was never actually, no caveat was entered on the title before my client took possession. Secondly, ultimately, UP failed to take into account the claimant's interest when entering into the agreement with my client. But primarily, when UP signed off on the strata management statement, they did so in a way which made the lease unworkable. And from that point onwards, it became impossible to perform. And then the final point, C here, is the next point in my learned friend's argument. In view of the earlier capitulation by Union Properties and AUH, Emirates must be stopped from raising it now. And then I'll come on to the next bit, but this is a stopper. So the argument is that somehow my client is stopped by statements made by third parties. It's just, again, it's legally incoherent. The estoppel is personal to the party that makes the statement. That's the first point. That, if you need authority for it, can be found in my learned friend's own authority. I'll give you the reference, a case called Lancaster. It's Claims Authorities tab 4, paragraph 30. Emirates can't be stopped as a result of the actions of others for whom it's not responsible. This is a primary point about estoppel. But the second point is this. Estoppel is about binding parties to private agreements when the contract fails. So say there's no consideration for some technical problem, say with registration, means it doesn't take effect. If the problem is with illegality of the contract, then it just comes back to saying that my client has effectively agreed in a way that's binding to carry out a contract which is illegal. Well, that's void. It's still void for illegality. Estoppel is about whether I'm bound to the contract. Illegality is whether or not the contract can be enforced. They're two completely distinct concepts. And then the final point which it says is that my friend goes on to say, and he says this in the outset of this paragraph, it says, in any event, all that this actually means in practical terms is that an order may be required to amend the SMS to accept the VEGIE bar lease. Zain is part of the Crane AUH Tetra Zain group. And it's this point about enforceability. So he needs an order. These are in personam inter partes proceedings brought by the claimant against the defendant. So he can't order, this court can't order my client to amend the SMS. It can't order a party to do something it's not capable of doing. So in these proceedings, it can't order my client to amend the SMS. It can't order Zain to amend the SMS. Zain's one of the owners of the property. Only the owners together, joint owners, so that would include AUH. So we're talking about a claim now, apparently, against the owners. I assume AUH is still the owners of the Ritz-Carlton. So it would be a set of proceedings against the Ritz-Carlton owners and against Limestone House owners, all of them, to either make a joint application to amend the SMS, or alternatively to call a meeting in which they vote on amendment to the SMS and then direct the higher body corporate of the combined lot to make an application to amend the SMS. So that is a set of proceedings that nobody's ever started. My learned friend says, well, at some stage there may be all these other proceedings. I think he said we may approach DIFCA, we may go to the Registrar of Companies, we will go against Zain, and all the rest of it. But where are they? Firstly, where are these claims? We're now 3 years into this litigation. My learned friend is saying, oh, now actually, this issue will be resolved by some future litigation, which has never been commenced. There's no evidence has ever been intimated. No evidence any attempts have been made actually to get some sort of amendment in that way to the SMS. But the second point, and this is really cuts through all of that, is that the effect of the SMS and the strata title law is that the lease is now, the performance of the lease is now and has always been unlawful. And it's what's known as supervening illegality. Say it wasn't unlawful at the beginning, all right? So there's no problem with the lease until the SMS is registered. Once that is registered, then it becomes unlawful. That is supervening illegality, and the usual legal mechanism by which that is brought to bear on a contract is by frustration. It's a bit like where you have a contract which is perfectly lawful between two parties, and historically this emerged quite a lot in, say, the Second World War. As a result of the war, the contract became illegal to perform because of sanctions imposed as a result of the war. So it's that, and it's not, you don't have to show that the war's going to go on forever, or the war will never come to an end. The question is whether or not that intervening illegality causes the contracts to come to an end. Let me show you the the relevant provision part of the Defence Authority Rules. I'm being talked at again, and I really do think this to stop.
I was inviting my learned friend to show you some relevant pleadings. He likes pleadings. I think this may be one.
Thank you. Tab 16.
Of the Defence Authorities, yes, please. Okay, so my learned friend says there's no pleading as to this. Now, clearly, this application, if my learned friend's entitled, say my learned friend's entitled to amend his pleadings, I would then be entitled to put forward my defence to this claim. So the draft pleading and the case that I would advance in response to the claim that's going to be put forward is set out in a draft pleading, which was served with Mr. Fanny Brocklehurst's evidence. That is the normal way in which one would respond to an application for immediate judgment, or make an application for immediate judgment. As Your Honour will know, an application for immediate judgment can be made even before a defence is put in, if you're confident that the claim can't succeed at law. The point of putting in a draft defence in those circumstances is to give the other party notice of the points that are going to be raised on an application of this sort. So if my friend wants to pursue this point, I'll take the wind out of the sails, because if Your Honour has still for you the bundle 1 from the hearing, if Your Honour turns forward to tab 50, turn please to page 257. 257.
Yes.
You see paragraph 56, Your Honour. For the reasons set out above, the further lease purports to permit and require the claimant to use retail premises within Limestone House as a bar and restaurant, an activity which is prohibited by the terms of the SMS and the Strata Title Law. As a result, 1. The further lease is void, alternatively unenforceable, as purporting to require and permit an unlawful activity. So paragraph 2, the further lease was frustrated by the agreement, execution and or filing of the SMS, alternatively by its registration. Alternative 3, the claimant is unable to comply with its obligations under the further lease to use such premises as a bar and restaurant, including clauses 2.7, 3.41 and 3.42 thereof. Accordingly, the claimant is an anticipatory breach of the further lease, and Emirates is entitled to and does terminate the further lease. Alternatively, the restrictions imposed by the SMS amount to an event of force majeure within the meaning of clause 6.8 of the lease, such as neither party may be held responsible for any failure to perform the lease. So that is where notice of these points was given to my learned friend. That's precisely what I'm saying today. What I'm focusing on at the outset of my submissions is the question of the legality of performance and the effect that that has on the contract. Now, it has a multiple potential effects on the contract, one of which is, A, it can render the contract void. As I say, normally, and we'll see this when I get to the authority I was trying to take you on to, the effect of supervening illegality, that is, illegality which arises during the course of the contract, is the frustration of the contract. That's the second way it's put. The third way it's put is to say, well, actually, imagine the contract stays in place and both parties are bound to comply with it. Well, that means that the claimant is bound, you've seen this, bound to open up the unit, the restaurant and bar without delay, and operate it without delay as a bar or restaurant. But it's not in a position to do that. So that would be an anticipatory breach of the contract, which would allow my client to terminate the lease. So those are the ways, and alternatively, it amounts to an event of force majeure, which my client is not responsible for, and that's one of the requirements of the force majeure clause. In any one of these ways, this is a lease which cannot be performed. So the authority I was going to take you to is the summary of the law of illegality and chitty. It's Defendant's Authorities, tab 16. And if we go, please, to page 621. And it's paragraph. So if we start, please, with 23024. Supervening. Does you want to have that supervening illegality? So this is the point I was making. So it is now customary to treat supervening illegality as an instance of frustration, in that it is similar to frustration by a subsequent change in the law. Apart from the effect of an outbreak of war upon a contract, e.g. with a person who thereby becomes an alien enemy, many wartime cases illustrate the power of the government under statutory authority to forbid, whether temporarily or permanently, the performance of a contract, and so frustrate it. In Metropolitan Water Board and Dick Kerr, under a contract made in July 1914, a reservoir was to be constructed and to be completed in 6 years from 1914, subject to a proviso that if the contractor should be impeded or obstructed by any cause, the engineers should have power to grant an extension of time. Under the powers conferred by the Defence of the Realms Act and regulations, the contractors were obliged to cease work on the reservoir by order of the Ministry of Munitions in 1916. The House of Lords held that the contract was frustrated by supervening impossibility, and that the provision for extending the time did not apply to the prohibition by the Ministry. The interruption was of such character and likely to last so long that if the work was to be resumed after the war, it would be a different undertaking altogether. Finn the LLC said that the interruption was of such a character and duration that it vitally and fundamentally changed the conditions of the contract and could not possibly have been in the contemplation of the cost of the contract when it was made. An express provision in the contract cannot exclude frustration by supervening illegality, where this would be against public policy. If we go forward, please, to 23026, we see this. The same principle of supervening illegality operates where a statutory power in existence at the time of making the contract is subsequently exercised to render illegal the performance of the contract. Thus, in re Shipton, Anderson and Harrison Brothers, wheat was sold upon terms that payment in cash was to be made within 7 days and against a delivery order. But before delivery and before the property passed to the buyer, the government requisitioned the wheat under an act passed before the date of the contract. The contract was held to be frustrated, so the sellers were excused from performance. So my learned friend says, well, this is all about the performance of the contract, but that's what illegality is about. Supervening illegality is about rendering, it's about change which makes the performance of the contract unlawful. And that may be by law, that may be by change of the law by statute, or it may be by an event which occurs after the creation of the contract, but which relies on existing statutory situation. But the effect of that is to render the performance unlawful. And that's just what happened here. There's no answer to it. Because as we've seen, the claimant is obliged to use the unit as a restaurant and bar, and that is unlawful. It cannot do so. And that's why it cannot perform its obligations. And as I've said, if the lease were not frustrated, my client would simply say, well, then therefore there's an anticipatory breach of contract. You are in a position where you, the claimant, cannot perform this lease. Now, no doubt the claimant would say that in the opposite direction, say there's a valid lease between my client and the claimant. The claimant would say, well, you can't perform the lease either. Well, then both parties have the opportunity to terminate, but neither gets damages. Why not? Because your loss depends on you being able to actually do what you were intending to do under the contract. So operating a restaurant and bar is illegal. There's no way on earth that either party is going to get any damages suing for breach of this contract. So certainly the claimant can't say, I've been held out from opening a restaurant and bar. In circumstances where, and we now know that the case, according to my own friend, is that the lease came into, the commencement date is in November 2012. Well, nothing's happened since November 2012 to make this lease admissible, to make it possible for the claimant to open a restaurant and bar and operate in the way that it has to under the terms of the lease. So that's why you can analyse it in terms of breach and termination, but that is why, in reality, the law deals with this in terms of frustration and avoid a contract becoming void for illegality. So that's it really on that part of the defence. So I just remind Your Honour, I don't say that there are real prospects on any of the issues there. You've got 5 issues before you. If Your Honour is to find that there are, for example, real prospects on some aspect of the case and none on others, then it's open for Your Honour to actually make those sorts of findings and pass it up in that way. Obviously, my position is there's simply no prospect on the case, assignment, registration, stoppable. But even if there were, these are just indefeasible points. Either the lease is on hold indefinitely, in which case no start date can be ascertained, or alternatively its performance just would be, as of now, unlawful. Now, unless Your Honour has any questions on the amendment applications or the immediate judgment application, that is all I wanted to say on the claim and the defences. I haven't dealt with my learned friend's application for disclosure, and there is also a request from my side, if the claim is to proceed forward, that there be proper particulars of quantum that are provided by the claimant. Because if the claim is going to go forward, I say that it can't, but if it does, if I'm wrong, if it's to go forward, then what needs to happen is for this claim to be quantified properly. Because if it isn't, there is absolutely no way for my client to deal with this proportionately and, frankly, commercially. It just can't, because it doesn't know what the claimant is looking for. And my learned friend said in his skeleton argument it's not possible to quantify this. On the other hand, we've got all this evidence from Mr. Akinlele in his latest witness statement, where it explains, I estimate that the losses are in the millions. We hear from my learned friend now in his skeleton argument that the lease is intended to run from November 2012. So regardless of whether my learned friend, the claimant gets an order against Zane, which I can't see as in any way possible, but regardless of that, his case would be that the lease started in November 2012 and finishes 10 years later in 2022. So then his loss has to be quantifiable, whether it's loss of profits, which seems to be what's being said, or whether it's some sort of analysis based on there's this other property that's available and you're going to take it on, the rent is higher. Whatever it is, it needs to be quantified, because at the moment it's just an absolute black box. My learned friend asked for an inquiry as to damages. That's a remedy that would normally be ordered in relation where there's a situation where the information about loss is really in the defendant's hands. That's why it arises in generally. That's why it arises generally in intellectual property cases. Because in intellectual property case, if I take your IP and go away and use it, and there might be an inquiry as to my profits, or alternatively, you could have an inquiry as to damages. And your damages would be your losses at not being able to go into the market and sell that product yourself and get the profits from your sales. And so the information about my success in doing so will be integral to your claim. But whereas here, there's nothing of that nature in this case. And so what needs to happen, I would say, is that there would need to be quantification of the case. I make that point before I forget it. There is then the disclosure application. I've made my points about whether disclosure is required, or whether anything further could be required in relation to this application. I say that it isn't. There's no possible basis for requiring Mr. Fernandez to give evidence in relation to this, live or otherwise. For the purposes of this application, you can decide the application now, and if you decide, if your Honour agrees with me that this is a case that can't succeed and there's no benefit, obviously, in further disclosures. Disclosure is only necessary if any part of the claim proceeds, and the extent of any further appropriate disclosure will depend on which parts, if any, succeed. So if, for example, the Honour wants to find, well, there's an arguable case on, I don't know, registration, then any disclosure would be limited to that if the other parts do not survive. So it needs to be within that context. Now, I think my learned friend makes some specific complaints, and we'll go to the order. But I think if I can cut through this like this, if the claim succeeds, I don't accept that it is necessary. But given what has happened in relation to my client's emails, and what has been discovered in relation to Ms. Fernandez's emails, if the claim goes forward, my client is prepared to undertake the disclosure exercise again. And that should put paid to any concerns. We know what went wrong in the first instance. That's still being investigated, the full extent of that still being investigated. But we will be in a position then to do the searches, and there's no reason not to. There is no justification for a discrete and specific order for production of, quotes, the master sales agreement, because this disclosure is only necessary if the case succeeds, and that may be on the basis you think there is something in that. I say there can't possibly be anything in that. What the court can't do is decide that issue by default by making a specific order in relation that my client produced the master sales agreement, because that would be unfair. And you've seen what my learned friend tries to get from that. If you order me to produce a document that doesn't exist, my friend's going to say, oh, well, they can comply with that order, and therefore you can assume that it does exist. So he creates by circular logic a presumption in favour of the existence of the evidence that's on him really to establish. So if we go, it's probably best if we just look at the schedule of the order that's being sought at the moment. I'll try and deal with this quickly because I don't want to labour this, because as I say, it's very hard to see how this point comes up, how this arises. It's in Bundle 1, tab 12, you see the draft order.
Yes.
I think it's been amended as well, I'm afraid. I think my notes have been against the one that wasn't amended. But if we just go through it, starting on page 231. So, subparagraph, so this is the schedule of documents, specific disclosures sought. So my primary position is if the claim goes forward, it should be sufficient just for my client to be ordered to redo its disclosure exercise. But if we look at A1, so 1A1, what's being sought is far too broad, because if you look at the preamble, it says with respect to the first defendant, all emails, letters, memoranda, file notes, telephone records or other communications relating to, and then goes through. And those terms relating to contain no relevance criterion to the issues actually in dispute in the claim. It's not bound by time. It's not bound by anything else. So in its current form, it simply can't work. Then 1A1 seeks a specific order in relation to the master sales agreement. You've got abundant evidence that it doesn't exist. We've been over that. But where a party says that a document does not exist, the usual approach actually is that they provide a witness statement from the person who's carried out the search, signing off on that witness statement saying it doesn't exist. That's the usual approach in civil proceedings. But in any event, if that document were by some miraculous event to be found, it would fall within the terms of the standard disclosure. So you don't need a discrete order in relation to it, and one can't be justified. The second item, internal correspondence from Melanie Fernandez in reply to an email from Balakrishnan Kannan, which contained a request for the lease contract. We've checked the documents again. This is the evidence of Mr. Fadi Brocklehurst, which you find behind tab 23 in bundle 4. He says he's checked it again, it doesn't exist. But this will be picked up in a general disclosure exercise. 3, all internal correspondence, meeting notes and instructions given in relation to drafting an amendment of the first defendant's letter dated 20 April addressed to Union Properties. Again, we say that would have been picked up in our first disclosure exercise. It will be picked up in the second disclosure exercise if it exists. The specific order in relation to that assumes its existence. And our position is, well, it doesn't exist because it hasn't been found. Similarly, in relation to item 4, it will be picked up in disclosure if it exists. As to B1, this is the document for the 9th of December 2012 email and the request for the attachment. That's been produced. It's been produced now in digital form as well, and Your Honour will recall me mentioning this yesterday. And as I understand it, my learned friend is at least satisfied, if not by the process, but by the fact that what he has is now correct. And then, as to 2, as I understand it, a reply email from Khalid Ali to the inquiry in the email, Mr. Fadi Brockhurst says, actually, that's already been produced, I believe. That's his evidence. But in any event, again, it's all been picked up in disclosure. In relation to all of the points in C, D, and E, if any documents answering those descriptions exist and are relevant to the claim, they will be picked up in further disclosure. We'll do it again. Don't accept the application should we need to, but we will do it again if this case goes forward. Paragraph 2. The paragraph 2 appears to have emerged from a criticism by the claimant of the list of custodians, which was identified by the first defendant in carrying out the disclosure exercise. So what happened, as I've said, was they identified the individuals who are likely to have been involved, collected their emails, and then searched them. And the criticism was, well, that wasn't going to catch emails passing between, for example, one of the relevant Emirates people and one of the relevant Union Properties people. I think the misunderstanding there by the claimant was what was meant by custodians. So in other words, if the document is in, like, say, take Melanie Fernandez, if it's in her inbox, it will be picked up by the search if it is relevant. And so there's no basis for saying that everything that passes between all of these people and Union Properties, say, should be picked up, because that's going to happen anyway, as long as the list of custodians that has been identified is reasonable, and we say it is. So that's the scope of the disclosure exercise that I can offer if the case goes forward. Schedule B is really about documents to be produced by the second defendant. There was, I think, a discrete issue about certain documents relating to Zain Capital. My own friend makes this point. This is at, I think it's the one on page 22, Is it E2? Oh, it's been E1, sorry, yeah. So it's the top of page 233. The suggestion that there were 300 documents relating to Zain. I mean, we clearly have documents which relate to things, but they're not relevant to the issues in disputes. And so there were 300 documents which we've been through and decided that those were not relevant documents. We made that, and now inevitably my own friends picked up on that, so we want those 300 documents too. That relevance, that sweep has been done, and they're not relevant. It'll cost us quite a lot of money to produce those, because they would need to be redacted to try to get rid of irrelevant confidential material, such as pricing and so forth. And that was the position that was taken in the disclosure statement. So that's where this presumably all comes from. Of course, if your Honour orders that it be provided, we'll provide it. It will cost us money to do it. It will take time to do it, but we will do it. Hiding anything. This is just that lawyers from this side have been through it. Lawyers, so external lawyers, and have said that they're irrelevant. And then there was also this complaint that my client hasn't asked a Freedian angel. As I said, Freedian angel were the Union Properties external lawyers. My client has no better access to a Freedies files than the claimant. If the claimant says there might be relevant documents with a 3D angel, well, the claimant should go and get them from a 3D angel. The reality is the claimant will get from Union Properties whatever is relevant in 3D's files. Because if, as was the case, Union Properties was ordered to produce the master sales agreement, then if that was with its lawyers, it would have been under an obligation to produce it. So that's, I think, all I need to say about disclosure. We don't accept that there are risks in disclosure. We don't, and obviously it doesn't matter unless you're not with me on the application, unless I lose my application, at least in part. But if it does go forward, we will do the exercise again, and that will sweep up any discrete questions that there might be about particular documents. It's not, however, appropriate to make specific orders that we produce certain documents, because that assumes that they exist, and our searches so far indicate that they don't. So that's all I want to say about disclosure. That, I think, really deals with everything that I had to say about our application, save for one matter which Your Honour raised yesterday. The question that Your Honour raised was in relation to registration. Now, my position, obviously, is that registered or not, it doesn't matter, because it's not registered now, and that's the end of it. Any interest that's created by registration is gone, because there's no registration now. If Your Honour is nevertheless not confident that might be right, and wants to make further inquiries of the registrar, my client's quite happy for this court to write to the registrar of your property. So that's the answer to the question that Your Honour raised yesterday. From our side, I don't think this has been shared with my learned friend yet, but we drafted out something which is in completely neutral terms, and perhaps I can, if we've got copies of this, perhaps we can provide them. I don't need to take Your Honour through it, but this is what we would propose would be an appropriate draft. I don't want to necessarily go through the detail of it. I think it's what's important is that it steers clear of submission if there is to be any letter from the court. And this, I hope, is in such neutral terms that it can't be objected to.
Thank you.
I'm grateful. And then the only other issue that remains outstanding then beyond my learned friend's reply to my submissions is his application to restore
the
company which currently doesn't exist to the register. Now, Your Honour asked me to do some work on that, and perhaps the best thing to do, my learned friend's also done some work on that, perhaps the best thing to do is hear from my learned friend's application, and then I will make my observations.
Thank you, Mr.
Thank you.
So, Mr. Roger, are you going to speak about the restoring the company, restoration?
Yes. So I've actually...
Or you prefer to reply to the immediate judgment?
Let's deal with it now, so it'll take about a few minutes.
So to finalize this application, your reply.
Exactly. So, and just on the finalising, if I may approach your registrar, sir.
You submitted today?
Yeah, we sort of wrote that overnight. So, paragraph 1 through the letter, it says, the claimant, and that's registration number 907, be restored to the roll of companies held by the registrar of companies with the status not renewed. Okay? Until the final judgment is made by the DIFC court in this case. That's the order which is set out in the application which is attached to.
Yeah.
So,
the registrar's decision is clear. Now you're going to appeal his decision? This is your position?
no, what the registrar said is that he would do exactly that, sir. and that is paragraph 2. The Registrar of Companies, Mr. Khalid Al-Zaroni, gave an undertaking on 22 January 2007 stating, Dear Roger, referencing your letter dated 19 January 2017, a letter dated 27 November 2016 in relation to the notice for striking off a VEGIE bar. That's a notice that they provided to because we didn't have a lease. I hereby accept the reasons provided in the said letters, including the court's order. That was the order for leave to appeal, sir, which granted leave to appeal for the company. Thus, the status of the company in the public register will be changed from inactive struck off to not renewed until a final judgment is made by the DIFC court in the case, and accordingly the status will be reconsidered. Okay. So that sir, is what the registrar said to us in January 2017, and until 2 weeks ago, week before last, sir, we thought that was all fine. Everything was fine. I checked the register myself following that time, sir, and it was restored. Now, my learned friends checked the register maybe 2 weeks ago and found out that it wasn't, that it was back off, struck off again. And so what's happened next, sir, is that we have written 3 times to the Registrar of Companies since that time, and regrettably, sir, he hasn't responded. Took quite a long time to get him to respond back in 2017. I don't know what the problem is, sir, but he hasn't responded. So I've written to him, I've said we will make this application to the court today. Please take any steps you wish to come and intervene. He has not done so, really asking that you restore the company. And that sir gets across to the next page, the second page. The DIFC courts can order the restoration of the company. So we wrote to him, just to recap that, so 19 May, 22 May, and 27 May. So 3 times in the last 8 days. And the law says this: the court may, on application of any former officer of a registered person, and a registered person includes the company, and then underline further at the bottom, sir, make an order or orders to restore a registered person to the public register, and any other orders the court considers appropriate. And that is what we ask, sir. We ask that the order you make simply be that we be put back to not renewed, which is exactly what he told us we would have.
Do you think if the court issue a certificate to the registrar of company stating that the case is still live will help?
He knows it's still live, sir. I'm not saying that somebody in the office would have done it, sir. It's this sort of thing. I know it happens. I'm not concerned about it. I thought he'd see my email and click the button, but he didn't. So if you just write on the order that I've the application's ordered accordingly, we'll get an order typed up and served on the Registrar of Companies, and he'll put it back on, I'm sure.
And you make this application without notice, right?
That's right, but I wrote to him and I said, if you don't respond, I will make this application without notice. And that, sir, there was, just before we get to this, sir, there was one other point. You asked, can I come straight to you? Do I have to have a refusal by the registrar first? And the answer to that is, no, I can come straight to you. And we just crossed that off at paragraph 8. Pursuant to Article 33(1) of the law, the court of original jurisdiction of the matters seeking an order, therefore a decision is not required before DIFC seeking restoration. So it's not an appeal situation, so I've just made the order direct to the court. I'm entitled to do so. Just in relation, I put in the index there, Ms. Muhairi has to be fair, sir. She did this. And We've got there, sir, the first annexure is the email from the registrar dated 22nd January. We read that, sir. And then next page, sir, at the top there, dear Mr. Alzaruni will call this matter, case is called next week. And then I quoted what he said to me in January. Pleasantine states the company as follows, struck off. Grateful for immediate intent of this matter in order for the case is able to proceed. Please advise when we have. Didn't get a letter, didn't get a reply. Next page, sir. Dear Mr. Zaruni, I refer to the email below, one we just read. Inquire as to whether or not you've had the opportunity to consider the matter. As of this morning, the matter remains struck off. And then the other day, sir, must have been Monday. I must have written again and said, dear Mr. Alzaruni, I refer to my unanswered and unacknowledged correspondence below. The company remains struck off and the hearing of this matter is now tomorrow. I would seek to remind you that in your letter dated 22 January 2017, copy enclosed, you undertook that the company would remain on the register until a final decision of the court is made. We're aware that your office did initially restore the company. I'm unsure what has occurred since, but the company has reverted to struck off. In the event that you are unable to rectify this matter today, our client will seek an ex parte order against the registrar of companies before the court tomorrow morning. You will of course be able to attend and oppose the making of the order, although we do not see any basis for you to do so. We will rely on this correspondence to seek an award of costs of say $1,000 for the time and trouble and all the circumstances that should not be necessary, and I ask you to take action immediately. Now, cost against public officials probably. But I'd like my $300, or my client's $300, because that's what we pay to file this application.
Okay, done?
Yeah.
Thank you for that. If you can assist, it's up to you.
Well, there ought to be a couple of things that ought to be brought
But
to
already
attention.
I can deliver my order regardless. Yes, thank you.
Well, thank you. Just to bring something to your attention, a couple of things. Firstly, if I can just, your Honour was taken to the provision of the operating law. And I'm not making submissions as such, I'm just drawing things to your attention. So, the restoration of a registered person under Article 33, the court may, on application of any former officer of a registered person. So the application needs to be made by an officer, it can't be made by the company. Logically, that's logical, the company doesn't exist. So an officer needs to make the application. And the way that we do originating applications in this court, because the claim would therefore not be made by, the application would not be made by a party to these proceedings. It would need to be made by way of Part 7 claim form. And then the other point is that if you look up on provisions of the operating law on page 7, I don't want to make your life more difficult, this is just the fact of it. So article, page 7 of the exhibits, so page 19 of the law, 30, so it's 33 if you look up. 33, 12, subject to the article 33, when a registered person is dissolved, all property and rights whatsoever vested in or held on trust for the registered person immediately before its dissolution vests in DIFCA. So if I was in your shoes, Your Honour, I would want to know that DIFCA had no objection to this. These are things that really ought to be pointed out to you. This is an ex parte application. There's a duty of full and frank disclosure on my own front. It doesn't matter whether he's told the other side that he's going to make an ex parte application. He's made one. So his obligation is to tell you all the problems that might arise. Now the effect on these proceedings, if the company is restored, I keep my powder dry on that. But generally, as I say, in the light of his duty of full and frank disclosure, I would want to know what is the test to be applied in these circumstances. And I would normally want to be shown some authority. If there's no authority from this jurisdiction, I would want to be shown some authority from a jurisdiction which operates in a similar way, which has a similar provision, to show, because you're left in the dark. When a friend says, I want to be restored to the register, and this is my reason, it doesn't explain to you what the legal test is. I would want to know, if I was in your Honour's position, why the company was struck off in the first place. I would also want to know whether or not, since that email that we've seen from the registrar of companies, it has been restored and it's struck off again, and whether any attempt has been made to find out why. But I would want to know about that. Now, we've heard about that in submissions, that it has been restored and struck off. It seems to me, if I was in Your Honour's position, that simply relying on a statement from the Registrar of Companies that there would be this restoration can't be adequate, because this is not a personal claim against the Registrar, to which you can be bound to that decision. Your Honour is being asked to make an originating decision as to whether this company ought to be restored to the Register. So I would want to know what's the test for that and what are the grounds for that, regardless of the position that was taken by the Registrar. It seems to me that there's no obvious justification for making this application ex parte anyway, given the time that my own friend had. Now, he says, well, I tried to get him to respond. Well, one would ordinarily expect one to launch one's application and get it listed for the first day of trial, and then at least give the other party the opportunity, the proper opportunity to respond, and then he wouldn't be faced with all these difficulties. So if I was faced with this application, I think I would tell my own friend to go away, put it back together in a form which actually works, and come back. I don't make any submissions as to whether or not you should grant the order or not. But that's
Yeah, understood.
correct.
Thank you for your help. So, in regard this application, my order is this is an not ex parte application. You have to serve it to the registrar of companies according to the RDC Part 9 of the service. I'm waiting for the reply, and I'm going to deal with this application on paper, not in hearing.
Okay. We'll do that, sir.
So record this as an order for this application, please. And the time frame will be applying based on RDC. Yes, Mr. Roger. Now you can reply to Mr. Paul.
Sure. Thank you, sir. Let's start, sir, with the pleadings issue. What are pleadings all about?
Sorry to interrupt. You have 1 hour or more?
1 hour, sir. Let's go.
Sorry, Your Honour. In principle, we had my own friend's application, my reply to it, then my application, my own friend's reply to on his application, response to my application.
So you said
there ought to be a period for me to respond.
So
At the end. Whereas my application, I ought to be entitled to reply to it. That would be the normal course.
fine.
I don't anticipate there'll be lengthy submissions, but that ought to be
Fine. Well, let's not make an objective here.
Thank you.
After his final submission,
Yeah.
so you will give you an opportunity to reply. This is
If
what-
necessary. Maybe there's nothing to say.
No, sure.
Thank you.
Just go ahead.
The mirror images. Oh, dear. Okay, pleadings. What is a pleading? What are the purposes of a pleading? To fully and fairly inform the other party of what you're asking. That's the locus classicus of the suit. In this sort of application, for my friend to succeed in his application for summary judgment, it would have to be that our pleadings are impossible, that there's no way through even for the amendment. Now that's just clearly not the case. What I'm saying to you, sir, is that our pleadings are fine, and you can't just pick little bits that you don't like and jump on those. There's also, sir, there's part 19 of the rules. In that sense, that if there's something you don't understand about the pleadings before you can ask for further particulars. Didn't happen. Hasn't happened. That's really the end of these complaints, sir. Now, the pleadings, sir, set out the facts upon which we rely. They don't need to set out the evidence upon which which prove or disprove those facts. Just the facts. And if they make the allegation, well, that's fine. That's sufficient. As I've just said, sir, if the defendant doesn't understand it, they ask for further particulars, which they didn't do. So if we move to the actual pleadings, sir, and that's ours, sir, under, I think, tab 7.
Number 1?
Yeah.
Yes, what's page?
It will
190.
171, sir, yeah.
This is at the beginning of the. Yeah, take me to the page. Which page?
Yeah. Well, exactly. The ones that I'd like to take you to, sir, start at 22. And this says here, by agreement for sale and purchase dated on or about 11th of January, Union Properties agreed to sell its remaining units, including the leased units, in Limestone House. Now that pleading, sir, that includes all of the agreements. If there's more than one, it includes all of them. It includes the master sales agreement. And if there just can't be any doubt about that, sir. In reality, the defendant's never been in any doubt about it. He's always known about the master sales agreement. We've been asking for it, sir. Okay, next one. We go over the page, go to 25. The sale of the freehold interest in Limestone House by Union Properties to the first defendant was therefore expressly subject to and made with notice of the leasehold interest of the claimant as set out in the further lease. Again, that's telling them that it was assigned to you. Okay. And then 26, sir, the first defendant was aware from the 14th of March of the fact of the consent of Lacrane to the claimant's lease and purchased the assignment of the further lease of the leased units. Again, sir, as we go on, if we go on to 58 and 60, but you've really got to read the whole of it, sir, and say, am I somehow misunderstood here that the claim that these people are making is that when this property got sold, that the lease went along with it, and that they purchased the assignment of the lease? That's got to be it. And here's the exact point, sir. The sale of the freehold interest in Limestone House by Union Properties to the first defendant was expressly subject to...
Therefore, is the word.
My learned friend doesn't like the word therefore. Again, we're dancing on the heads of pins of stuff that doesn't need it. No, what you don't like is people interrupting you.
No, because of inaccuracy. That's the only reason.
Which is at the beginning.
Oh, dear. Okay. The sale of the freehold interest in Limestone House by Union Properties to the first defendant was expressly subject and made with notice of the leasehold interest of the claimant as set out in the further lease agreement. And again, sir, at 60, the first defendant has refused or otherwise neglected to recognise the lease interest of the claimant and has changed the locks on the leased units, Limestone House, and denied the claimant access to its leased area. Again, sir, over the page at 62, the sale of the freehold interest in Limestone House by Union Properties to the first defendant was expressly subject to and made with notice of the leasehold interest of the claimant who held the further lease in the same terms if it had been registered under the DIFC property law. And then, sir, the equitable obligation arises by Operation Equitable Stop of the doctrine of anticipation, the rule in Walsh and Lonsdale, which apply irrespective of any registration pursuant to 31H of the DIFC law of real property. Then again, since the 12th of March, since March 2012, the claimant has attempted to negotiate the unit access to the units with the first defendant. Such negotiations have included giving the first defendant time and opportunity to develop the plans for the space, which would allow for the integration of the claimant's leasehold interests into the development of Limestone House DIFC. Now, sir, this is pretty clear, with respect, and it is difficult to see how there's any room for the confusion. And if there was a procedure you can follow to clear up any confusion. It was never followed. The next point, so if we just flip forward to paragraph number 12, sir. 11, my apologies. If we go to paragraph 18 of that document,
again, in which paragraph? Page and paragraph?
18, sir.
The same document?
Yeah.
Yes.
It doesn't say pages. 11. And there, sir, the application is based on a point of law that the first defendant purchased the assignment of the lease with its purchase of the subject units. Right? So this is in the application, sir. So if there's any misunderstanding from the claim, and I appreciate my learned friend's better at it than me, I fully concede that. But this one, I say, gets home. Any confusion whatsoever, sir, cleared up here where it says you purchased the assignment of the lease. That's the end of it, sir. Next point, sir. We've had complaints about, over-complaint about this discovery issue. Well, we've just heard now, sir, that my learned friend's saying, yep, the problems are still going on, we're still being investigated. So even now, 17 months after the Court of Appeal made its order, they haven't complied. And it's their non-compliance, not my non-compliance, sir, that's at issue here. And I've said it before, sir, but the hearing, time before hearing is gold. You have very little. My learned friend's skeleton arrived on Thursday night. First I knew, sir, that I'm up against imminent counsel. What arrives with it is like some unexploded bomb, sir, is this further bundle of documents. No notification given whatsoever. And I have been critical about that, sir, because I don't know who knew, and I've asked my little friend, he said, the moment I knew, I let you know. But that only goes so far, because it's clear that the bank knew from at least the 15th of May that this was a problem. And if they didn't tell my learned friend, well, obviously he's blameless, but it doesn't mean that they are. And that's so my complaint is, given that we're now facing our fourth, my learned friend said, yeah, we're going to do this exercise again. So we had it done first of all in February 2018. They had another crack at it in January of 2018. They got a very lengthy extension, further 72 days to do it. And then they had another crack in May. Now we are here, we're going to have another go. Okay. Now, and then, sir, my learned friend raises 2 points, and I don't know if I need to go to them exactly, but the first one, he said, well, this is specifically how Mr. Bell has been unfair to us. Okay. He says, there was the issue about the email sent to Khalid Al-Ali from the DIFC, which attached the units as a letter to the registrar Director of Registry Services, attaching the list of units. We were looking at it, so I don't know if you want to go there, because you probably...
No, I'm aware of that schedule.
Yeah. Well, the problem with it, right, was that when we received an electronic bundle of emails. It was just pretty much, they were in four great big folders, 1, 2, 3, 4. The one we received, a number of them which we received, including this one, didn't have the emails attached. Okay, the attachments had been actually taken off the emails, which I didn't actually know that you could do that. I thought that the Microsoft system had a lot of integrity built into it. You can't take it. Once you've sent it, it's rock solid. But apparently you can remove them, and these ones were. Okay, and the difficulty, and what Khalid Al-Ali had asked EMDB was, are these all of your units that which you have? Are these all of your leased units? I said, it's sent off to the registrar, and they said, yep, these are all of our leased units. Now, naturally, sir, we wanted to have a look at that attachment. So that's what the 18-page letter dated 9 May was, wasn't all about that, it was about all of the problems, but it covered that specifically, right? Now, we don't get an answer to that at all. No answer. Never been answered. And so, Mr. Carnell said, I will. We looked yesterday. He said, I will answer it. It'll take me less than 10 weeks. It took you to write it. But he never did. He did something else instead. So, what do we do? What are we supposed to do? So we made the application for it. Okay? We've asked you. That's the proper thing to do. We ask you. So we go to the court. What happens is that we get Mr. Hardy Brocklehurst. Now, he gives us what he says is the attachment, but it's not attached, okay? And when they've confirmed, yes, these are all of the units, right? The attachment is only the residential. And we know that they have residential and retail. Everyone knows that. And so if you're saying it's all, it's not all. So we said, well, will you give us the actual attachment, the full attachment? Give us the email plus the attachment attached, and we'll be happy. Okay. Again, that doesn't happen. We're 4 months on, still hasn't happened. It happens yesterday, and so we get one email yesterday. Presumably, somebody looked at it and said, actually, we can win this one because although they said it was everything, the actual attachment was just the retail ones. They sent it across, and then my learned friend says, now, Mr. Paladin's made all these complaints. He had nothing to complain about. I sent him the email yesterday, and it didn't include these retail units that he was looking for. His complaint never had any foundation in the first place. Well, actually, see, that's not the point. The point is that you're supposed to do things in the first place at the lowest level. Why do we have to keep escalating it up and come here to get it? That's the point about that. Okay. The next point, sir, is about the misdated letter. And it said that I've been unfair. Now, I was particularly careful, sir, not to say that there was any misleading of the court. But I did say that they should not, that they should have disassociated themselves with that letter much, much earlier. Okay? And that has most certainly come to light. At the time, there was some doubt about how this misdated letter came about, but now we've seen the secretary typed it. Everything was wrong in it. Somebody else added some more wrong things that off it went, and it even was wrong by the whole year. But none of that was known back in the first Court of Appeal hearing. Now, I did not make a mistake, sir, about putting the date of that letter into the chronology as the 30th of April 2012. There was a discussion about it, and they insisted that it go in as the 30th April 2012. Now that's just my recollection, sir, because I haven't had time to search my emails. But that is my recollection, and I was quite happy for somebody to put in a witness statement about it. Because
I can show you the email if you like.
I know
looking at it.
that it was earlier discussed, but what I am talking about is the circumstances. We knew that it's either 12 or 13, which one is it, and that there's doubt about it. Absolutely, we knew that. But the circumstances of it going into the chronology are not, as was said. It wasn't a mistake, sir. So if anyone wishes to put a witness book statement forward about that, be my guest. Okay, next point. So, and it's hardly a minor matter, sir, because paragraph 18.4 of the Court of Appeal relies heavily on that letter, and it's unfortunate that it ended up that way. And particularly, sir, if the defendants had searched their own documents, right, the documents we've seen now, if they'd done a proper exercise then and properly looked at that letter, right, they would have known without a shred of a doubt that it was wrong, right, and should have told the Court of Appeal. And the Court of Appeal wouldn't, as paragraph 18.4 of the Court of Appeal decision does, reproduce it in the detail with us. That's all we're going to say about that, sir. Now, if those two matters, right, are actually the only complaints about my complaints, well, the rest of my complaints are true, and undoubtedly, so they are, because we've had 4 successive exercises. It's all wrong. And then the next point, sir, is my learned friend seems to take various approaches to this. First of all, he says, in relation to the Master Sales Agreement, he says, we've never been ordered specifically to produce it. But then he concedes in the next breath that, yeah, but the order for document production would cover that order. He just said it a few minutes ago.
If it exists.
Yeah, if it existed, that's right. And the question, so if it exists, it was covered by the order, okay? And if it was covered by the order, the reference to 28, whatever it is of the rules, sir, does apply, because, so if it's covered under the order, they have been ordered to produce it, and if it exists, they haven't produced it, and so therefore it should be considered that it's against them. And my submission is not confused, fanciful, far-fetched, or anything like that. So that's how it works. Now, whether or not it exists, sir, is a matter of evidence, and it's whether it exists on the balance of probability. That's the test for admission of civil evidence. So is it more likely than not that it does exist? And if it's more likely than not that it exists, which we say it is, well, the court is entitled to take the inference that the document's against them. And we say that that's an easy inference to make because we know what was agreed before, that we offer to sell all of our stock and leased, rented, vacant and rented was the exact words. So we know what happened back in November before the agreement, and we don't know, and there may be a shred of doubt about what happened in that agreement, but we know what happened after the agreement because we know that they carefully sorted out the rents. And we do need to have a look at this. And just I take you to Bundle 2, so tab 20, page 439. And the question that's got to be asked here is that, so that's Bundle 2, sir. Tab 20, 439. Okay. And this is the last known copy of the Master Sales Agreement, and this is some 27th of December. So we're heading towards sale time. Everyone's getting organised for sale, and this was a draft which was being exchanged. Okay. Now,
but no signed one. This is what you want to say.
No, but again, Sue, that probably you wouldn't necessarily expect to find the signed draft in your email system, right? Because what happens with the signing of a draft is people sign it, And so it's done on, it's the one document that's not exchanged electronically, so it's signed up. So it is a matter of looking for it. And the test here for document production is everything in your power and control. And it said, well, with respect, sir, it was the learned Chief Justice who suggested that the parties should approach their lawyers, okay? And what your tasks were doing, right, when you're doing document production, is you're looking for documents which are in your power and control, and you produce a document production statement, and part of it which didn't adequately happen here, and again, that's a 9 letter. It's another thing we were complaining about. You didn't do a proper document production statement, and if they had done a proper document production statement, sir, that would have said these documents were in our power and control, and they're not now, and would have listed them. And then, if you're looking for something that's in your power and control, if you've been told to get your bank statements, right, and you look around home through the bottom of your wardrobe like I would, sir, and you don't find it, but then you remember, gosh, my accountant has got one, or actually somebody, it doesn't matter if it's somebody else's accountant or somebody else's lawyer has got one. It is, in fact, your duty to go and get it, and to make reasonable efforts to get it. And that is actually something that they could have done, and it's something that they haven't done. So, but just before we turn away from that document, sir, I want to show you this. Okay, because the next thing my learned friend says, he points at various provisions of this document and said, well, even if there was one, it wouldn't matter, because if these two individual SPAs didn't mention it, that's the end of it. And if there was any conflict between the two documents, the individual SPAs are going to prevail. Well, who said that there was going to be a conflict between the SPAs and the master sales agreement? Because if we go through to page 444, sir, okay, we see here there's a schedule. And again, sir, what we're doing is an evaluative exercise. It's like...
Which empty?
Yeah, well, it's not exactly empty, sir, because it says Schedule 1, list of units. Okay, so this is the draft going backwards and forwards, okay? And so there's going to be inserted in here a schedule of units, okay? Now there was only really one schedule of units, and we've spent hours looking at it, sir. And the closest example, sir, is back at page 424. And there's is the schedule of units. So...
which we saw yesterday.
Sorry, sir?
Yeah, I saw this yesterday.
Yeah, exactly. So, you know, when it comes to the master sales agreement, right, for my learned's friend submission to work, as he likes to say, well, there would have to be conflict. And if there was going to be a schedule attached, on the balance of probabilities, sir, it was going to be this one, because there was no other. So I think we can say, so just to round up this issue, my learned friend accepts that if there was a master sales agreement, it was covered by this order, it was covered by the Court of Appeals order, okay? If it was ordered, they had an obligation to look for it. If they haven't produced it as a result of that, the court is entitled to infer that it's against them. And when one decides, well, would the master sales agreement have mentioned these units? I say, well, that's actually really easy. And the answer's got to be yes. Because when we look at the draft, it was going to have a list, and we look for a list, there's only one list, and that list mentions our units. And if, sir, I'll come to the point in a minute, but my learned friend, he concedes, yeah, contract's fine. This lease is a contract, irrespective of registration. If there was a contract between Union Properties and our client, which most certainly there was, and if that was a signed on, well, that's binding. Okay? So, and this would have been the contract. It's missing. Now that actually moves to the next point of Melanie Fernandez, right? For the first time, and I actually asked about back when they got that adjournment back in February, sir, your Excellency dealt with it at some stage on a review application, I said to the court. At the time, sir, the excuse that they made was, look, one of the people who are dealing with this is very ill, and that's causing us difficulties. One of the, I can get you Mr. Hardy Brocklehurst's exact. Mr. Hardy Brocklehurst, I can get you his exact words, but it was mentioned there that somebody was ill. And we actually asked, well, who is that, and how is that stopping you? Actually wrote to the defendant and said, look, that's a reasonable excuse for not getting something done if somebody's really ill, and you tell us who's ill, what it's about, and of course we'll give you more time. Well, they didn't, right? And so now, right, in relation to the summons, we hear, well, yes, it's in fact Miss Fernandez who's ill, but that, of course, that's unfortunate, and of course we don't want to unduly burden her. But, and I've just heard about it now and haven't had time to get the authorities to, but I most certainly can. That the rule is on that if you're saying that somebody is too ill to come to court, you've got to provide evidence of it. Okay?
I'm not saying that.
She's not saying that. Right?
I'm not saying she's too ill to come to court.
Right. Okay. Well, in which case, sir, there's nothing preventing it. And of course, if she's unwell on the day, or if she needs less time or something like that, we'll do everything to take that into account. Ramadan will be over, it'll be much easier. So I don't know why the submission was made then, if she's either able to come to court or she's not. And the answer is she is able to come to court. And the further answer is that she's still employed by the Emirates EBD group, and so she's available as well, sir, within the jurisdiction. Very easy to do. Okay. And why we need Ms. Fernandez is not just the admitted, and we've just heard, possibly for the first time, that this ongoing disclosure, it's going to be coming in for some weeks. We're going to do an investigation, and we'll do it all over again, and everything will be fine. Well, sorry, sir, we've heard that before, actually, but why we want Ms. Fernandez to come to court? Two reasons. One, sort out this disclosure issue. It was her emails that are at fault, that are in trouble here. But the second thing, it dovetails back to the missing master sales agreement. Because what happened here, sir, is that, and my learned friend, I objected on the grounds of hearsay. Okay? And I say my objection was well made. It caused my learned friend to dive off into the rules and say, well, there's notice provisions, and he escapes the notice provisions here. And so he says, well, that's fine. I can proceed on hearsay. Well, really? The answer to that is not really. And anyway, that evidence has to be treated with great caution. And what is the hearsay evidence that he wishes to rely on? Because the issue with hearsay, sir, is reliability. It's Chinese whispers. That's what it's about, sir. What somebody else said to me. And so for me to come to court and say, well, somebody else who's not a party, see, anything that they've produced here, sir, that's not hearsay, because they're here, they're a party. But my own friend, 23 years as a criminal barrister, sir, I know a lot about
criminal was a little bit different, you know that, right?
I know about the difference between civil liability and criminal liability.
Anyway,
this is a story. This is what.
And the court can answer this question during the reservation of judgment, of course.
Sorry.
Well, exactly.
I apologise.
apologise.
Exactly, sir. If you wish to rely, that's the difficulty with hearsay. It's about reliability. Typically, it's unreliable, and we know why it's unreliable, because it's what somebody else said about something. And the courts are generally loath to accept that evidence. And if there's better evidence, there's the best evidence rule, you're supposed to rely on the best evidence, right? And that is why she should be here. Because what we've got here with Mr. Hardy Brocklehurst, and I'm still just on the same, bundle 4, sir, tab 23 at page 911, right? Mr. Hardy Brocklehurst.
Yes, which paragraph? 5?
Exactly, sir. Yeah, you're obviously familiar with it. Indeed. And we're sounding a bit like a fireside chat here, sir. Indeed, Rajesh Mistry recalled that whilst a master sales agreement was signed between Union Properties and the first defendant in connection with certain residential properties, the sale and purchase of the retail units included the disputed VEGIE bar units were documented by signing individual sale and purchase agreements only. Well, okay, that on any view, sir, is hearsay. Okay, so boom, reliability is the issue here. Is it reliable? Well, probably not. It's inherently unreliable as hearsay. So with the admission, the key to the admission of all evidence, sir, is reliability. Kumara v. the Queen, old English Queen's Bench decision in 1953, I think it's Lord Wilberforce, sir. Okay, and so that's what governs any admissibility is relevance. Okay? And when it comes to the admissibility of hearsay evidence, sir, it's reliability, and that's indeed what the test and the rules are all about. Well, this is unreliable, and it conflicts, sir, with the drafts that were exchanged. So this is a situation, sir, whereby the parties agreed, not just in the letters from November, but through to actual exchange of drafts of the master sales agreement, that there would be this thing, okay, and then it disappears off the radar. There's nothing to say, oh, dear John, we've decided not to go ahead with the master sales agreement, and we've scrubbed that out here. Nothing about that, right? It just disappears. And then we get somebody coming along and saying, oh, I don't think there was one. Or we actually get somebody coming along and saying, somebody else told me I don't think there was one. Again, there's one person who would know, and it is a key issue, and that is Melanie Fernandez. She's available, she's able to come to court, she's well enough to do so, she should come. I realise it's an inconvenience at this stage, sir, but it's not an inconvenience caused by us, it's an inconvenience we're prepared to put up with. And I'm suggesting, sir, that in fact the hearing, that part of the hearing, get adjourned for the first available date, which should be the week after next. And if my learned friend can't make it, his juniors are fine counsel, sir, and can most certainly do it. And Mr. Carnell's a hugely experienced lawyer, sir, and he could certainly do it. And we just get her in here for half a day, and she can answer these questions. And it's practical, it's simple. And my learned friend says, oh, this is extraordinary. I've done hundreds of court cases. Well, so have I. And it's nothing extraordinary about it at all. If there's some problem with the evidence, well, what do as lawyers? What does a court do? We get the witness in here, we swear them to tell the truth, and we ask them some questions. That's what we do, sir. And nothing. It's everyday bread and butter stuff for a court like this. Right. Next one. Okay. Being said, well, I'm going to finish on time, sir. It's been said, this order was very wide, wider even than your Honour's order of 20 September, which is you're probably familiar with, sir. Well, why was it so wide, sir? And why was it more extensive than your order, sir? And the answer to that is because the Court of Appeal was faced with what they found to be a pretty extraordinary situation. Okay, and so you're on the sat on the panel of the Court of Appeal, so I don't need to tell you what the Court of Appeal's thoughts are, and you don't need to tell me. But I'm saying, sir, that the Court of Appeal made the order that it did because we're in an extraordinary situation, and that was actually set out by His Honour Justice Cook in the decision, Sir Jeremy Cook in the decision, where he said, and I've put it in, it's a paragraph 16, and said, was there actual registration of the lease? What, if anything, is meant by provisional registration? It's in my skeleton, sir, it's paragraph 16.
I'm referring to the judgment itself.
Yes, sir. In the judgment itself, that is tab number, volume 1, sir.
Yes, page 165.
Yes, sir.
Anyway, read from where you were.
Yeah, exactly, sir. Was there actual registration? What, if anything, is meant by provisional registration? Is that registration within the meaning of the law or not? If it is, what impact does that have in the light of a registration of the sale on 29 March, following the SPAs of 1 January, and how does the registration strata management plan after 28 May, with its inconsistent provisions, affect the situation? Did EB so conduct itself as to that it's subject to an equitable obligation in respect of the lease, and if so, from when? Now, there's another point. Your Honour will recall, and we don't have a transcript of it, but I was there, sir, and so were you, and indeed so was Mr. Morgan, and one or two others. The very last thing that the learned former Chief Justice said at the conclusion of the last hearing, sir, was, I want you to get the registrar of real property into court, because he didn't understand the letters which had gone backwards and forwards between our office and the registrar. And actually, if you're still there, sir, on that decision, can I ask you to just go back to page 163? Because we're talking there about the misdated letter, and I was just telling you orally, sir, I'm sorry, I'm tired, it's been a long couple of days, and I was talking about paragraph 18.4 and the misdated letter. Just looking at it, sir, it's 14.8 was the misdated letter, and 14.8.1, 0.2, 0.3, 0.4. Sorry, I just misstated. Apologies. But it was relied upon. Very unfortunate. Shouldn't have been done. And I'm saying that they should have stepped away from that. Now, the Chief Justice, sir, was saying, get the registrar of real property into court. And of course, sir, according to the roadmap that we developed yesterday, sir, we will. Okay, but before that can be done, sir, my learned friend has come up with a whole big treatise, sir, of how this whole thing works and how you can conclude that this thing was never registered, and if it was registered, it's not registered now, and so that doesn't matter. Okay. Now, we've gone through the law, but I'm just going to briefly take you to a few really important points, sir, which I think...
You can give me the reference and later on.
Okay, sir. Mr. Munib's approval, okay, was dated the 24th of the 5th, 2011, and the reference, sir, is at 2/20/387.
Bundle 2, tab 23?
Yeah, tab 2, bundle 2, tab 20, page 387. Okay. That's Munib approval. Okay. Now,
fine.
It's important, sir, that my learned friend he accepts, right, that that was an error. Okay. But he says, well, if the strata management, well, Mr. Munib said, seeing as you already signed the lease with this guy, you can continue. That's what he said, and he had authority to make that, okay? Because they're the owners and the managers, and they were organising the SMS, okay? So, and we looked at it yesterday, Sue, but my learned friend's skeleton, he says at 22, he talks about that, and then he says at 23, despite this, the SMS containing the prohibition on restaurant and bars was filed, okay? So, that's at paragraph 23 of his submission suit. So that is, and indeed, there's no other, you can't look at it any other way, can you? Okay. So that happened then. And then we had, indeed, the filing of the SMS, which my learned friend talks about in his submission there. And that happened, maybe, on the 1st of June 2011. If we take these dates that's his date, sir. And the bundle reference for that, sir, is the appeal bundle at 4/24 845. So next we have that filing of the SMS on the 1st of June. Next, sir, we have the building plans. Now, in my learned friend's submission, sir, when he was talking about our hopeless argument, right? If I can take you to my learned friend's skeleton at paragraph 24(1)A, he said, the units did not exist and would not exist until completion of the building and registration of the strata management. Would not exist until completion of the building and registration of the strata management and SMS. Real property is divided into lots by registration, by strata plan, strata title. Before registration of those plans, a unit of real property does not legally exist as legally distinct property. It's simply part of the existing lot. So that was his answer yesterday and in his submissions last week to why this thing couldn't be registered. Now, he seemed to duck that a little today, but the answer, sir, is this, and it does involve going to the appeal bundles, and that is at AB 4/14/71 and 4/15/73. Now, and can I just correct something I told you before, sir?
Yes.
The filing of the SMS, I said it was AB. Can you just cross out the AB because it's not? It's the trial bundle. Apologise for that. But if I can very briefly take you, sir, to those documents because it's important. And well, perhaps I don't need to, sir. I can just tell you, right? There, you will find, sir, disclosure which came.
Yeah, I saw that.
Right, exactly. And you would have seen the date on it, sir, because the date was the 16th of February 2012. So far from it being the case, as my learned friend would say, and not only that, sir, but it's stamped by the DIFC authority, okay? So it was...
My understanding, this is for whole building of correct?
No, actually, sir. This is for the plan for the actual unit, both units, 17A and 17B. So, and this, sir, is disclosure that the defendants put in, right, via Mr. Carnell's witness statement. Okay, so it's their disclosure. They got it from the Registrar of Real Property. Okay, and it proves that the Registrar of Real Property was in possession of a plan dated 16 February 2012, which is months before the registration. And there's really, really, really good reason for that, sir. Because if you took my learned friend's submission for what he says, right, that until there's drawings of everything, okay, you can't register a property, okay? And I'll go very briefly take you to what the law actually says. It says it's got to be sufficiently identified. But that plan, it's drawn by professional surveyors. It's very precise, so no question there. Okay, how did they register the sale of the units at the end of March? Right, there had to be plans available. Right, so they sold all these units. They all got registered. The titles didn't issue until the strata management plan was done and the strata management statements were done in 2014. Okay, but when it came to the registration of a unit and the registration of a strata management plan under the Strata Management Act are two different things. Different plan, first plan under the DIFC Law of Real Property, second plan under the Strata Management Act law, and so there are different plans done at different times for different purposes. So first of all, sale goes through based upon these plans, which the registrar had, goes through at the end of March. Then, sir, we get the strata management plan catching up with it, and in 2014, the strata management plans were developed, and then, sir, we saw yesterday that the titles get issued at the end of 2014. So there's just absolutely zero magic about that, sir. The next point is we have our registration of the... Oh, sorry, I'm moving on. My next point, sir, is that in this timeline, okay, so we had that of the 16th of February. The next point in this timeline, sir, is the 28th of May, and that is the registration of the lease registration form, okay? And we've seen that, but of course the references to the reference to that in our bundle, sir, is, I've got the appeal bundle reference, but I might as well give you our bundle reference to that, sir, and that is at 2/20/28 May 2012. Sorry.
Anyway, already I saw this.
Yeah, exactly. I'll just give you the reference. Yeah. Right. I'll move on to the next one. Well, we're getting that. The next one, sir, is the strata, the registration of the strata management statement, and that was done, sir, on the 2nd of July 2012. And that's a funny little email from, now that's the earliest date that I'm aware of, sir, and that's at AB 4/24/181, sir, page 181. Appeal bundle, bundle 4, tab 24 at 181. And that's an email from the registrar, sir, to Mr. Baldwin, and it says that was the date that the strata management statement was registered. And it also had a funny little addition to it, and said that something to the effect of the VEGIE bar filed a registration form, but our staff haven't dealt with it yet. Something like that. It's a funny little statement. But, which can't be right, because he'd stamped it. But anyway, moving on. So the page reference that I was about to give you then, sir, was, so it's 2/20/526. So that's for the lease registration. Okay. 28 May 2012 lease registration form 2/20/526. Strata management statement, that little email about it, sir, appeal bundle 4/24/181. So, what do we learn from that, sir? Okay. Well, number one, the lease was certainly capable of registration because if a plan stopped it, actually, problem solved, there was a plan. Okay. Our registration on the evidence came in before the strata management statement was registered. Okay. And it's not, as my learned friend said just a moment ago, that it's all dealt with about the order of filing. The order of filing is important, but not as important as he says. Sorry, sir, can I ask you just to go to the real property law? We'll have one last pop through it, if that's okay, sir.
Which article?
We'll start, sir, at 16. Now, this is important, sir, because everything that happens on the register must be recorded. Okay, if you put a lease on, it must be recorded. And if, like my learned friend says, it went on and then it came off, there has to be a record of it, and there's none. So no record of it coming off. Okay, so that can't be right. Next point, sir. 19. The registrar's duty to register instruments. So there was a positive duty on the registrar, sir, to register these instruments. If we go on, sir, to 21. Okay. Now this is the point made by my learned friend, because he says, the SMS was put in on the 1st of June 2011, okay? And so, in reliance on this, instruments that are in registrable form must be registered in the order in which they're lodged. So he says, well, if the SMS got lodged first, it should have gone ahead of the lease registration form, which came on the 28th of May. But you've got to read these things again, sir. And the point is this: instruments that are in registrable form. Okay. Now that SMS, right? It wasn't in registrable form then. Okay. And it wasn't registered until 2012. And in any event, sir, registrable form is a big question, because if Mr. Moonen had agreed that there was an exception to it, right, it wasn't in registrable form because it was incomplete and it was wrong in a material detail. So nobody quibbles with that, sir.
I do.
Well, nobody quibbles with the fact that there was a mistake in the making of it, that they'd given permission for our one to be an exception. And nobody can quibble that when they found out about it, they went, oh gosh, these people got an exception, we want one too. So there was an exception, and it was understood to be an exception. So it wasn't in registrable form. If we move on to the next matter, is 23, the priority of registration. So registered instruments have a priority according to when they were registered, not according to when they were executed. Okay? So, if the registrar stamped the lease registration form on the 28th of May, which he did, and signed it, okay, and it got entered into a spreadsheet which was kept at the time of the register, at the registry, and at the time they said that we keep the register on a spreadsheet, so it was put on a spreadsheet. So, if that was registration, sir, all of this SMS stuff, it doesn't matter, because it came later. It was too late. Okay, so we got the priority, and so and the next point, sir, we were just looking at before, is if we flick through to 33, and that is, sir, not just the contract point that my learned friend said that. So he accepts now that the lease can operate as a contract, and this allows the lease to operate as a contract, irrespective of registration. But it's the two, sir. The lodgement of an instrument in registrable form for registration has the same effect as the lodgement of a caveat protecting the interest claimed under that instrument. Okay, and it's a caveat against dealings, sir. Okay, that's what a caveat is. Caveat is Your Honour described it correctly yesterday, excuse me, sir, with the Dubai land as the reservation. Same thing. It's a shield around it. It doesn't create any rights of its own, but it's a shield. You can't register it with them. And the lease registration form, so that was a registrable form. We have the proof of it from the registrar's own stamp, and that is conclusive, sir. So, next, we have the 54 that must be registered, and then we have the 55, sir. 54 and 55. We'll go really quickly through that, sir. Requirements for a lease to be registered. Okay. And in order for it to be registered, I'm at 55, sir. A lease must include a description sufficient to identify each lot or part lot to be leased. Well, whilst the actual lease had a provision for it, it had a schedule for a plan, there wasn't a plan in it, but we do know that there was a plan in existence with the registry at that time, so it was broadly met, and indeed that's undoubtedly why it got stamped. So it's with respect to my learned friend, it's nothing to do with unit titles, all that stuff from the next year. It's absolutely to do with, have you got a lease, have you got a plan, have you paid your fee, am I satisfied that there's two parties to it, and the registrar was satisfied because he stamped it. But not only that, we've seen that late evidence at tab 27B, sir, the late witness statement came through that she actually sent through some documents to the VEGIE bar for them to give to the registrar to establish that. So we've got the evidence at 27B. Okay, so that really, sir, there's just a couple more points, 59 to 61, okay? If a lease is going to fall off the register or be removed from it, like my learned friend would say, there's only three ways for that to happen. Under 59, under 60, and under 61. Okay? It either expires, it's terminated following their default, or it's surrendered. There's no other choices. They don't evaporate. There's no evaporation. Okay? Expire, terminate, surrender. None of those happen. If any of them did happen, they would have been recorded under Article 16, sir. And then we're through to 149, sir. The registrar, and this comes back, if I might, sir, to your Excellency's excellent suggestion yesterday about the Zane thing. I've had a bit more of a think about it, and you're right, sir. I'm happy if the court is willing to give us the declaration that there was a contract. I'm happy not to proceed against Zane, because your Honour's analysis of this was correct. That it then actually goes back to the registrar, and it's the registrar's job in the first instance to resolve issues with Zane. So if you provide the declaration, yes, they have a lease. That then goes back to the registrar. We haven't asked you to order the registration of it, so we're going to ask the registrar, his job to consider it, and he can consider it. And one of the things he must consider is, well, what's the impact of this on Zane, right? Now, and Zane might say, we're fine with it. They might say, actually, we've got a problem with it, but the issue is, okay, that if they won't prejudice their rights, and then we look down at paragraph 3 in 1593 still, for the purposes of paragraph 1b, the rights of a registered owner are not prejudiced if the registered owner acquired or has dealt with a registered interest with actual constructive knowledge that the register was incorrect. So you see, sir, here we've got the situation whereby somebody bought it, right? So when Emirates MBD bought it, right, they needed more than mere knowledge, okay? But if we actually had a lease against the Emirates MBD under contract, or because it was registered, or under equity, right, we're then entitled to get it registered. And then under Article 1492, that means it's as if it always was registered, okay? And then if it turns out that Zane knew that of the interest of us, it doesn't have to mean that they intended to cheat us or anything like that. In this situation, notice is enough. And so, all I'm saying to you is, number one, we would like the declaration. And number two, Your Excellency is quite right. I have got out of the gates too fast with Zane. If we've got that, the proper thing to do is actually at that stage put it back with the responsible officer, and that will be fine. So I think, to be honest, my thinking was, well, I don't want to have too many hearings, and so let's get Zane in now. That's really what was. I want to get this case over before I die, so to say. Some things you can't hurry. Right. Okay. And one thing I can hurry is the rest of my submissions, and I'm going to go really fast.
So still more you have to go?
Well, yeah.
Almost
If I
exceed
can-
1 hour.
I really want to finish fast too, but there's a few things I've really got to
But
say.
you have to realize I'm fasting and I have a limit power to continue with you.
You want me to stop now, Sue?
No, but we have to finish it today.
I'm going. Right.
Just take me to the most important points.
Yeah. The next one.
And don't repeat what I heard yesterday.
Brilliant, Sue.
Just reply
Excellent.
to Mr. Tom.
Right, I'm totally with you here, Sue. Illegality, right? This is indeed a recent invention, and I did put my learned friend disappointed on it. Okay, he didn't plead illegality, right? They pleaded that it was, sorry, can you take me to the draft pleading, paragraph 27, wasn't it, my learned friend? Anyway, what they pleaded, sir, was that it was unlawful. Now that's different from illegality. And the case, I don't think my friend was brave enough to take you to his authority, right? Because what illegality is about is something that's illegal, okay? And what he's saying here is, it's in breach of the SMS, of the Strata Management Statement. Well, that's not illegality, sir. It's arguably unlawful, okay? But it's not even unlawful, right, if it's an obvious mistake, right, and can be fixed, okay? So the illegality cases, and the ones that he was referring to are wars, okay? So, there's a good one at the moment, sir. In this country, it's prohibited to deal with Qatar, right? That's an example of illegality, sir. It wouldn't be, I'm not going to go into geopolitics, sir, but that's what illegality is about. It's about sanctions, it's about money laundering, and it's about other serious criminal activity, right? It's not about a mistake in the putting together of an SMS. And the case that he relies upon, sir, is, it's an insider trading case, okay? And so the whole nonsense about illegality, my learned friend dreamed this up last week. It wasn't in their pleadings. They pleaded that it was unlawful. They pleaded what it actually said, right? He's realised that's not going to be enough. Because why it's not going to be enough is because this court can cure it. And we've said that what we need is the declaration. Okay? We take that to the registrar. If we went now to the higher body court and we've been said, we haven't even started the pleadings on that, the proceedings on that. If we went there now, what would they say? You haven't got a lease. Why are you coming to us? We can't decide whether you've got a lease. Okay? We've actually already asked the registrar, and he's already told us, you don't have a lease. So that's why we're here, Sue, because you are the one who can help us. You're the one who could look at the evidence, who could decide the point, whether or not we have a lease, whether it's in a contract or an equity, or it's registered. We don't mind. We'll take them all. And declare that we did. And then, everything else, I'm quite confident, Sue, that if a robust decision comes forward from this court saying, yep, there was a lease, I think everyone, in fact, will fall into line and the whole thing could really go away, and all we'll be talking about with the bank is how many zeros should be on the cheque, which would be a very easy conversation to have. Otherwise, sir, there might be another proceeding, but we're not scared of it. But it's not a matter of next one. And the difference between illegality and unlawful, sir, is that unlawful can be cured, and as it turns out, the very body that can cure the illegality that my learned friend has invented is this one. It's this court that has the jurisdiction to decide the point. So this court can fix it straight away. Next one. And so there was that talk about splitting the case into 2 parts, but I think I've explained that very well. I hope I've explained it very well. Why we want to split in 2 parts. We have to come here now to get what we're asking for. And we've tried to cut through as fast as we can on that. Now, contract, sir, we've agreed that it's 33.1. My learned friend made an extraordinary submission about the money. I spent a long time yesterday dealing with the issue of the money. He spent no time at all dealing with it in reply or in his submissions. Right? When they accepted 45,000, sir, I'm not going to take you to the evidence. There's so much of it. They did it because they wanted it, and the reason why they wanted it is because they were the landlord and they were splitting it. It's so clear. My learned friend hasn't tried to question it, but he just extraordinarily said today that was an accounting. Well, yes, it was, and it was an accounting of the rent. He didn't say an accounting of what, but it was an accounting of the rent. It's just so obvious. The relevance of Zane. Well, actually, we do seek the document production regarding Zane, and you'll see from what we just saw about Article 149.3, sir, why it's a good idea. If they knew about us, and we say they did, but if there's any further evidence that they knew about us, well, they're going to be, the registration is going to flow through to them. Okay. Now, my learned friend's question has queried our words related to. So I've drafted the order related to this, related to that. Well, the simple things. If you make a declaration, we have a lease, and we can sort out any wrinkles in the draft order between us. But he says what matters here is relevant to. Well, I say related to is actually related to the word relevant. They're cousins if they're not brothers, those two words. They're certainly from the same family. Definitely from the same tribe, sir. So, we're dancing on the head of the pin with that stuff. Now, the last point, sir, and it's certainty. And in our authority, sir, I put the case that really matters. Now, the 2 cases which my learned friend referred you to, he talked about the one with Mr. Mike Ash, what's his name? Ashley. He's the guy from Sports Direct, very colourful character. And he did own Newcastle United. He sold it last week to, indeed, one of the sheikhs from, not Sheikh Mansour, but another sheikh from Abu Dhabi, bought it maybe yesterday, sir. So, what happened here in that case? It's Ashley v. Blue. Okay. Mr. Ashley and Mr. Blue and some other execs from the thing. They were in the pub in Oxford Street. They were drinking like fish, and they were talking about how much money Mr. Blue was getting paid for doing his job. And during this conversation, Mr. Ashley said, "Well, I don't care if the share price reaches £8. I don't care if I pay you 15 million." Right? And everyone, this is in the judgment, everyone laughed. That's very funny. Okay, sure enough, about 8-9 months later, the share price doubled from £4 to £8. So Mr. Blue shoots around and says, "Well, I want my 15 million. right? And then extraordinarily, right, he sued for it and got laughed out of court. What Lord Justice Leggett said is that this case does nothing more than demonstrate the human capacity for wishful thinking. That's his very last words. It's a good read, that case, sir. Brilliant writer, Justice Leggett, sir. Lord Justice Leggett as he is now. But that case, sir, it's notorious because it's a joke. All it does is illustrate a principle that stuff that's discussed in the pub doesn't mean very much. Now, this case is, and the other case, sir, about everything south of Cambridgeshire, that's an employment case, and that was one of the grounds that it was decided upon. But it was a restraint of trade. So a person is leaving employer A and going to employer B, and employer A is saying, you can't go near any of our sites and anything south of Cambridgeshire, and that was considered to be too uncertain to enforce. The case that actually, the real case on the subject, sir, I'm surprisingly effective to mention it because it is hugely important, and that is Forte, sir. Open work, and it's a noun bundle, sir, open work v. Forte, okay? And it is hugely relevant to this case, sir, because it's under bundle 7.
Authority bundle?
Our authority bundle, sir, tab 7.
Yes.
Now, if you'll recall, sir, tab 6, my apologies.
Sorry to intervene. I mean, I will need a chance to respond to some of this. My own friend had the other idea.
No, he doesn't deserve it, sir, because the cases, as he said himself, they're mirror images of each other. So he's had it.
My own friend's relying on authorities that he hasn't written about in his skeleton argument, and he reserved his submissions on this yesterday until he heard what I have to say. So I haven't actually seen his submissions on these issues at all. I hope to have a chance to reply. I'll be very short, but I'm worried that we're running out of time.
I did actually reply in my submissions, sir, and I did actually see that.
Can you make your point first?
Yeah, let's go to this point right here, sir. Go to page 110 if your Excellency would. 110 at the bottom right-hand side. And then mark paragraph 21, okay? And then the Lordships consider in modern times, the courts find it readier to find an obligation which can be enforced, even though apparent certainty may be lacking as regards some terms of such as price, provided that some means standard by which that term can be fixed can be found. Now, the next point, sir, top of paragraph 25, the court should strive to give some meaning to contractual clauses agreed by the parties, if it is at all possible to do so. So, and this, I think my own friend was critical of something I'd said in my submission, sir, that the court should strive to do everything that it possibly can to make things work. Well, no, actually, sir, that is the law, and that is what should be done. Okay, at least be placed on hold. So the final point. Now, the next point, sir, if we take the actual, if you remember, sir, the wording of the 15th of March 2012 letter, the put on hold letter, okay, what it said is this: lease commencement date and rent commencement date to be adjusted and revised, okay? Now, this case of Forte, it quotes another very, very important case called Hillis and Co. versus Arcos. It's just back on the next page. Earlier.
Which paragraph is this?
The reference to Hillis and Arcos is at 22, right? But I'm at 25, where it starts quoting Hillis and Arcos at the length, very lengthy, from the bottom of 25, sir, right down to later he added this, and then it finishes off above Scammell there, sir. Now look, if we come up to the bottom of the big paragraph and go up. Can you see the line where it says, thus in contracts for future performance? So I'm about 1/3 of the way down page 111, sir, of the bundle.
Yes, yes, sir.
Yeah. Thus in contract for future performance over a period, the parties might either be neither able to agree nor desire to specify many matters of detail, but leave them to be adjusted in the working out of the contract. Now that is exactly, sir, the word that these people used in the 15 March 2012 letter. Lease commencement date and rent commencement date to be adjusted and revised towards a new date. And far from this being a contract by very drunk people in a pub, right? This was a contract which had been going on for some time, and so that's what they're sort of talking about here. So, and my new friend, he gave the example this morning. He said, "Oh, okay, I want somebody to come and work in my business. I want my friend to come and work in my business. I say to my friend, well, I want you to come, but now's not the right time. We'll get back to us later." Okay. Now that's an agreement. That's an agreement to agree, and we all know that that's actually not enforceable. Okay. And so he's saying that I've said to you, you come and work in my business, come back and we'll discuss it. We'll definitely agree on that later. But later we don't agree. Okay. Well, he's saying that that's the same as this. It's not the same as this, right? This situation is what's discussed here. The contracts, when the parties that have been involved for over a period of time, okay, not only is it a long-running contract, right, but it's one that's already started, right? It's 3 months in, so he's been paying rent for 3 months, and then we're putting it on hold. So it's so far from the pubs that it's not funny. And all my learned friend can really point to is the pub case, and it's just not in the same ballpark. Right. Moving on, sir. And this is actually where I got the inspiration for the line that my learned friend really criticised, and that's the top of page 112. The object of the court is to do justice between the parties, and the court will do its best if satisfied that there was an ascertainable and determinate intention to contract, to give effect to that intention, looking at the substance and not the mere form. And this is exactly the problem with my learned friend's analysis of this. He's gone into it and he's gone, oh, well, we might never be able to agree on that. And the agreement, I'm quite satisfied, sir, is what is written in that letter. Okay? The 60% was Miss Fernandes' understanding of it, right? And it's important to say that she understood that there was an obligation, and that was her interpretation of the obligation. We'd accept that.
Where does she say that it was an obligation?
Well, she says, yes, boss, this is the one where we get 60%, where it's on hold until 60% leased. Okay? So, yes, she did. Of course she understood there was an obligation, right? She understood that her understanding of it, or what she said then about her understanding, this is another reason why we should cross-examine her, sort this out. But she understood that it was on hold pending an event. Okay? Over on the other side, you've got Mr. Al-Khalili. And we saw yesterday, again and again and again, he's on the phone, on the email every couple of days, getting angrier and angrier and angrier. And he's saying that the time for completion of this was no later than November 2012. By that stage, he was like, I've waited long enough, I'm ready to go, this is costing me. And he was very angry and upset. And you'll remember, sir, in his 10th witness statement, I won't take you here, but he actually, this was from some of the late discovery that apparently doesn't matter, but this was what Mr. Muhammad Qadi, who was the senior guy for UP, and he said he was writing to Naki on the 11th of March, 3 days before this agreement, and he's saying, as per the attached memo sent to you by Annalyn, UP is no longer the owners. and as the ownership has been transferred, therefore you and I need to contact the person in charge, Ms. Melanie Fernandez, to discuss any related topics. We acknowledge that you are not the cause of the delay. Okay, so this is why it's been put on, and I'm sorry, sir, the reference is at Bundle 4, tab 27B.
I have it in losers. Mr. Benagi witness statement.
Yeah, his very last witness statement.
I have it in losers.
Yeah, and it copies in the email from Mr. Cardi. And Mr. Cardi is saying, we acknowledge that you were not the cause of the delay. Okay, so is it in favour of Mr. Naki? Well, yes, sir, it is. And so it was a condition that he could waive. Absolutely. And anyway, in terms of the decision we've been just looking at Forte, it doesn't matter who was to waive it and who was taking advantage of it, because the court just comes in this situation and says, I'm solving it. I'm solving it. I'm declaring he had a lease, and it should have been an action long ago. And we can sort out the cost of that later. Now, just next page, sir, page 113. All of the next page is really brilliant stuff. 114, and I think I wrote a bit tight myself at that stage, sir, but that certainly 113, 114, and certainly paragraph 30 at the top of page 114. First, the parties plainly intended the words to have some effect. Okay, so that what my learned friend is saying, what he said this morning to you is, well, this had no effect. You can't dream of what the effect was. That we're going to extend it until we're going to adjust and revised. And he says, well, you know, it's a two-stage test. There's first set of complications, second set of complications.
Still, you have more to address?
Not on that, sir. And we're also happy to write to the registry. We think, well, the key question that the registry should be answering is what happened, just that last bit that we were looking at, sir, regarding the Excel spreadsheet sent to the registry which had 2 rows removed. Okay, so the registry said, please send me your list of leased units so I can compare them with my list of leased units. Now, we'd like to know what were your list of leased units at the time, right? And what did
at this point, can you both of you agree on one draft?
Yeah, I'm sure we can.
We can try.
Yeah, my learned friends.
Anyway,
it might be quicker if you're on the sides.
I'm going to send.
Yeah, after the hearing, not necessarily today.
Absolutely. And maybe we'll send you two alternatives. That's probably.
Maybe you settle before handing down judgment.
Well, we're here to do business, sir.
I'm too optimistic.
Okay. We've already sorted out the restoration of the company, sir, and thank you very much for indulging us. Sorry if I irritated you, sir. It's been a tough case, but thank you very much for your attention.
You put all applications in one hearing, this is unusual.
Yeah, exactly.
Yes, Mr. Tom?
Your Honour, I'm just going to be I'm going to be as quick as I can. I wouldn't imagine I'll take more than 15 minutes of your time, but who knows? We'll see where we get to. Can I start with the uncertainty point? My learned friend just showed you...
The last case?
Yes, the open work case. Do you have that open still? Tab 6, if we put that one away. And my learned friend took you to an extract of a case which is included at paragraph 25 on page 110.
Yes.
And just so this, making good my point that I made earlier about this question about why a court's reluctance to find the contracts are uncertain. And it's because they want to give effect to the contractual intentions of the parties. So what the judge, what's said by Lord Wright, and it's recited at the bottom, you were showing some of this, but I think it's important you see the whole of it. So he says, it's clear that the parties both intended to make a contract and thought that they had done so. Businessmen often record the most important agreements in crude and summary fashion, and so on and so forth. It is accordingly the duty of the court to construe such documents fairly and broadly, without being too astute or subtle in finding defects, but on the contrary, the court should seek to apply the old maxim of English law, and so on. Words are understood such that the subject matter may be more effective than wasted. That maxim, however, does not mean that the court is to make a contract for the parties, right? So you can't rewrite the contract or go outside the words they have used, except insofar as there are appropriate implications of law, as, for instance, the implication of what is just and reasonable to be ascertained by the court as a matter of machinery, where the contractual intention is clear. And so so there's 2 points there. You can't rewrite the contract here. At some point, the words just have to give way. And the second point is the whole policy of construction is to try to give effect to the intention of the parties. And that, in fact, you were taken to paragraph 30, was the fundamental part of the reasoning in this case, because the Lord Justice said, applying the approach set out in the authorities to which I have referred, one can draw certain conclusions. First, the parties plainly intended the words of the provision to have some effect. Now, my learned friend told you that I said, oh, my case is that these words have no effect. That's not my case. I've never said that. What I have said, I thought I'd made this clear enough, is that the agreement that was entered into in March 2012 on both parties' case has legal effect. It puts the lease on hold. That's the legal effect, and the parties intended it to have that effect. The next question is, can the court ascertain from that agreement something which triggers the commencement of the lease? My learned friend conceded in his submissions an agreement to agree is not an agreement, it has no contractual force. So so in effect, and it's an indefinite, it's putting the lease on hold indefinitely. So it gives effect, that construction gives effect to the contractual intention of the parties, it gives it legal effect. It doesn't fall foul of the problems normally associated with arguments on uncertainty. Now the effect of that, so I can enter into an agreement with Your Honour just simply to cancel a contract. That agreement has legal effect. The result is that we don't have a legal relationship between us anymore. Do you see the distinction?
No.
If we go into the...
You agreed to put it on hold forever, is what you're saying.
Your Honour,
Can't you?
okay. So, that's the case that I'm making out. It doesn't fall foul of these problems normally associated with questions of uncertainty, but in any event, even if it did, you can't rewrite the contract. That's the short point. Unlawfulness. My learned friend made a distinction between unlawfulness and illegality. It's pure invention. So, this is the first time I've heard this point raised ever, frankly. But my authorities, let's not go to it, but Chitty, I took you to paragraph 23.022. I didn't take you to 23.022. That deals, by way of an example, with a question of a compulsory purchase order. It's not a question of some sort of criminal statute saying, the court can't enforce a statute for crimes. It doesn't have to go that far. The point in that case was simply a compulsory purchase order. The cases in this court, in which the court has wrestled with the question, not in reported judgments, but there is one question in the case was whether a contract could be enforced where it was alleged that one party didn't have the necessary operating licence. So it's not, absolutely not the position that there has to be some criminal charge that could be punishable in the criminal courts as a result of proceeding with a particular contract. The question is, the policy considerations that this court will not enforce a contract which is prohibited, the activity of which is prohibited by the laws of the jurisdiction. That's just a fundamental public policy position. And it is by the provisions of the strata title law, not by the strata title management statement, but by the strata title law itself. I'm going backwards through my learned friend's submissions because the ones at the beginning were of less significance, and if I run out of time, then it won't matter quite so much. My learned friend took you to Article 21 of the Real Property Law. That is the provision which says that instruments are registered in the order in which they're submitted. My own friend's position now is that the strata management statement wasn't in registrable form. That, with respect, is a pretty difficult argument, given that it was in fact and has been registered. It's an extraordinary argument. It's just pure assertion. It makes no sense. And the reason he says it is simply because it's inconsistent with what he says are his client's rights. It can't affect the registration argument, because his case at that stage is that the interest is created by registration. So you can't have the interest until it's registered. So you can't say, well, all right, the SMS can't be registered because I have the interest, because the interest doesn't arise until registration. So at the time of registration of the SMS, it's the first one in time that's registered, it therefore becomes that's submitted, and it's therefore the first one in time that's registered. But even on his argument under Article 21 of the Real Property Law, if it was simply about the sequencing, the SMS comes first. Your Honour was pointed to the provisions in the Court of Appeal decision, Sir Jeremy Cook's observations about the things, he said this at paragraph 16 about the things that needed to be investigated. He talked about registration, was there registration, was there provisional registration, if so, what's the impact, how does registration affect the position afterwards, and particularly the registration of the SMS, and the stop. These are all the issues that we've been resolving today. So before the Court of Appeal, my client wasn't making this application, and we've moved on. So these are the issues which I say you can, on the material that you have, take confident and firm decisions today to cut this case, to bring this case to an end. My learned friend persists, it seems, with this application against Ms. Fernandez. I don't say Ms. Fernandez is too ill to come to court. I don't say she's unavailable. I don't know what her availability is. She's been told about it by my clients. The illness was raised largely, well, it's a matter, it would be potentially something which could affect your discretion, but it's also something which has impaired her involvement in these proceedings. It also was advanced in part, and particularly her employment status, simply to show that she's not in charge of this disclosure exercise. The reasons for bringing her here, it is said, are firstly the disclosure problems. To give some explanation of those, she wouldn't be the right person to do that in any event, and as I've explained, further disclosure isn't going to assist this court on this application. Now my learned friend says, well, actually, she should come here, we should get her here to decide, to tell us all about the master sales agreement. Well, then why wasn't that application made well in advance? The only thing that's changed is what my client has found out about his disclosure exercise. But to say that then justifies some sort of order to get Ms. Fernandez into court to deal with the MSA is just, it doesn't flow from the consequences of what happens. But in any event, this is an immediate judgment application. So my position is you can decide on the basis of what is likely to be available at trial that there was no master sales agreement. If I'm wrong about that, then we'll have a trial about it. That's the point. My own friend said, effectively saying, let's have a trial on that little discrete factual point. I say we don't need to, but if I'm wrong about that, then we'll have a trial about it later on down the line. There's no reason to drag Melanie Fernandez into court to deal with that discrete issue on an interlocutory application. But just dealing then with this question, I have various, as you've heard, various reasons why I say that on the material you have today, you can confidently find that there is no MSA. And certainly that there is no MSA, master sales agreement, which is in conflict with the terms of the sale and purchase agreements. And my learned friend says, well, who says there's a conflict? And actually he says, my submissions, for them to work, there has to be a conflict. We'll just step back from that for a minute. The implication on that is my learned friend says there is no conflict between the master sales agreements and the sale and purchase agreements, but I took you through the terms of the sale and purchase agreements. And we can see from those, not only is there no mention of the lease, but it expressly excludes the prospect of a lease being transferred. So unless there is a conflict between the SPAs and the MSAs, my own friend's case doesn't get off the ground, even if there is an MSA. even if there is a master sale agreement. As I pointed out, I made my other solutions about if it's in the terms of the draft, then it's always all subject to the terms of the SPA in the first place. The final three very short points I want to make deal with these complaints about disclosure. Firstly, we get this, well actually there are a couple of others. This misstated letter was a question about whether it was somehow wrongfully deployed by my client in front of the Court of Appeal. It has absolutely no relevance whatsoever to this application, but the allegation has been made. The email, and my learned friend can check it, that was sent from my instructing solicitors to him is dated 23rd of May 2016. In that email, my instructing solicitor said that it appears to be the wrong date, and it appears to be 2013 or 2012. That's May 2016. As I understand it, it's 8 months, 9 months before the Court of Appeal hearing. This is all within the knowledge of the claimant at that hearing.
Just on that, sir, his complaint earlier was that we had put it mistakenly into the chronology. And yeah, I knew that there was a suggestion that it was a mistake. And we had an argument about going to the chronology, what date it should be. They insisted that it be the wrong date.
Well, that's again a new complaint. It's got absolutely
It's your
nothing.
complaint.
It's a new complaint just made just now.
No, you haven't been listening.
Continue.
It has
Mr. Sir.
nothing to do with any of the issues in these proceedings. It's effectively a complaint of professional misconduct made against my instructing solicitors about a hearing that happened in January 2017. If my learned friend wants to advance that complaint, we will meet the complaint in detail. If he wants to make a complaint to the relevant authorities, he can do so. What I don't want to happen is for Your Honour to sit here and think that it is in any way accepted that my instructing solicitors misbehaved at that hearing. It's completely untrue.
I think this is a different route, which is code of conduct.
Yeah, quite. If my learned friend wants to make a complaint, but I respond to it simply because it's made and it's repeated. My learned friend suggested that in relation to disclosure, well, what he said, firstly I accept. He said what we are required to disclose is everything relevant within our power and control. Firstly, that's qualified by the fact we have to make a reasonable search. So that is what we will do. Complaints that have been made about the way in which the disclosure has gone forward are not accepted, save to this extent that the source material for the searches was something that was excluded at the IT stage. And we will research that. We'll come back to that in a second. But what my learned friend does is he says in relation to the Afridian angel position, he says, documents in Afridian angel's possession, he says, are within my client's power and control. It's just pure fantasy. There is plenty of authority about when documents are in your power and control. And there are lots of authorities which deal with this question where you have a group structure, whether or not documents that are held by another company in a group are within the power and control of another company in the group. So there's enormous amount. Nobody has ever suggested that documents held by somebody else's solicitors are in the power and control of a party. It's just invention. It's extraordinary.
If you know there's a copy, you should get it.
As to disclosure, very shortly, my learned friend complains about there having been multiple attempts at disclosure. The problem has arisen, as I've said, we were searching the same database of documents, and that will be corrected if it needs to be going forward. It's not correct that the documents were provided after the first disclosure exercise in some sort of dishevelled job lot state. They were scheduled. There was a schedule of documents provided. I don't want to labour the point about the appendix to the email, attachment to the email of the 9th of December 2012 suggested that, in fact, it was me, I told my client to send that email to the claimant's solicitor simply to shut down this point. I would have thought that would be the end of it. Apparently not. And then just very finally, well, two very short points. Firstly, my own friend described the test on immediate judgment as that I have to show that his case was impossible even with amendment. It's not a test. Real prospects of success, and we've been over what that actually means. My point on the pleadings is this. My learned friend has set out what should be his final word on what his case is in his draft document. It's about giving proper notice of your case. He says he's pleaded the facts on which he relies. There's no allegation of a representation, there's no allegation of reliance, there's no allegation of detriment, for example. All of the points I made about the pleadings are not unfair, cheap, short points on pleadings. And then I've gone on to deal with how the case has been put on, particularly in relation to estoppel, which hasn't been dealt with at all. So there's no pleading case on this aspect, and it's not sufficient just to say, oh, well, there was a transfer on about the 11th of January. Unless you have any further questions, I'm very grateful for hearing me for that extra 15 minutes. I do appreciate it. And I do apologise for some of the interjections that we're making during the course of the day. It is a difficult balance from an advocate's point of view.
I don't mind to stay, but at least we reach to a conclusion of this battle, I can say.
I'm grateful. Thank you very much.
So I'm going to reserve the case for judgment. This is a point one. Point two, if the parties agree on a draft letter to send to the registrar of real property, I'm glad to receive it by after the Eid holiday. So let's say 8th of 9 June. Yeah.
So we should do 8th of June.
8th of June or 9th of June, it doesn't matter. During that week, I'm flexible. I make it flexible.
We shall do that. And if we can't agree, then it's my own friend.
So I will take both recommendation and I will draft something. Yeah.
Is your Honour contemplating that once a response comes in from the registrar or property?
Yeah. When I receive a reply, I share it to the both parties. And if you wish to further submission, written further submission, I'm happy to receive, and I will put a deadline for exchange further submission in regard the real property registrar reply.
Thank you, Your Honour. Can I suggest that Your Honour also place a word count or a page count on that, and also confine it quite strictly, because what I don't want to happen is we have a large post-hearing submission come in from either party. Frankly, I don't think there's anyone who's interested to have a long and lengthy submission that ranges around the issues. It needs to be focused on very, very discreetly on the impact of the response from the real property registrar.
Okay. Okay. That's it. In regard to the cost, after handing down my judgment, I'm going to deal with the cost as in general rules. I will give parties opportunity to file a submission in regard to cost.
Right.
Yes.
Just one further matter, sir. Largely because of all of this late discovery,
Yes.
I didn't get my statement of costs done. Can I put that in the next week or so?
So I'm not going to decide on the cost. So I'll give you opportunity when the time comes.
Okay, thank you.
Thank you.